Good morning. We're going to get started with the executive committee meeting. Welcome to everybody. To start the meeting, I'm going to ask Terry to please take the roll call of the board executive committee.
Fox, Flanagan, Krinsky, LeBron, Myers, Moore, Parker, Vera, Pasternak.
Here. I just realized that, as everybody knows, we're operating under Bagley-Keene, and this is the meeting of the executive committee, so the non-members of the executive committee unfortunately need to move to the audience.
Skip my name. That's right.
Today, we are starting a new era at the State Bar. We are webcasting our meetings this week, and I want to make a brief announcement about that before we get started. In addition to watching what you do sitting at this table, you also need to do certain things when we're speaking so that the audience out there who's not present in this room will know who we are and be able to hear us. First, you need to be certain to turn on your mic and be sure to speak into the mic. Second, and this is new, and to the extent I remember, I'll remind people today, before speaking, please identify yourself by stating your name, and make sure when you're not speaking that you turn off your mic. And I'm now going to request that the committee chairs also please restate any questions before answers are provided. If you follow all those guidelines, I'm told that people at home or in their offices should be able to follow everything that we're doing. So, as always, I'd like to ask if there's any public comment on any items on the executive committee agenda. Okay, I don't see anybody moving forward. I do not have an oral report as executive committee chair, and we don't have any consent items. We have some items being referred to other committees. Do I have a motion to refer those to other committees? Okay, I have it. Terry seconded. I'm sorry, who made the motion? Okay, Miriam Krinsky made the motion. Terry Flanagan seconded it. Any discussion? Any objection to substituting the roll call? Okay, roll call is substituted. Next item on the agenda is a status report from the Nominations and Appointments Committee. One more. And please turn on your mic if you would. There we go.
We move to the next agenda item and
Okay. We'll come back to you then. Status report from the Audit Committee. Danette Myers.
Good morning. Thank you, David. Danette Myers, Chair of the Audit Committee. The Audit Committee had a meeting yesterday, actually, and I want to thank all the members of the Audit Committee for attending that 8 o'clock in the morning meeting where we discussed two issues. One with the expense reports, executive staff expense reports, and everything seemed to be okay. And the second was a motion which I believe will be later presented to the board. I'm not quite sure when. Perhaps Elizabeth or Francisco can assist me in telling me when that resolution will be presented to the board regarding the issue of a CFO. The audit, financial audit that was prepared by Moss Adams was concluded. I believe it was a very good audit, and I signed the certification on April the 30th, and I believe it was presented to the legislature as well as the Supreme Court. So with that, I think that's all I have for the audit committee. I should indicate that the Keller audit will be completed according to Christine Wong sometime in June or July, which is an audit that does not need a timeline, and it'll just be presented to the audit committee and then to the board. So with that, I will conclude my comments, unless, Elizabeth, I've forgotten anything, because I see you with that look on your face. I'm not sure if that's an early morning look or, but good morning to you as well. And so that concludes my comments with respect to the audit committee. Thank you, David.
Thank you, Danette. Anybody have any questions? Okay. Gwen, are you ready to proceed with the nominations and appointments committee report? Are you still having technical difficulties, Gwen?
Yes.
Okay, we'll come back to you. Let's move on then to item D, which is the board policy manual phase 1 cleanup, and Dina Goldman.
Good morning, everyone. This item is presented to you and tomorrow to the board for cleanup of the board book and reorganization of the board book. So last year, the board adopted a new organizational structure for the board book. It had 24 different tabs. It's been consolidated into 5 substantive sections with subgroupings. So this item just presents the existing content of the board book, reorganized and moved into the new organizational structure, along with technical edits and corrections to citations. The concept is that we're going to do this, and then in phase 2, we're going to move forward with any substantive amendments to the board policy that the board wants to make or that staff recommends. And there are some footnotes in this presentation that suggest some of the substantive edits that will be coming up this year.
Vanessa, is there something you would like to add?
I may not have heard Tina, but we also have a final section 5 on the technical changes that will come next in July before we start the substantive phase.
Yes, that's right.
Good. Miriam Krinsky?
So I guess if you say our name, we don't need to say it again.
I'm trying to avoid that.
Yes, thank you, David. So I appreciate the good work that's been done on this. I know it's been a massive project, and I know that Joanna Mendoza and David, you as well, put a lot of work into this project also. So there were I have one question, and then I know that as part of future phases, the issue that I had asked about at the last board meeting about, giving another look at some of the provisions that relate to the purview reporting, et cetera, of the executive director versus general counsel versus the board versus our chief trial counsel. I think that's going to be a very important area. I know that it's not the intent at this phase to be trying to look at that, but I know that Vanessa and OGC are going to be looking at that, and I think that's going to be very important for us to give some attention to how the manual defines those areas. The one question I had was I saw in attachment D there's a newly proposed social media policy on pages 3 through 7, and I was just trying to get some sense, is this sort of are we being asked now to prove that? It looked like a lot of really interesting work again, but it wasn't clear to me in terms of that new part on those pages what the thinking was.
Miriam, that is an existing policy that's in the form of what we call an administrative advisory that was adopted and is on the books to be followed, but it was not adopted by the board. So we thought that if we were going to put it into the board book, it should be adopted by the board. But the suggestion is not that you approve it substantively right now. It's just to preview it for you.
Okay, so I think that's the question. That the board hasn't yet acted on that, And the fact that it's being moved and put in here, I saw the footnote that says request board adoption. So would our action today by approving this in phase one be adopting this, or are we just, maybe the footnote can make a little clearer that this has not been approved by the board, that it's simply being placed here as a placeholder and that it will come to the board? I just don't want somebody to look at the manual with this language in it and assume that we've adopted these provisions. Again, I think there's a lot of good stuff in this, but I'm not sure if we were being asked to approve it, that I wouldn't have some questions on some parts of it. So
I think that I would suggest, I noticed that yesterday when I was reviewing these materials, I would suggest leaving the header and the footnote and removing the content for now.
okay.
And then we can reinsert the content when we come back.
Okay, I would feel a lot more comfortable with that because, it's 4 pages of content that I would want to have us do a deeper dive on. Makes me a little bit uncomfortable. So that sounds like a good solution.
Okay. Any other questions or comments? Do we have a motion to move the item with the change that was just mentioned?
I'll also move with the removal of that.
Okay, so Miriam Krinsky makes the motion. Do we have a second? Seconded by Jim Fox. Any further discussion? Any objection to substituting the roll call? Okay, very good. Passes unanimously. Then we'll come back to the status report from the Nominations and Appointments Committee. Chair Gwen Moore.
We met on April the 19th and considered and made recommendations on 6 matters that will come before you when we go into closed session. We have 3 matters on closed consent. 6011 California Rural and Legal Assistance Board of Directors Annual Appointment of Members. 6012 the Legal Aid Society of Orange County Board of Directors Annual Appointment of Members. 6013 Standing, Special, and Section Executive Committees for 2016 through 2017, their annual appointments of officers and members. And then we have 3 matters for action. The American Bar Association, the House of Delegates Annual Appointment of Members, Judicial Council Annual Appointment of Members, and the Committee on Mandatory Fee Arbitration, their annual appointment of officers and members. Come before you tomorrow.
Thank you. Any questions? I don't see any. That concludes the open session of the Executive Committee meeting, and we have nothing in closed session, so the Executive Committee is adjourned. Thank you. And stakeholders and access to justice, Joanna, I imagine you're chairing that today. Wherever you would like.
I was asked to make a brief announcement about the webcasting to remind everybody that because we're webcasting, you're going to speak to make sure you turn your mic on and to speak carefully into the mic because we're doing closed captioning today and you need to speak clearly and then to turn your mic off when you're done speaking. And to make sure you identify yourself by stating your name into your mic. And then committee chairs, please restate any questions before answers are provided. Okay? Committee Chair Hernan Vera is unable to attend today, so as Vice Chair, I will lead the meeting in his absence. And I'd like to welcome everyone and call the meeting to order. I'm Joanna Mendoza. I'm the Vice Chair of Stakeholders. To start the meeting, I'm going to ask Leanna to please take the roll call.
Okay, Hernan Vera. Joanna Mendoza.
Present.
Jeanette Brewer.
Present.
Michael Colantino.
Present.
Linda Corcoran. Renee LeBron.
Here.
Brandon Stallings.
Here.
Carrie Wiley.
Here.
Before we move on with the rest of the agenda, I'd like to ask if there's anyone in the room that would like to make public comment on any item on the agenda. Seeing none. We have no items on the consent agenda today, so we're going to move on with our first item of business. Kelly Evans, who is the Senior Director of the Administration of Justice, will present this item. Kelly.
Thank you, Madam. If I may, I'd like to start with giving you some highlights from the California Commission on Access to Justice.
Kelly, is your mic on?
Oh, thank you for that reminder. Is that better?
Yes.
Oh, yes.
Okay, thank you. This is Kelly Evans. I'd like to start today by sharing with you some highlights from the California Commission on Access to Justice. Every year, about this time, the Commission has an opportunity to share some highlights with you about its work from the past year. Our chair, Judge Mark Duhas, unfortunately was unable to be here today because he's at the Equal Justice Conference that the ABA holds, and I'll be joining him there later today. But he sends his regards, and I'm delighted to share with you some highlights. The report that you all have before you talks about a range of work that the Commission does. And I know that a number of you are familiar with the Commission, but for some of our newer trustees, I thought it might be helpful just for me to give you a teeny bit of background. The Access Commission was established in the late 1990s to make recommendations to the bar, to the state, to all of relevant stakeholders in our justice system about ways that we can improve the justice system for low and moderate income clients. It's a 26-member body. The Board of Trustees appoints a number of members. There are also trustees from the Governor's Office, from the Legislature, from the Supreme Court, from the California Chamber of Commerce, California Council of Churches, the Labor Federation, and other groups. It's a really broad-based group of folks. About a third of the members are judges. We have the Supreme Court Justice, Justice Liu, who has come before this body before. We have a number of appellate court justices and trial court judges as well. Just a great group of people, all who care deeply about our justice system and making sure that it's accessible to all of California. And one of the nice things about this broad-based membership is that the Commission is often able to have a unique and different perspectives about what might work or what maybe is not workable. But they also are often able to take positions as a body that any of the individual stakeholder groups would not be able to take for various institutional or political reasons. So it's a unique group. It's a hardworking group. They've been involved in some really transformational processes and projects over the years to improve justice in the state. It's our pleasure to be able to work with them and support them. As I mentioned, there's a range of work highlighted in the report. I wanted to just talk a minute about two of the big projects that the Commission worked on last year and they're continuing this year. And one of them deals with funding. The Commission is always looking for ways, often partnering with the bar, to identify more resources for our legal services providers in the state. And last year, an incredible opportunity came up. The federal government passed, basically there were some changes in federal block grants that floated the states dealing with victim services. They're called VOCA grants. And all the states have been receiving these VOCA victim assistance block grants for a number of years. California, including, in fact, California has been receiving about $77 million a year in these grants. And the state of California used the grants for very good purposes. They were used to provide compensation to victims of crime, used for shelter services, counseling services, other very critical services for crime victims. But there was a big gap in California's funding of victim services. They were not funding legal assistance for victims. And there's a lot of research and studies that have been done that show that legal assistance to victims can have an enormous impact. It can actually help in cycles of violence and put people on better paths. So one of the things that happened is that the VOCA grants that were being provided to the states was an incredible increase in 2015. California's share went from about $77 million to over $230 million. And so we thought, with new money comes new opportunity. So the Access Commission, partnering with the State Bar and the Legal Aid Association of California, we approached the state's VOCA administrators, the California Office of Emergency Services, to talk to them about what we perceived as a gap in the funding of victim services in California. So we had an opportunity to educate them about the range of services that legal services organizations provide to crime victims, ranging from domestic violence assistance to helping elders who are subject to fraud and abuse, to helping victims of consumer fraud, just a range of really important services to crime victims. And it was a really, really productive series of conversations and series of actions that the Commission took. And as a result, we're happy to report that for the first time, California has now issued RFPs, requests for proposals, that explicitly allow legal services organizations to compete for funding. To date, there's been over $30 million in new grants released that explicitly allow legal services organizations to compete for funding. And so we've had at least a dozen, maybe a little bit more of our organizations, our legal services organizations apply for this funding. The awards have not been made yet, but we are cautiously optimistic that at least some of them will receive support for some of this work. So it's a great, great project for the Commission, and they plan to expand this type of advocacy beyond this pot of money and look at other potential federal and state funding sources that we might be able to unlock for legal services. So that was one project I wanted to let you know about, focusing on resources. And then the other, I just wanted to circle back with the project I heard a little bit about before, and that's the Access Commission's Legal Incubator Project. And this is the project where the Commission decided to try to, I always call it the chocolate peanut butter problem, where two things, you put them together, they're better when you put them together. We've got this incredible unmet legal need in the states, and we have too many lawyers who are in need of work. So couldn't we do something to match the two populations? The Commission went out to private foundations and raised over $200,000, and with that money, we did a few things. We did a series of meetings across the state to bring stakeholders together and educate them about the possibility of creating legal incubators to train new lawyers to represent more moderate clients. And then we used the bulk of the money for seed grants to fund innovative, collaborative projects that would train lawyers to do this. And the Commission, working collaboratively with the bar, we ended up funding 4 legal incubators throughout the state. And the project is going like gangbusters. One of the things I think the Commission and I are most proud of is that through this advocacy, not only are the 4 incubator projects that the Commission seeded, not only are they working, but there are now about a dozen, soon to be 13 incubators in the state. Through this work, a number of programs formed, even though they didn't receive funding. Last year, the 4 programs that we seeded, their lawyers provided over 12,000 hours in pro bono service. We've got new lawyers that are now trained, fired up to represent low and moderate income folks throughout the state. It's a small number. We've got 58 graduates so far, but the programs are changing again. Judge Uhas likes to call it when you throw a stone in a pond, there's a ripple, and you don't know how far out the ripple goes. These young lawyers, not all of them are young, newer lawyers, I should say, are doing amazing things. When the fires broke out in Lake County and neighboring counties over the past several months in the fall, our incubator up there, the attorneys stepped up, worked side by side with FEMA, with a lot of legal assistance to folks who were fire victims. We've got newer attorneys who are taking over the practices, retiring attorneys in small towns. We've got newer attorneys being swooped up by opposing counsel because they're seeing what a great job that they're doing. And there's this peer network that's forming of people that realize that they can make a sustainable living serving everyday people. So it's an exciting project. We're continuing to provide technical assistance to these groups, and it's really spreading like wildfire. And so those are the two projects I want to highlight for you from the Access Commission. I'm also happy to answer any questions about anything in the report or those projects.
Kelly, can you talk, Justice Lewis came and spoke to us last year about the language access issue. Can you talk about some of what the Language Access Committee is doing?
Sure. That committee did a really influential report on language access issues in California several years ago. And that report made a number of recommendations that at the time were seen as pie in the sky, that simply unworkable or too expensive. But now we are actually being implemented in the state. And right now, it's a statewide language access plan being implemented by the Judicial Council for courts in every single county in the state. And a couple of our commissioners, Justice Rivera and Judge Steve Austin, are members and leaders of that project. They're working very closely with the folks that are implementing that. So they are striving towards having signage in languages that people can read and understand, having interpreters in cases where before there were no interpretation services available. So the Commission is continuing to be very involved in that. We think that the Judicial Council's work is moving forward and going very, very well. The next frontier for the Access Commission is to look at language access in the justice system outside of the court system. So, for example, in administrative law proceedings, just in the way that public lawyers and private lawyers deal with clients with different language issues. So we're starting to look at whether there are resources and solutions that can be extracted from everything they've done to date and put out in other contexts.
I just want to, it is, Michael Collins, I just wanted to emphasize the good work that the incubators are doing. As you know, I practice law out in Nevada County, which is not the most populous part of our state. And the history of our legal community is that we had a real legal services agency in the 60s. And when funding got consolidated, that agency was displaced by LISNIC, which is in Sacramento, and provides some services in our community, but has limited resources. And what had been a legal services office became a legal lawyers referral service and a tool for raising money for government and low-income services. Well, that has basically died. In fact, they just disbanded. And they disbanded under the pressure of the technological changes in the world. Clients, even unsophisticated ones who are looking for a lawyer, start with Google. They do not start with the white pages or the yellow pages or the county bar. And now that organization has put its energy into the incubator, which is trying to provide a way for kids to get a toe, young lawyers to get a toehold in the business, and to make a difference in the 20 counties in the northeastern corner of the state that we have traditionally served. And they have really had an impact. Not only did they do the fire outreach that we talked about, they reignited a lawyer in the library program. They reignited seminars put on by the Public Law Center where videotaped presentations are made available for a very low fee on the issues that we tend to see in our small claims court and in our mediation programs. So it's made it possible for newer lawyers to move out to a graying part of the state, quite frankly, and it's been really transformative. And I just wanted to spend a moment to congratulate you and the Commission on what I see as a real success that I hope can be replicated in other less populated corners of our state.
Thank you. I'm sure you pass that.
It's a segue from a speech to a question, if there is one. My sense is that the demise of our lawyer referral service is the canary in the coal mine, and the rest of them are going to fall soon too. And I think that means another source of funding for these programs is going to go away. And I'm hoping that's on the radar screen of one of your alphabet soup committees to give some thought to what kind of a transition is available there to recapture some of that energy and repurpose it.
It's definitely something that the Access Commission is thinking about, and actually something that with Elizabeth Parker and with our lawyer referral service certification staff folks that we're engaged in ongoing dialogue, because the reality is if people are finding life partners using technology, why wouldn't they find a lawyer doing that? So something's got to give. There's lots of dialogue and conversation happening on that front. Answers, but definitely on the radar screen.
All right, sorry, Brandon Stallings had a little bit issue with the microphone. Just want to thank you and your team for really carrying the banner for the bar in some of these really important areas. And what I see as one of the best parts about the bar, which is lawyers trying to put victims back in the position they were before they were harmed. And I think going after the broken grants is an incredibly beneficial thing, not only to victims but also to attorneys. Do you know if there's any way for those funds to supplement the client security fund? Does that come into any of your discussions or the commission's discussions?
It's not something that the commission has discussed. The California Office of Emergency Services is the vote administrator, and they administer the grants through generally competitive RFP processes, although sometimes they'll issue an RFP that's very directed. The only eligible applicant is LA County, something like that. I don't know whether they would conceive of a program that brought their collects of those. I don't know. It's not a discussion that the commission is involved in.
And then secondly, I saw under the rural task force committee, and like Michael, I come from a very rural county where we don't have the same access to the funding some of the larger counties do. What sources of funds have been identified by that committee, or is it still just kind of in the infancy stages?
So all of it right now, the bulk of the funding that we administer is administered based on a statutory formula based on poverty populations. And so, there are obviously very good reasons for that, but there are also downsides to that. So, a lot of our rural places, as you know, have few needs, have fewer resources available, but may not necessarily have the population numbers that a lot of the urban areas have. So one of the things that they are doing, so the statutory formula in some ways works, in other ways there are limitations in terms of rural environments. One of the things the Commission did last year is it brought in somebody named Jim Richardson. He's an expert on rural fundraising. He funded this group called the National Rural Funders Collaborative in Texas. And we brought him out to meet with all of our rural legal services providers to share best practices on fundraising in rural environments. And Jim did a report I'm happy to share with you. It's very, very interesting. He talked about some of the successes that they have had in Texas and other places. And one of the things that he does is talk about the connections between rural and urban places, about there's an ecosystem that's connected, and that's one strategy for the funders. So in addition to giving strategies and best practices, Jim also identified a list of funders that are willing and able to fund in rural areas, and so we made that available to all of our programs. Some of them have applied for some of that funding. So that was some funding that's available. One of the things we're always on the lookout for, though, is funding that we can target to rural areas that's not necessarily beholden to this formula. So, for example, when we did the incubator project, that was purely discretionary money, and the commission made certain that that we had one of our meetings in a rural part of the state, we did a committee in the Central Valley, but two, that some of the seed funding would go to support rural incubators. So it's a constant priority for the commission.
Thank you.
Terry?
Terry Wiley. First of all, Kelly, I want to commend you and the Legal Access Commission for the work that you're doing. I think it's fantastic, and I think it shows the important work that we do here at the State Bar. It's fantastic. Now, my question is, you indicated that you have plans for 13 additional incubators.
Not right now. When we started this project, there were a couple of incubators in the state. We provided seed funding for 4, so that makes a total of 6. Right now, there are 12, and there's soon to be 13. And those are not ones that you're funding. Those are ones, I'm so excited about this, because when we started this project in 2014, and I would talk to stakeholders, and asked them, what do you think about this idea? What do you think? There was met with a lot of skepticism. But we kept bringing people together, kept talking about different models, kept encouraging collaborations, kept pointing towards pathways of sustainability. And people got on board, and they're still getting on board. So the great thing is they're forming without us paying for them. We're serving as a convener, a source of expertise and technical assistance, but we don't have the money to pay them. But we tell them about different models, and so they're forming of their own volition. And one of the other really good things is that we have a lot of law schools on board. We have more law schools in California participating in incubators than any place else in the country.
Well, I just think it's an example of how something can start off small and grow into something.
Right, it's that ripple.
Exactly. So, fantastic. Congratulations.
Any other questions on this topic? If not, we'll move on to our second item on the agenda. Kelly Elkins is also going to be presenting on that.
Sure, this one will be shorter, I promise, but also one that I'm so pleased to be able to report to you. One of the committees that my office supports is the Standing Committee on the Delivery of Legal Services. We fondly refer to it as Scuttles. And when I first started, I thought for sure they were talking about the candy, but then I realized it's Scuttles, it's not Skittles, Scuttles. So Scuttles is a 20-member advisory group appointed by this body, and it's made up of lawyers in the field, diverse lawyers from all different practice areas all over the state, all different geographies. And in contrast to, so the Access Commission is to focus on big structural justice issues. What the Scuttles Committee does is they really look at the nuts and bolts of the system and how it's working and how it can be improved for low and moderate income folks. And given the diversity of the practice areas and geographies from which some of them come, they bring a really nice perspective. They spend a lot of time looking at court rules and processes, commenting on those if there are ways to improve them or change them to make the system work better for low and moderate income folks. They do that. They also do a fair bit of work trying to promote pro bono, and they do that in various ways. One of the ways, two of the big ways, they regularly produce trainings that are available free of charge for legal services lawyers, but also lawyers who will do pro bono. And in the report, we list the variety of trainings that the committee was involved in last year. There's an incredible diversity. These are high-quality trainings that lawyers from big firms, small firms, can receive this excellent training, and they'll feel comfortable doing an unlawful behavior case, representing a child who is an unaccompanied minor who may be facing deportation, whatever the topic is. So these trainings are available live, but they're also, we do them in this great partnership we have with the Practicing Law Institute. They're also available later to access on demand in your pajamas. So we regularly, annually, are training thousands of lawyers using this platform. It's difficult to know how many people are doing pro bono service as a result of it, because we don't have a mandatory pro bono reporting requirement in the state. But we believe that we're making more competent lawyers and we're giving them free tools to represent people free of charge. So that's one of the ways that this committee encourages and facilitates pro bono. The other way is through a recognition program. Every year they work really hard to solicit nominations and then to vet folks who've been involved in exemplary pro bono service. And they recognize people from all different walks of the legal community, law schools, big firms, small firms, law students, et cetera, et cetera. And then there's a great acknowledgement ceremony that we do with the president of the Board of Trustees. And I hope you'll all come. It's an annual meeting every year. It's usually very inspirational, and it's meaningful for the folks that are recognized. So we do that through this committee. The committee also works really hard to try to find ways to provide more representation for moderate income folks. So people that don't qualify for legal services but still can't afford a lawyer, which is actually most people. So they've been working with our lawyer referral services to encourage the lawyer referral services to come up with models for serving that group of people, average everyday Californians. And there is kind of a toolkit that they're putting together that shows the lawyer referral services how it can be done. We've got two lawyer referral services with very successful models. So they call it modest news or moderate news in a box toolkit that they're working on providing for lawyer referral services. And it includes things like information about different fee structures that you can charge people, information about unbundled legal services, folks may need help with one piece of their case, but with adequate information, they can do the other pieces themselves. Well, it's more affordable if you approach a case that way, if it's doable. So lots of different strategies to try to just fill the justice gap because it's huge. So I'm happy to answer any more questions about the work that settles the standing committee, but it's a great group of folks from all over the state.
Any questions? No questions. Thank you, Kelly.
Thank you.
We have no items on the closed session agenda, so I'd like to thank everyone for their participation and the stakeholders and Access to Justice Committee. Meeting is adjourned.
We're just going to take a minute or two. I don't want to stand and stretch.
It's still coming.
So we're delaying just a moment so that Leah Wilson can join us. And I would say a word, this is Elizabeth Harper speaking. Leah is in the middle of a major effort drafting 4 reports, and so I've excused her from most of this meeting. She's experiencing something that I've only seen in taking final exams on steroids. Oh, great. Describe it as taking final exams on steroids.
They're new.
So I'm going to call our meeting of the Regulation and Discipline Committee to order, and thank you all. Let me again remind everyone in regard to our webcasting that we are webcasting, and actually I want to thank our and this is Miriam Krinsky, the chair of the Regulation and Discipline Committee. I want to thank our executive team and our president for moving us into the webcasting world. I think that this is a tremendous advancement in terms of ensuring that the work we do is accessible and transparent, and really joins the 21st century in terms of enabling us to be available and that much more a part of the interested stakeholders and communities that might choose to follow us. So let me remind everyone, given the webcasting, that turn on your mic and please speak into your mic. Identify yourself. If you haven't already been identified, turn off your mic when you're done speaking, and I will do what I can to try to repeat any questions that didn't otherwise get picked up. So before we get to the chair's report, is there any public comment?
Madam Chair, shall we take the roll?
Oh, I'm sorry. So we will take the roll. Thank you, Deb.
Miriam Krinsky?
Yes, here.
Glenda Corcoran?
Here.
James Fox? Here. Jason Lee? Dennis Mangers?
Here.
Danette Myers?
Here.
David Pasternak?
Here.
Brandon Stallings?
Here.
Terry Wiley?
Here.
We have a forum, Madam Chair.
Thank you. So is there any public comments? Seeing none, let me go over a few things in terms of the chair's report. First of all, I appreciate the large block of time that has been allocated to RAD today, and I will do everything I can to keep us on schedule and moving along, although I know that our president has indicated that if we need to go beyond this, that we should feel fully comfortable doing so. Many of you who were here at our last board meeting recall that I think we spent the better part of 4 hours between RAD and A&E talking about these issues of public protection, and there are some very important issues that started a conversation at that meeting that we'll be returning to, not today, but at our July meeting. I think we determined there were some things, and I'll mention them toward the end of the chair's report, that we wanted to have ruminate a little bit. But I think it's very valuable, and I hope a practice will continue, at least on a yearly basis, to bring RAD together with A&E and really have that lens of how do we think about prevention and education as a mechanism for preventing and further protecting the public. I want to call out a few things in the consent items, and certainly if there are any parts of the consent items that anybody has any questions on, let us know. There are some very important status reports in there, and we put them on consent not because we think they're any less important, but we do hope and expect that not simply all members of RAD, but all members of the board look through those materials and those reports with great intensity and with great interest, because that information is incredibly important. I think what it's reflective of is the tremendous work and activity that's afoot among our staff And I want to note a few things that I spotted in it that I think is reflective of the efforts that are going on in regard to what we do and what this organization does as it relates to public protection, but also educating lawyers to keep them from running afoul of our rules and provisions. If you look at the status report of the Office of Professional Competence and see the good work that they and COPRAC are doing, what we see is that they've answered over 3,300 member inquiries, given guidance to lawyers in incredibly important areas. They've been doing a tremendous amount as it relates to training. They're going to be presenting 4 programs at the annual meeting. There have been over 50,000 visits to the ethics information webpage. The trust account handbook, something that we've talked about, that deals with some very complicated areas where lawyers can get in trouble and where their clients can suffer as a result. That trust account handbook in just 3 months has been visited over 2,200 times. Really impressive stuff. So I really think when you think of the work we do in public protection, that's such a vitally important part of it. When you look at our client security fund claims, over the last 3 months alone, $2.3 million has been paid out through the client security fund. So again, I think that those are some important things for all of us to pause and reflect upon in terms of the good work that's been going on. I also want to thank Colin and our State Bar Court again for the welcome they gave us during Discipline Day. You all saw that the opinion from the case that we saw had the opportunity to hear has come out. And so for those of you who were there, you might find it of interest to see where the court came out. For any of the new members of the board or anyone who didn't have a chance to see the State Bar Court in operation, I would really encourage you to take the time and do that. And you can work with me or work with Colin if you're interested in seeing an argument, but I think it was incredibly illuminating to be able to be there and watch our State Bar Court, which is really unique in the nation, and see the quality of the court, the thoughtfulness, the professionalism that they bring to our discipline system process. I also want to welcome our OCTC interim director, Greg Dressler, and thank him for stepping up and for the good work that I know he's going to be continuing in the coming months. Jim and I plan to spend some time with him before the next meeting to go through and really, as we did at the start of our term, look at what's on the horizon, look at the work afoot, and ensure that the transition process is as seamless as possible, and that we continue as a body and as the leadership of this committee to work very closely with OCTC. The Ethics Symposium was held on April 9th in San Francisco. Over 80 attendees, a day-long program. The Sondheim Award was given on behalf of this organization to Karen Goodman and Judge Brian Walsh. And I want to thank our president and vice president for going and waving the flag of the Board of Trustees and being there for that program. And finally, I want to flag 2 upcoming meetings that we have on the horizon, just in terms of some of the things that are coming up. As you all know, at the end of June, on June 23rd, there will be a special meeting of the board to deal with the very large package that will be coming to us from our Rules Revision Commission. We'll have an opportunity during the board meeting, and David and I talked, and I think it was David's decision, and I think a very good one, to do the previewing of a few more of those rules that will be coming from the Rules Revision Commission before the full board, so that all members of the board can be engaged in that previewing. So we'll have a few more rules come to us at that previewing during the board meeting. And I very much appreciate Randy and Jason, as well as our liaison, for working together on trying to identify the rules that really need some added attention by the board. That commission has done incredible work. They've now approved 38 rules and as of their April 1 meeting. And they will be meeting in Los Angeles, that commission, on June 3rd. For any of the board members who happen to be in LA that day, I think it's a wonderful process to see in action. I've been to a few of their meetings now. and very impressive to see the nature of the dialogue that's going on by that commission. And finally, at the July RAD meeting, that's going to be an opportunity for us to circle back on a few of the issues that came up at the last board meeting. We'll talk about the expungement issue that was raised during public comment. We'll have an opportunity to circle back on some of the prevention strategies, and I want to thank Brandon and Jason for sort of working with me to follow up on some of the interesting work that's being done around substance abuse, alcohol abuse, and the recent study that came out identifying the prevalence of those concerns within our profession and within law schools and among young lawyers. And we'll have a chance to circle back on the client trust account survey and recommendations. So we've got a lot of good things on the horizon, and as always, thank you to Doug and to our staff for sort of keeping us on track and working with us on all of that. So let me now move to the consent items. Is there anyone that wants to have any of these items moved off for consent? Okay, so our first item of business, and let me know that at some point we will have one of the presenters that will be coming for some of the Rule 2201 matters that we'll be doing in closed session. So when that individual does come, I think we're going to try to wrap up whatever agenda item we're on and move into close to accommodate his schedule. So we'll do a little bit of stop-start on that when he does get here. So the first item on our agenda, Leah Wilson will be reporting on, and as you all may recall, when we talked about our annual discipline report, we decided that it was very important for us to be, as a body, looking at and thinking about some of the takeaways of the ADR. So this is something that we're going to start a process of today. I think we're going to have a continued dialogue and attention to the ADR issues throughout the course of RAD meetings over the coming months. And this is an opportunity, I think, for us to hear a little bit more about the new Office of Research and Institutional Accountability, which is quite a mouthful, but needs its own good moniker. And on that, again, I want to thank Leah and acknowledge just how quickly in the last few months that has come together. That was an idea that we had a chance to talk about during the January breakout session, during our January planning meeting. And in a very short period of time, we're now already seeing that operationalized. So thank you to Leah, and Leah, take it away.
Okay, and I am going to introduce Dad McLeod, who's the director of that office, and I think our acronym is ORIA, right?
We've been struggling with that mouthful ourselves.
Yeah. No, you have to turn your mic up, press that button. Yeah, there's a little bit button at the bottom. I'll take that. Right. So one of the things that came up in preparing this year's annual discipline report is the fact that along the way, a number of decisions need to be made about what is included and why. And we did the best that we could, and we footnoted extensively all of those decisions that were made. But what I think needs to happen is we need to schedule actually a significant amount of time on Brad's agenda to really go through sort of each element where there is a decision point. Basically, the statute lays out many of the reporting requirements, but still does call for the exercise of a lot of discretion about how you define those statutory requirements. And we did the best that we could, but I think there are many different ways you can go. And some examples of this are how you handle reportable actions. We chose to pull the criminal conviction monitoring out, so we didn't pull out the parallel to criminal conviction matters on the civil side, where there are some very similar circumstances that would suggest that those should not be captured in the backlog. We left those in, we pulled the criminal out. There's any number of examples like that. So that's one part of figuring out or having RAD get engaged with the ADR is really some nitty-gritty work on all of the decision points on the data. But then stepping back, there's more of the macro issues. I know when we discussed the report this last time, there was some concern by several board members, and I think you, Miriam, in particular, about what is it that we're reporting on. This is our opportunity to do an annual report to the legislature and our other stakeholders about the functioning of our discipline system. And pretty much what we've given is a whole lot of tables, right? Some analysis, but a lot of tables, and we're only giving a piece of the story. And so that takes me to the even bigger question that I think this committee needs to grapple with, which is how do we define our discipline system? And of course, there's a great nexus there to the conversations happening at the governance task force. We chose to define the discipline system a certain way for the purposes of ADR, and why you're forced to do that through the ADR process is you have to report on the costs of the discipline system. So in reporting on costs, you have to decide which programs and parts of the bar you're including. We've made decisions about how we define the discipline system as part of the workforce planning effort that you'll hear about later this afternoon. But those are decisions that we are kind of making up as we go, and I think they really need to be formalized and ultimately somehow reflected in the statutes that govern our reporting on the discipline system. So those are some of the issues that I see us really needing to tackle, as well, again, as more kind of structural and foundational issues on data integrity. And with that, I'm going to introduce Dag, again, our director, and I'd like you to say a little bit about your background, because some people know Dag, not all of you do, but he's really a great catch for us here at the bar, and we're going to be able to draw upon his background quite extensively. So I'm going to introduce Dag. Dag's recently taken over supervising the 2 data analysts in OCTC, and in a very short period of time has gotten kind of a good sense of some of the issues around our OCTC data in particular. Dag.
Thank you, Leah. My microphone is on. Everybody can hear me? I'm webcasting. Thank you for that introduction.
Now my microphone's on. I come to the State Bar from the Judicial Council. I got my teeth in judicial administration at the Judicial Council, where I spent about 14 years. I worked in the Office of Court Research, which itself was just being established when I arrived, and worked as a research analyst there. I eventually became the manager of the Office of Court Research, and really the main thing that we focused on at the Office of Court Research initially was developing workload standards for judicial officers and workload standards for the trial courts. And it was an interesting process that only really bore fruit. I started in 1999 and bore fruit in 2013 after a lot of wrangling between the Superior Courts and the Judicial Council over data and interpretation of the data and what you really can say about something as simple as filings. Like, are we counting our filings data correctly, and does it mean what we think it means, and is a felony filing in Los Angeles comparable to a felony filing in Alpine? So a lot of questions that can seem kind of esoteric and that have real-world application when you get into using these data for policy purposes. So that's kind of my background at the Judicial Council. I've very summarized. There's a lot more in the 14 years, I hope. I spent 2 years in the Superior Court of Alameda County, working as the director of criminal and traffic operations. I wanted to work on direct operations, and had a really good time sort of getting into the nuts and bolts of case processing. But when I saw that there was an opportunity here to go back to some of the data and research stuff, it was awfully tempting, and I'm excited to be here. And it's been a pleasure. It's been an exciting month. I started just over a month ago. And so it's been a blast getting to know Elizabeth and Leah, and I already knew Leah. Full disclosure, already knew Leah, but getting to know Elizabeth and getting to know the bar a little bit. So, when I arrived, the ADR was already in process, and it had someone assigned to it who was doing a great job, and I didn't jump into that. I had a couple of observations about it, so I'm not going to really discuss the ADR so much unless you have questions you'd like to ask. But I would like to say a little bit about just some observations that I've had about what I've seen in terms of data and data quality, and sort of what I'd like to start working on. I've been reminded repeatedly working here of something that a court executive from a large Southern California court used to always like to tell me. He used to say, if you've seen one court, you've seen one court. And I think that comment spoke to kind of the tension between what we did at the Judicial Council, where we were looking at the fact that, hey, we're looking at a court system. And we need to understand like the courts as units that are comparable, and what they do is comparable across, across the entire state. And yet as soon as you get on the ground, you do see that courts have a lot of differences across courts in the way that they do things. They call things the same thing. It might be a preliminary hearing here, it might be a preliminary hearing there. What they actually do on the ground can be very different. And so what it means in terms of the time it takes to do that, the resources required for it, and the outcomes that you get as a result of it can be very different, even though it's called the same thing, it's counted the same way. So I mentioned that because having arrived at the bar barely a month ago, I look around and I see a very unique organization. There are a lot of things here that I'm getting up to speed on, like what it is exactly that the bar does, what the discipline system is, how things work. But I wanted to also just point out, and I think this would be the thrust of my comments today, would be that I also see a lot of similarities. And I think there are organizational similarities between what I'm seeing here at the bar and what I saw at the Judicial Council in my time there. And let me just point to a couple of those similarities. The first thing that I really realized when I was at the Judicial Council, I was coming to the Judicial Council directly out of graduate school, and I was surprised to see how data don't really speak unless spoken to. And by that, what I mean is that the council used to collect a lot of data, and it would go into a system, and sometimes it would go out into a report. But until we actually started using that data, people didn't pay that much attention to it. And so we would produce an annual court statistics report. People would review the data. They'd say, okay, yeah, I guess so, and we'd move on. When we actually started using the data, when we said, we're going to look at our work, our caseload, the number of filings, and we're going to try to weight those to take into account case complexity. And once we weight those based upon case complexity, we're going to try to say something about how many judges the state of California needs, how many staff the superior courts need. That process developed a great deal of interest and debate over whether the numbers were being counted correctly, and it sort of led us to some very fundamental, what I was saying earlier, I think, can seem like esoteric questions of like, how do you count a preliminary hearing, or how do you count any of a number of things that come up? With criminal cases as opposed to civil cases, the counting rules are different for those. Do you count parties, or do you count numbers of defendants? Do you count counts against defendants, or do you count only the body? You've got a person in custody, you count him, or you count the charges against that person? So all of these questions we were wrestling with the Judicial Council, and they became, we only started resolving them when the data had a meaning beyond just the reporting, like, yeah, we have to comply with the legislature's mandate that we submit an annual court statistics report. Another thing that I saw there that I think I'm seeing here is that the quality of data, it kind of depends upon where you're sitting. And I think that there are really three distinct places that look closely at data and that have a distinct function to perform. They need to collaborate closely, but they have distinct functions. And those are the IT side, the analysis side, and then at this level, the policy side. So the IT is historically data often starts in IT, and historically data management and analysis got stuck in IT because that's where the data came. As soon as information systems started producing data, that's where it was, and people started using IT people to do data analysis. And yet the meaning of the data was often not fully appreciated. And so I think what happened was that IT people, and I saw this at the council, would say, okay, the data are complete, they've all been reported. And then the research people would look at it and say, well, yeah, they reported it, but it doesn't really make that much sense. Like, you're saying that, say, Nevada County has twice as many filings of something as Los Angeles County. So let's just at least step back for a moment and say, yes, they reported, but what did they report, and how do these values relate to one another? So this is kind of a different focus on data that I think research and analysis has that is distinct from IT, and I mean no disrespect to IT. I see Rusty over there. I had a great talk the other day with Marat And I think I'm really excited about collaborating with the IT group. But I think it's just a different focus, and it's necessary. It's not a bad thing. It's just different. And then the next level of data, when you get beyond the analysis level of like looking at issues of validity and reliability of the data to make sure that the numbers just make sense on the face of them, then you get to the policy level where data quality is yet another thing. And there was an interesting discussion at the board meeting in Sacramento that sort of got to this question. When you look at the data and you say, well, we have imposed more severe discipline on attorneys in the most recent period than we did in the period before that. Is that a good thing? Are those notches on the belt? Are we excited about that? Or is that a bad thing? We've received fewer complaints than we did in the previous period. Is that a good thing or is that a bad thing? That's more of a policy, political question than a research analytic question. But again, I think that it's a collaborative process where IT research and then policymakers, leadership come together, and have the leadership will have confidence in the data that they're not seeing a difference in the number of complaints, or they're not seeing a difference in the severity of discipline meted out that's a statistical anomaly that's a result of data reporting issues or changes in operations that often cause these types of changes in what you're seeing in the data. So 2 final points that I just wanted to make, if I'm not losing people yet. Some people really get into data, other people are like, please. So I'm one of those people that really gets into it. So to the 2 final points I would make are, one, that transactional systems, and this is, again, these are just things I've seen here that I think they look very familiar to what I saw at the Judicial Council. Transactional systems were not they were not built for analysis and reporting of data. And by that I mean transactional systems are the case management systems that are run in the trial courts for managing their cases. District attorneys' offices have them, public defenders have them. Everybody has a case management system of one kind or another. It might be an Excel spreadsheet, but pretty much everybody at this point has a case management system for tracking the business. That's what you need a case management system for. That function is very different from producing data for analysis and for research and for reporting. And you might be surprised to hear it, but even as a researcher, I don't believe that the transactional system should be built for reporting. I think that they should be built to make your business process run smoothly. So I think that the trick with good case management systems and with good research is to know how to lock down codes, to know how to have clear rules for changing codes when a new issue comes up that you want to track, making sure that you've documented all that information well, that you're not losing track of, like, hey, we used to code this in this way, now we're going to code it in that way. Now we care about this, we didn't used to care about that. Immigrants didn't used to be an issue, or whatever the issue might be that comes up. You just need to have systems in place to document that stuff, and that allow you to sort of go back and say, yeah, this is, we're still counting the same things. Maybe we've broken out some new categories, but there's consistency over time in terms of the reporting. So then the final point I just wanted to say is Leah asked me yesterday, late afternoon, she's like, oh, you're on the agenda tomorrow. I was like, okay. So she said, say a couple words. And so I think I said more than a couple now. But she said, talk a little bit about your plans for the office. Well, I think that there are really 2 big categories of work that I envision, and I'd love to get feedback on what fits into those categories, as well as the possibility that there are other categories that I'm not thinking of. But the 2 big categories in mind are sort of ongoing management data, the data that talks about the work of the bar itself. It's sort of an internal management controls that reflects our staffing levels and the workload of our staff and any range of things that affect our workload, incoming filings and times to disposition of cases. And I don't have the terminology down exactly. I don't hear the term disposition used much. And there seem to be interim dispositions from intake in OCTC to the pre-filing stage, the investigation stage in OCTC, and then through filing in state bar court, and then the process of the case being adjudicated in the state bar court. But really getting a handle on all that internal management data, that's a big infrastructure issue, and I think it can take a lot of time on the front end, but once you've built it up, it should flow. It's again, it's these data that come in as a byproduct of the business process. We're not talking about building special reports. This should be part of our bread and butter, that we know, how many staff working on what, how long cases take, how many cases coming in what categories. The other big category that I think of that the office is going to be working on and that I haven't even been able to turn my attention to yet, but that I think is also very exciting, I see Kelly sitting out there, is the area that Kelly works in terms of like providing funding to legal aid providers and looking at the outcomes of those programs. There's a lot of money going out to help to improve access to justice in the state of California. I think that's a terrific thing. Are we getting the most that we can from the money that we're spending, and are the programs working, and what are the people of the state of California really getting from the great work that's being done? So those are the two broad categories that I sort of envision the office working in. It's again, it's been an exciting month. I hope maybe a little less exciting next month. We'll see. We've got another big report coming up, but.
Okay. But I did want to clarify, Doug, when you're talking about the Kelly and the legal services, that's not the only part of the second piece of the office. So we've been talking about sort of the internal data management as well as program evaluation more generally. Another piece is bringing in some of the work that we're contracting out to researchers across many of our programs, including admissions, because I see Gail here. So that's another part of the charge that I've given to Doug in his office.
So I'm seeing a couple of hands, but Leah, I'm not sure that you were yet finished. So maybe we can have Leah finish unless you all had specific questions for Dag.
I do.
Yeah, and I'm finished because I think we need to agendize maybe an hour or so on ADR, and it is kind of a mind-numbing experience. So maybe we're going to start now. We have many meetings ahead of us before the next one is due. We can take some chunks at a time each meeting and just go through some of the definitional issues.
Great, and one thing that I think Jim and I may have an opportunity to sit down and talk to Leah about, and Greg as well, as we're planning for the July meeting, is what is the best way to manage that. And we may think about creating in essence, having a subcommittee, having a couple people on RAD work with Leah and Dag on that. So let us know, or let me know. I mean, if this stuff sounds wild and crazy and fun to you, and or you'd be particularly interested in sort of rolling up your sleeves and helping get into some of these issues, that would be useful to know. And I think we're going to start to look at how do we best break it down a little bit and think about ways to engage RAD in a number of these ongoing issues, because I think this year, as we know, was the first time that RAD and the board had the ADR presented to it with an opportunity to engage on it, that started not at the very last meeting we had, but a couple meetings before that. So we've really had some ongoing conversations, but I think it behooves us, now that we've gone through that process once, and now that we have individuals who are really taking a long, hard look at this in a capable way, to start to think through not simply the mechanics of what needs to be in the ADR, but really the more meaningful issues, because it's not just about putting out a report. It's about the fact that we need to be keeping our finger on the pulse of how we are doing in regard to our discipline system, and what does that mean, and what do we need to be tracking, thinking about, monitoring, and how do we best do that. So I know Elizabeth wanted to make some comments, and I saw David and Denny and any other comments.
Thanks, Mary. Elizabeth Parker. I'll be very brief and just to express my enthusiasm for the creation of this unit and with Dag's arrival. I think the only tension that Leah and I have had is who gets more of Dag's time, and so far I've been losing. But the fact is that unless we measure things, I don't think we can manage them. So this is just a thrilling moment, I think, for the State Bar to really see its way to a very different kind of day. We talked about internal measurement, but I think there's an important goal that eventually we must get to, and that is benchmarking ourselves externally as well, to make certain that what we are doing is absolutely at the level of excellence that we deserve to be providing the citizens of California. And I think then this is the start of something that is really a major shift in the way we focus on our work. And so to Leah and Dag, I want to express tremendous thanks. Already you're seeing a huge difference in the kind of reports we're generating. There will be 4 coming out shortly that will be evidence publicly that we really are making a major shift. And I'm delighted to be part of it.
Great. So David and then Dan.
Yeah, Dave Pasternak. I had heard about DAG in this unit before. It's the first time I had an opportunity to meet DAG and hear firsthand about his background and what he's doing. And I really want to compliment our senior management team because it's just quite evident that what you're bringing to the bar in terms of addressing issues we've had in the past. The auditor's report last year made it quite clear that we've had data collection issues in the past. But you're moving beyond that to what are we going to do with the data and how we're going to use it and what purposes can it serve and how can it make us a better organization in fulfilling our public role. I just think that you're absolutely doing what you're supposed to be doing. I do want to express a concern, however. I now count 2 very excellent employees that we poached from our senior judicial branch. And I do want to express a concern about taking too many away because eventually we may get some backlash from that. But I welcome you, Dad. Thank you everything for that.
Thank you.
Denny Mangers, I want to second the President and the CEO's observations today. Most welcome. Your maiden report is well received from my view. A couple of comments that I hope will be pertinent. This very curious system that you've joined here has half of the people's regulators sitting here paying rapt attention and half of the people's regulators either in the hall or in the audience on their phones and laptops. So what we're going to have to find a way to do is to engage not only the members of RAD, if this system is to continue more effectively, and there's a data component to that, but we also have to find a way to engage the balance who don't have the benefit of sitting here and performing their role as regulators because of the way we're organized. This is no help to the regulatory body itself at all. It's statutorily required and almost indecipherable. So I'd like to underscore the importance of your suggestion, Leah, that we pull together not an hour, not a day of the body, but, Madam Chair, a subcommittee as you've proposed, that actually works with you and Dag and gets into the nuts and bolts. And finally, after the nearly 6 years I've been here, we get to an understanding of what's required statutorily, but more importantly, what would benefit us as regulators in making the decisions around the things that Ms. Krinsky and I have been talking about for several years, and that how do we become more proactive in our discipline system on the basis of what we learn about the discipline system. For 6 years, I've been told that in the absence of a case management system, we can't actually provide any data that's relevant in that regard. DAG seems to be suggesting today that that's not the case, that there are ways to draw data by working in a kind of interrelated, synergistic fashion with the other elements of the agency, drawing the data that would be instructive to us as we try to become more engaged as regulators, and as we've often talked, Ms. Krinsky, not just as a punishing machine, but really trying to find out how do we prevent some of the heinous problems that we see going before our state bar court. So I welcome you, Dag, and I'm hoping that somehow when we go back into board meetings, instead of the usual process of presenting our colleagues, all of whom are regulators, with just resolutions that reflect motions essentially, 2 or 3 liners, that we actually report out to the balance of the regulators something that's meaningful to them and pulls them into the process. This hasn't done it. Even this one-page encapsulation has failed to do it. So I think maybe you can help us develop, on the basis of what you learn about the system, devices or tactics that take the data, as you put it, out of the esoteric, and just reports that I can tell you as a former legislator sit around on desks and in files almost never read, and find a way to get it more meaningful and useful. That's my hope for this body, and you're most welcome. And I think you and Leah, in combination with our very capable chair, can work out a scheme where instead of continuing to talk about these, we actually set up the subcommittee. By the end of the year, we ought to be able to devise an annual report that actually is useful. And more importantly, a board meeting report that actually engages our people as regulators and tells us something that we need to know. Those are my views.
I wanted to jump in and just ask Brad to comment on the monthly reports, because he has made some, taken a look at least the OCTC monthly reports and made some comments to me about that. And I'd like you to just share some of your initial thinking or questions about how useful they are, because I'd love to hear from the committee as to how useful you find the reports, because I think that is something on Doug's agenda to address.
I just wanted to make sure I get the 2 points. I think the two main observations that I've seen about the reports that I've seen to date are these. One is that we have a lot of what appear to be sort of in-process measures. Like there's a backlog number, there's a tendency number. You can sort of look at what I think perhaps the comparison would be to say, like, you know how much. You know what the deficit is that you're running, but you don't know. But the numbers are not always clear in terms of, like, is that a deficit that you're running on top of, like, a really huge amount of, like, income and payments on the deficit? So, like, what is your debt? Or is that a deficit that you're running on the basis of, like, maybe a smaller proportion? So trying to get at the difference between, like, these flows of work that go through and what I earlier mentioned is a term that's not used much here, but dispositions. Because to my mind, the disposition is a count of, like, that's work completed. And when I look at disposition, I at least know that it's moved on. So I want to see more disposition data. This is something that I've been struggling a bit, talking to Yolanda and Fumiko about to get it. I want to see more sort of disposition of work completed at stages that gets us to some estimates of, like, okay, that's how long it takes. I mean, we know how long it takes on average to get through the system, but I think that those disposition numbers still remain murky to me. So that's one observation. The other is that when I look at the flow of cases through the system, we start out by counting complaints. Eventually, we get to state bar court where we're working primarily with respondents. Those two numbers are somewhat different, and I think my sense is that we do ourselves a disservice on the backlog numbers in particular, because we take those complaints that are suspended or put in abeyance, and we set them aside, but we continue to count them as backlog. I think the auditor might have dinged us on this, but I think that's totally legitimate. It's not that we're not working those. There's a respondent who's being prosecuted on many of those cases, and yet we're counting the backlog of those suspended cases on that respondent against ourselves. So I think we need to really get clearer on, like, respondents versus complaints, and I think that they're both useful measures, but they just need to be understood in relationship to one another.
That latter comment is particularly responsive to what I just said. You know, I've been hearing that every single year. Of course, there are aspects of the backlog thing that aren't even fair to the bar, but we don't take the initiative to do something about it. Now, what I'm hopeful is, with this initiative the chair has proposed and that Leah intends to staff with her help, is we sit down. An auditor is not just out to attack the bar. An auditor is a rational, thinking, intelligent human being that if we sit down with them and bring them in partnership, we can come to an understanding about what should be reported and how. And I think that's what you're getting at this latter part. That lack of understanding, that common understanding with our oversight agencies, continues to lead to the kind of attacks that are in many cases unwarranted, but we don't do anything about it. So welcome to hopefully solving that problem.
One of my questions here, in terms of putting together a subcommittee and the timing, I was just thinking about how much of any of this work we would want to try to get codified in this year's fee bill. That would suggest a little bit more acceleration. You know, I think it's to our benefit to take the time and to develop requirements for our own reporting outside of the legislative process. But to the extent that we want to clarify things like what are we including in the backlog, that makes sense to put on the fee bill timeline. So I was just, wanting to raise that.
That's a great point. But in thinking through, so that would mean that we would need to have some proposals, kind of ready to go by.
I don't know. That's what I was thinking of August.
So I don't think it's out of the question for us to be able to have some proposals thought through, ready to go by the July meeting, which positions us in time. This is the first step in not the first step. I mean, we've already been talking about this through a few meetings, but in terms of really trying to put this train on the track and get it moving and fueled, we're starting down what is going to continue and be an agenda item for all of our RAP meetings. So the fact that we're trying to do some legislative fixes doesn't mean that that's the end of it. I mean, this is really something that on an ongoing basis, not just this committee, but I appreciate the fact that we do have, as Danny pointed out, other board members that I think are here, are listening, are they're not sitting around the table. I think taking this discussion quite seriously, and there will be elements of this that we will bring to the full board. So this is going to be an engaged and inclusive process for this entire board. But I do see the need to try, both while we're looking at some short-term legislative ideas and fixes, to also be developing the longer tracks and laying them down. So, yeah, Jim.
I agree that legislatively, ultimately, we need to address it. The concern that I have is, frankly, the willingness of the legislature to change anything in our current reporting, because I'm not sure that they're going to be willing to do that. I think that it's important, and Denny certainly hit the nail right on the head, talking about the fact that we have been unfairly attacked with the current reporting of backlog, including cases that are suspended or in abeyance. There's nothing we can do about it, and yet we get hammered with that. So I'm not saying that we should not attempt to deal with it legislatively, but I am suggesting that we need to partner with perhaps the state auditor, who has been very critical, and get on board with them and collaboratively approach rationally. As Denny said, auditors are rational people, to point out how unfair historically the mandate has been, and to modify it with their support. And I think then we would be able to generate legislative support to statutorily change the mandate.
Any other thoughts or comments on this?
I think Jim Fox has made a very, Elizabeth Parker, I think Jim Fox has made a very useful suggestion. The timeline we're talking about may be too aggressive to achieve all of that, and I'm a little worried watching Leah and Ned working as if they were doing final exams, as I mentioned earlier, on steroids, spending all-nighters, that they can really accommodate this kind of a project in a very short space of time. So I think that needs to be factored in. I think, however, we could reach out to the auditor even now and see whether they would be willing to collaborate with us on this kind of a project. I think with their involvement, then we would have what we need to address the changes with the legislature in a collaborative way, and that could be very successful.
Well, I think these are all terrific ideas, and as everyone can hear, we are very fortunate to have Dad with us. I think that this is really going to up our game in terms of our ability to be thinking in a strategic way about how do we learn what we need to learn to be promoting protection of the public and to fulfill our mission, and do it in a way that benefits from the data, benefits from the information, and makes it meaningful so that there's not a misunderstanding or misimpressions about the quality of the work that we're doing. This discipline system and has been referred to by many as one of the best in the nation, and yet that doesn't mean that there aren't things that we can do better, and it doesn't mean that there aren't those who will continue to criticize or find fault, but we can always do better. And so I think that we can benefit from all of those observations and in an enlightened, strategic way, look for how we can continue to do the job that we do. So I want to thank you guys for the presentation, and we look forward to continuing the discussion at the next meeting. So with that, I know that we have the individual with us who is going to be reporting on some of the closed items. So what I'd like to do now is have us moved into closed. I'll officially do that in a minute, but for those of you who are going to be moving, it's my understanding that probably we're looking at around 40 minutes or so of discussion in closed. What I'm going to suggest for the RAD members who are staying in the room, I was going to take a break right now, but I understand that the individual who's with us to present the closed is on a tight schedule. So if you can hang with us, we'll do half of closed first, and then we'll take a break, and then we'll finish up with closed. So again, for those of you who are on the clock to rejoining us, maybe we're talking about coming out of closed in around 15 minutes or so. So if that sounds all right, then pursuant to Business and Professions Code Section 6026.5 sub E, we'll be moving into closed to have a discussion in regard to disciplinary investigations and proceedings. So thank you all for taking
Okay. Okay. Stand by for.
That's what I thought.
You remember
Well, that's what, that's kind of.
I'm just.
I mean, that's what I was saying.
You do remember public members.
Yeah,
Left-hander's seat over here.
Jason, Annette, and Eric.
Yes, yes.
I'll call you something.
Okay. Hi. How you doing? How are you? It's doing okay. Yeah.
You don't hear as much like
I'm done and I'm buying my car.
I guess that's a good sign that she's going to.
Jeanette's here, but now Jason and Terry. Should we just go ahead and get started? We have a forum.
They're coming in the door.
Okay. Terry. All right, now we got it. Praise God. Whenever you're ready, Madam Chair.
Okay. Okay, I think we're going to resume our RAD meeting in open session, and the next item on the agenda is 3B, the non-attorney UPL takeaways, proposed new protocols and policy, and I think Greg will be presenting on that, and Jason and Jen will also be doing that. So, gentlemen, whoever wanted to take it away first, I'm assuming that's probably going to be you, Greg.
Yes. I think I'm going to just put my mic on. I'm very interested. So we drafted for implementation in OCTC a policy directive on the handling of non-attorney unauthorized practice of law complaints, so that we have very clear direction and understanding for all staff about how non-attorney UPL complaints are to be handled. And there's a draft that was posted with the materials for the meeting. The draft is going to be further revised, and I think we'll easily have it finalized for consideration and approval by the July meeting. And in general, the idea with non-attorney UPL complaints is that when they come in, if there is an allegation of non-attorney UPL, or if evidence develops of non-attorney UPL, then as soon as a case like that gets to enforcement, there will be a law enforcement referral. And after that, we've opened lines of communication with law enforcement partners, and we're going to keep those open so that they know that we're going to be handling complaints this way. But additionally, that once we refer something, that doesn't mean that we've stopped work on it or that it's been closed by us, but that we will update them with information as investigations progress. But they're getting the referral at the beginning of the investigation rather than at the very end of the investigation, which has been, I think, the historic practice about the way the referrals have worked. And so you'll see in the policy directive, there are very specific ideas about timelines and who is going to have responsibility for making referrals, and then we will have. We're working on a parallel track, but once we implement the policy directive, we'll also have protocols within the office that have more granular direction for OCTC staff on the handling of attorney UPL complaints.
And then I know, Jim, you wanted to offer some thoughts as well.
I'd like you to explain from a management standpoint how, when a case comes in through intake and lands in investigation, at what point you, as the acting trial counsel, have an opportunity to then track its progress through the process you just described?
So in terms of anyone in the office who is looking at a complaint, I mean, it goes into our system, and it's coded when it moves from intake to investigations. And then also, as the case progresses, status updates are entered into the system, including we are tracking when the referral happened, who the referral went to, and we're working on the protocols around the information that gets transmitted and then the record of the information that gets transmitted.
As you can imagine, what I specifically would like to know is that if something receives a code or a number, a case, whatever,
yes,
from intake into investigation, how is it possible then that we hear that hundreds of these have somehow been lost, misplaced, misfiled, without anybody knowing? And what's the protection, the prevention from that going forward? Because when I go about, I'm being held, in some cases, kind of personally responsible. For instance, when I was RAD chair, how is it on your watch or subsequently several hundred of these UPL cases can be lost and no one knows? And at some point, somebody kind of lamely suggested, well, that's a case management system problem. If it were electronic, it wouldn't be the case. Well, in the absence of electronic, you seem to be describing a system, but that failed us.
Right. So I'm not sure in terms of my ability to speak about things that happened historically is limited. I will tell you what the plan for the future is, though. You know, there's going to be an expectation, and it's set forth in the policy directive, of how and when and frankly how fast cases are supposed to move, and that is set forth in this policy directive. And basically, the timelines are to be the same as attorney cases that we get into OCTC in terms of when the timeline to move them out of intake and the timeline to investigate them in enforcement. And so they're going to be in the system, and there's going to be tracking around, you know, has this case moved, and we will know if a case has been in intake for a longer period of time than recommended, and then someone can look at that and see what the problem is. Not all of them will move as fast as we would like, but the policy directive has a timeline and has a goal for the percentage.
Well, you've leapt to timeliness and timeline.
Right.
But I'm trying to get at something rather more fundamental, and that is, what is the system, irrespective of UPL? What is the system when a case moves from intake to investigation?
Right.
How is it numbered or coded, or how does it become part of your management system, so that you always know how many you have and at what stage they are, and so that hundreds can't be lost? What is the system?
It's upon receipt, they're coded into the system, and the system gives them a number. And then when a case moves from intake to enforcement, it's coded that it has moved from intake to enforcement.
And then you, as trial counsel, acting trial counsel, have some means, I assume on computer, to track those numbers and know at all times what the status of those cases is.
In terms of that specifically, we develop reports so that can be tracked, and it can be tracked on a timely basis, yes.
So, I'm not holding you responsible for this by any means, but so from your standpoint, given that system, it's kind of unthinkable that you as trial counsel wouldn't have several hundred cases go missing, or 50, or 10, because there's always a way to track every single case that came out of intake.
There is a way to track cases, absolutely there is, and certainly I don't want any case to be lost. UPL case, regular complaint about attorneys, they all go into the system and they're all tracked.
So I just want to underscore that what you're essentially saying is that system has always been in place. Apparently it did fail, it's not on your watch, but on your watch, you have a system now, a management system for tracking cases and assuring the RAD committee that we're not going to have any cases going missing on your watch.
That absolutely is my goal, and we have the case management system that we have. It's by no means up to date, and it was not invented in this millennium. I can assure you of that. It is not a great system, but there is a way to track cases in the system. Yes, sir.
Thank you.
So I saw a couple of hands. let me maybe, I saw Jim and Jason, I know, David, you had your hand up as well. Let me maybe turn it over to Jim and Jason next, because obviously we're aiming to do two things here. I think one is we're aiming to try to look backwards and see what we can learn from how things were handled previously, and what that shows us in terms of any voids or system breakdowns or failures or opportunities to try to improve. And second of all, we're trying to look forward and be able to craft some policy and a new way of handling these cases. So Jim and Jason were willing to step up and work together as a subcommittee at David and my request to do both of those and work with Greg on that. So I think maybe the two of you can provide a bit more background on what you've been doing thus far and kind of what you still hope to continue to do to help us on this.
Okay, let me start out. First of all, as everybody here knows, the ability of the State Bar to deal with non-attorney UPLs is very, very limited. If a non-attorney is, quote, practicing law and has a case load, we have the ability to go into the Superior Court and obtain an order assuming the jurisdiction over that practice. We do not have the ability to in any way punish or control the behavior of non-attorneys. Our jurisdiction is over attorneys, other than when the public is at risk by a non-attorney practicing law. As I said, we can acquire control over that caseload, as it were. There was a meeting a couple of weeks ago with representatives from octc, the Los Angeles District Attorney, the Los Angeles City Attorney, and the Department of Consumer Affairs in Los Angeles. However, that was specific to Los Angeles. And going forward, we will be working collaboratively with the California District Attorneys Association, which includes as its members those city attorneys who have prosecutorial powers. There are provisions under the Business and Professions Code whereby unfair business practice actions can be filed by district attorneys, city attorneys in jurisdictions over 750,000, or city attorneys who have prosecutorial powers. They have to be informed of the existence of those cases, though, before they could try to exercise any control or jurisdiction over 17,200 or 17,500 of the Business and Professions Code. What the draft proposal that Greg has put together will do is to speed up the referral to law enforcement, because only law enforcement and prosecutors, criminal prosecutors, have the power to regulate or to basically seek criminal sanctions. It is a misdemeanor for a non-attorney to practice law. Only they can prosecute. We are not able to do that. So we are trying to establish a system whereby when the case comes in, if it is determined by octc that in fact a non-attorney has regularly been practicing law without a license, that matter will be referred to prosecuting authorities or to law enforcement. The difficulty from the law enforcement's perspective is the lack of resources that they have to deal with these cases. And that is an issue, that the legislature has expressed its concern about UPL. And frankly, it's an issue that is going to require resources. The State Bar doesn't have the resources, nor do we have the power to impose sanctions against non-attorneys. The state legislature, I would suggest, might want to consider, and I discussed this at our planning meeting back in early February, establishing pilot programs for funding for investigative purposes for law enforcement to deal specifically with the issue of non-attorney UPL, to encourage local prosecutors to take it seriously and, in fact, to take action. Now, in the original draft protocol that was presented to our board on April 26th, I believe it was, when we were in Sacramento, there was a concern about language that talked about confidentiality. And I raised the question about why would there be any confidentiality in non-attorney UPL cases, because they're not members of the bar. And the Business and Professions Code that specifically talks about referring cases confidentially to law enforcement specifically mentions member. Whenever a member investigation gives rise to concern that somebody might have violated the law, then it would be confidential. But for non-attorneys, there is no confidentiality. There is a difficult or a problem, and it's something else that I think we're going to have to work with prospectively for our July meeting, in addition to finalizing the draft protocol, is to amend Rule 2302, which also references confidentiality, even though it's for non-attorneys. And so I think that we need to look at that rule and perhaps simultaneously send out for public comment the amendment to the rule and the proposed draft protocol. Now, there is a specific issue relative to immigration and non-attorney UPL involving immigration cases and confidentiality, perhaps, of complaining witnesses who may not be legal residents of California or the United States. And we do not want to put those people in jeopardy by, quote, outing them for disclosure that they are undocumented. And so I think that there are ways that we would be able to protect the confidentiality and the identity of the complaining witnesses. However, there may very well be a good public policy and public protection reason for disclosing the identity of the non-attorney people practicing law, because they will continue to victimize other people. So that is prospectively where we are going. I've been in discussions with Vanessa, and I think we're pretty much on the same page relative to the issue of the confidentiality and the fact that the Public Records Act provisions that investigations may be confidential, they don't have to be. So I think that we are making progress. I think that the referral to law enforcement may have had independent complaints that they had received that we're unaware of, and they might not be aware of what we are. So by notifying law enforcement, it places the information where it rightfully belongs, which is with the local prosecutors. And Jason, do you have anything to add to it?
Only briefly, and big thanks to Greg for being so responsive. I think it is, Jim and I are absolutely agree that it's key to get UPL complaints to the agency that has the broadest jurisdiction so that they can make a determination whether or not there should be prosecution. I think part of the issue is that when, in prior instances where there were investigations of UPL, the time starts ticking essentially when the complaint is made or when the allegation of the misconduct occurred. And the statute of limitations for misdemeanor is only 1 year. So we need to make sure that the criminal authorities are in the best possible position to not only fully investigate the case and prosecute. And I think this proposal, when we work out the details of it, puts us in a good position. It puts the criminal authorities in the best position to pursue these cases. Maria mentioned the other end of what we're attempting to accomplish, which is to figure out what happened with historic practices in the process of the UPL, something that you raised. That, if it is truly every single complaint gets a number, then how is it that cases were lost or not sort of tracked? So Jim and I are also going to get some more additional information about that too, and we'll report to RAD on that issue too. So it's an open question, but we'll work through it.
A couple of things. First, I think this is excellent that we are adopting hopefully a protocol so that the situations we've had in the past will not be repeated in the future. And I compliment Greg and everybody else who's been working on this. It's my understanding, and maybe Jim, you're the person to respond to this, it's my understanding that additional problem that we have on the investigatory end is that we don't have all the subpoena powers that we need to adequately investigate these cases, and that there may be a need to ask the legislature for some more authority in that area so that we can assist law enforcement to the maximum extent in investigating these cases for them. You're nodding your head affirmatively, is that accurate?
That's correct. We don't have the ability to issue subpoenas in cases involving non-attorneys. We can subpoena bank records and trust account records of attorneys, but not of non-attorneys, because we don't have a relationship with non-attorneys.
It's my hope, and this is Dave Pasternak, it's my hope that that's authority that we will ask the legislature for, and based upon the interest that many of them have expressed in these UPL cases, I hope that they will be agreeable to giving us that authority and somehow or other funding, perhaps in a manner that Jim suggested, to be able to assist law enforcement in investigating these cases so that to the extent that they are warranted, law enforcement can prosecute them. I just have one other comment for Greg. I'm assuming at some point in the future this protocol or something very similar to it will be adopted, and I hope that you and Doug in the future, after it is adopted, will be getting the board members each month in the packet that you put together, Doug, on the processing of discipline cases. And I know you include some information now in UPL cases, but that you will include information in the future on the timeliness of the handling of those UPL cases with an explanation of any that go beyond the time limits that are specified as to why it's taking longer to process any of them.
So I think all of these comments are very helpful, and Greg and Jim and Jason will all be coming back to us at the July meeting with a final policy directive for us to approve and move on to the board with an assessment, sort of the results of the investigation, so to speak, that Jim and Jason are doing about what happened and what does that say in terms of anything further, any other voids we need to fix. And I think we've heard the suggestion as well that they'll also be presenting to us any legislative proposals, because July would really be our moment to think about that, if that's anything that we want to be trying to move this year in some manner. I see Jeanette's hand. Let me just raise one or two other things in that list. I think we've now identified for you, Greg, and Jason and Jim, for the two of you as well, a number of different areas to be thinking about and looking at. The other two that I just want to add is to be thinking about in the policy directive, the question of whether an immediate referral by intake makes more sense than waiting for it to move on to the enforcement unit. I'm not sure the pros and cons of that, but it seems to me there might be some benefit of an immediate contemporaneous referral by intake. So if the thinking is not to do that, I know at least I would want some understanding of why not to do that.
Just one comment on that.
Okay.
The reason that you might want the referral to go from enforcement is that at that point in time, you will know the attorney who is overseeing the investigation and who will be with the investigation until the matter ends. Mm-hmm. And so you will, if you are receiving it, you will be able to contact the attorney who is still involved, because if the referral goes out of intake, the attorney who sends it from intake will not be with it as it's investigated.
So I guess maybe just think about, is there a different way to satisfy that objective? That's a very good point. You want the right person to be the point of contact for law enforcement, but is there a different way? Could there be an immediate referral, and then the minute somebody in enforcement is assigned, they reach out and say, hey, I'm the person to be back in touch with? So I'm just sort of looking for a way to maybe speed it up a little bit and not have the clock on the 1-year statute tick. I guess and maybe the answer is no, it's better to wait, but we'll only be waiting a very short period of time. But I just think it's worth thinking about that. And then the other issue in terms of the policy is there are multiple law enforcement agencies. Saying refer to law enforcement doesn't really say to whom are we referring. City attorney, district attorney, attorney general, county counsel, that may not be the right answer, etc. So I think we need to tease out a little bit more. To whom are these going to be referred, and what does the protocol say about knowing to whom? If it's going to be a multiple referral, we need to do it in a way that doesn't cause confusion among different enforcement entities, because if you refer it out to 12 different agencies, they're all going to be running around with their heads chopped off. So I'd just like to see a little bit more analysis on that. And then I think going back to Danny's question, and this is probably a combined question for Jason and Jim and Greg, I think we need a little bit more of an explanation around the case tracking mechanisms. And I understand that intake starts a tracking process, but maybe a little bit more of a description of what tracking process, and what if something doesn't get logged in before it's officially with intake? If it comes in and it sits in a drawer, how do we ensure that the tracking process starts? So that may be a combination of the work you're both doing, but I think we need to understand a little bit more of that tracking process that will then be coupled with David's good point of, and then we need to on a monthly basis, or whenever RAD meets, be doing more to stay on top of that, the tracking that is. So, Jeanette.
So 2 comments. One comment, Miriam, is on the latter part of what you just said. I could see, Greg, your difficulty in putting down which law enforcement agency, because in Los Angeles alone, you're not going to know, because the city attorney handles the city of Los Angeles, and depending where there's an independent prosecutorial agency, the LADA will pick up where there isn't one. So in Redondo Beach, they may handle he's not going to know that. So I don't have a difficulty with what you have here, because I think it would be very difficult for them to determine who it's going to be. That's a big step. So I see where you're coming from, but the gist of this is okay with me. The one thing that I would comment on is the part where the UPL violations, you make a determination that they're not UPL cases. And so I'm referring to page 4 of 6, where intake says the complaint isn't sufficient, and then you go on to say there's a reconsideration. The complaining witness can have that determination reconsidered. Who does that complaining witness go to? Where does that go? And I think that needs to be in here, since this is going to be a public document. Does it go to OCTC? Who does it go to? And what's the timeline for that? Because if somebody then makes a determination, oops, that is a UPL case, then it goes back to your timeline. Additionally, does it keep the initial number that it was given? Because that's another way that we get into Denny's comment about where did that go. So that tracking mechanism needs to be done. So I would incorporate something like that in there to give us sort of a complete picture of what happens to both the cases that we proceed on and the cases that we don't proceed on.
One further point, and perhaps for the benefit, this is Dennis Myers, of the new members. It was the previous executive director who went to the legislature and created a level of expectation with regard to the bar's role. And in my personal opinion, inflated the magnitude of the problem. Probably anticipatory rather than contemporaneous, but nonetheless created that, which led to 2 abortive attempts to give the state bar additional statutory authority for prosecution of these UPL cases, and the Gonzalez bill that set up another layer of expectation for the bar. So it's not out of line for the legislature oversight body to say how many of these cases coming in here for UPL actually relate in any way to immigration. And when we've asked these questions before, especially about the lost cases, we don't get a definitive answer. So my suggestion is that given the inordinate now attention that we brought upon ourselves in this regard, it would be a really good idea to track specifically, case management system or not, which are immigration related. So that we have an honest response when an oversight person says, is there a wave of these things coming in? Recall also, for our benefit of our new members, to be really responsive, we spent hundreds of thousands of dollars on Spanish and other language radio and other ads to try to convince people to bring cases of the unauthorized practice of law, especially as it related to notarial fraud, to our attention, and found that it was useless, as were the town meetings, which ended up being mostly filled with people, victims of senior fraud, as opposed to immigration fraud, because the affected parties are too frightened to come forward, as Jim pointed out in the past, for fear of deportation and so forth and so on. So my strongest advice is to make sure that you know right from the get-go in this tracking system, and that we can be more responsive about to what degree are these immigration-related cases. It should be a no-brainer, but we still don't get that data. And Dag, wherever you are, that should be another synergistic mission. It doesn't sound like it would be all that difficult to me, but every time I've asked this question before, it was, well, in the absence of a case management system, we can't really give you that kind of data. Well, that's just crap.
So I hear your comments, and I'll be prepared by July to have been in the weeds and to be able to give you answers. I'm not saying it necessarily obtains here, but a thing that people should know in general is the system that we have does have a lot of limitations, and so we track various things, and some of them you have to track manually. And if you can't track them in your case management system, the validity of your tracking, is always going to be subject to question. But I definitely understand the importance of this, and I'll work through it by the next meeting.
I didn't understand that sentence.
Okay. Some of the things that one might want out of a case management system, you can't get out of the one that we have now. And so, if you want to track them at all, one has to track them manually. And when you have to track them manually, they're very subject to human error. That's the problem.
So what you're saying is, I can tell you that this is a UPL case, right? Because you have to know this is a UPL case because you're about to refer it to somebody else as opposed to putting it in your own system.
I can tell you it's a non-attorney case, yes.
Good. And then why is it that if you can come to that understanding, why is it you can't take the one next step and find out if it has anything to do with an immigration case?
So I'm going to see if our system can do it. I'm not saying that it can't. I'm just saying there are lots of things that we track in OCTC that the system doesn't help us track, and we have to track them manually. That's all I'm saying.
I would find a way to solve that one if I were you.
So I'm not going to be able to program the system, I can assure you of that, but I'll look at the best way to solve the problem.
So I'm sort of hearing that maybe getting DAG involved in thinking about some of these metric issues and data issues with you, Greg, might be useful. I mean, obviously you can't create miracles. You can keep trying, but I do think it would be good to gain an understanding of what can we do with what we currently have. And one thought, I think, Jason, you had your hand up and Terry had his hand up as well. But the other thing I'd invite, the three of you, Greg, you, Jason, and Jim, to think about is if there are aspects of both what we've learned looking backwards and what we're trying to achieve looking forwards. And I think, by the way, that at the end of this, we will be in a much better place, process-wise, accountability-wise, on all fronts in regard to how we handle these cases, including probably in a better place if we can get some legislative fixes and more resources for how the public is protected from this kind of misconduct. Not simply how do we do our business, but obviously ultimately how is our business impacting the public. But if you all conclude that you're camera ready by the end of June, we do have a meeting then to discuss the Rules Revision Commission, and I'm not suggesting that we take time away from what will obviously be a massive discussion and item in its own right. But if there are things we should talk about and start to think about in terms of any more immediate legislative fixes, it might not be a bad idea to try to have a little bit of time at that meeting to be able to do that. So just think about that. Dave will give us 5 minutes. No, I mean, I think we can probably, even if need be, have that day go a little bit longer. It would be better for us to do it in June than July. So we got Jason and then Terry.
It's Jason Lee. Just in terms of framing the historic look back and the recommendations that are going to come from that, once we identify what went wrong, what is the expectation of the new case management system coming online?
I'm going to answer that because I don't think that's not a fair question for Greg. So the expectation for a new case management system is that it's going to address many of the concerns, but not all, particularly not right away. And part of that, we'll be coming to the board in July with a recommendation on which path to pursue on CMS. We have two different, very different options in terms of the bids that have been presented, and we're still in the process of vetting them. So in either event, we'll get a very configurable system, if not a fully customizable system. And so it will address many issues, but I don't think it will address all. At some level, and this is part of what Dag was talking about, at some level you have to understand that your case management system is to help you get your work done and get it done efficiently, and that's a little bit different than making sure that you're able to collect data for sort of analysis and reporting purposes. And so we are going to have to build some bridges off the CMS to get us everything that we need. So it's not the panacea. It'll be better than what we have. But one of the things that even since Dag has been here that I've learned is that the AS400 is a lot more robust of a system than maybe many of us have thought that it was. But it does take a lot of human,
That's a nice way of putting it.
Human intervention to get out from it what you want. But it does have some capacity and capability. So I think it would be a mistake to think CMS is going to solve all of it.
Okay, so in July, we're going to get a
You're going to get a recommendation
and deployment after.
Much later. It's going to be a pretty significant deployment schedule based on, in part, on the direction that the board decides to take.
Got it. Yeah. So to address like Denny's question about identifying certain types of cases, this is something that we're just going to have to be dealing with in our current system for at least the short to medium term.
Right, and I wanted to just follow up on Miriam's comment. DAG is now supervising. Previously, we have two data analysts in OCTC that were managed up through the OCTC structure. They've moved to now report to DAG. And he is, unfortunately, in the month that he's been here, been doing nothing but working on other reports. But as soon as he comes up to brief next week, he will transition. So he understands that this is a huge priority, and to work with the data analysts and figure out, he knows that we need to start reporting on this and understanding the data that we have. So I think we will be able to do something with our current system better, perhaps a bit more enhanced level than we think we can right now. I'm fairly confident that we will.
On that point, Liam, just with respect to the UPL cases, given everything,
right?
Is there some thought to, with the adoption of whatever we will deal with respect to the case management system in July, taking that area and making sure that Denny's concerns, as well as all of our concerns about tracking those cases, given the fact that the legislature is looking at them and they are important to public protection, to doing something with just those cases, or putting somebody there to look at them and incorporating them in that system so that we don't lose them.
Yes.
And I understand the fact that we've got limitations.
So any system we get is going to allow us to track cases by any kind of case type that we choose, case type designation. There is an element that you're not going to avoid, sort of a human element. As long as we continue to allow the receipt of written complaints. So the new system will have sort of an e-filing interface, so you can file your complaint electronically. But we're never going to preclude people from also submitting a complaint in writing, for example. You always have a human element in that written complaint coming in and then needing to set it up into the system and then having it need to go somewhere. So it's not all a system solution, right? There is a management solution and a number of other solutions. But yes, the CMS will be tracking that case type, and we can, I understand that that's a priority.
I've got a couple of questions for Greg. And one is just for my own information. So when a UPL case comes in, the case is, there's intake, and the case is coded, and the case is assigned to an attorney or an investigator.
The case at intake is not assigned to an investigator. At intake, it's reviewed, and a decision is made whether there's something to pursue, and then at that point, it would be forwarded to enforcement. And in enforcement, there would be an attorney assigned and an investigator as well.
And when it's referred to enforcement, can it go to any attorney, or how is it determined who that case goes to?
So specifically for the non-attorney UPL cases,
Yes.
those, I mean, as of now, we have, organized into a group, attorneys who are specifically dealing with the non-attorney UPL cases that are coming in. And it goes without saying that having the ability or having fluency in Spanish is valuable, and so we have personnel in the unit who speak Spanish.
And I guess what I'm leading to is one of my suggestions, because as you know, there's four prosecutors, and you can probably go to any prosecution office, and prosecutors' offices have units. So we have domestic violence units, and these attorneys only handle domestic violence cases. We have a gang unit, they only handle gang cases, or human trafficking, or any number of different specialty areas. And I think one of the reasons many prosecutors' offices do that is because you develop a level of expertise handling domestic violence cases or gang cases. So one of my suggestions would be, and I mean, I'm glad to hear that you have a unit of attorneys that are handling the UPL cases, but at some point, if they're assigned to a unit, one, you're able to track the cases much easier if they're assigned to a limited number of attorneys. And I think, two, those attorneys also develop a level of expertise handling those particular cases, and you find a lot more effective, I don't want to say prosecution of the cases, but a lot more effective handling of the cases when you have a limited number of attorneys touching those cases and dealing with them. So I don't know if I'm glad you thought about it, but I don't know how permanent those attorneys are when it comes to them handling those cases.
That's the plan, going, that is in place now, and that's the plan going forward. And as far as my planning, I have no plans to undo that at any point in time, certainly not in the near future.
So from this point going forward, you have a UPL unit.
So in Los Angeles, we actually have people in intake who are dealing with non-attorney UPL complaints, and then people in enforcement. And we have a bigger mass of people in Los Angeles, and for the non-attorney UPL complaints, we have many more in Los Angeles than we do in Northern California. But even in Northern California, we're trying to do as you suggest, which is concentrate the cases with particular people so that they are conversant and they develop expertise. And not only that, but that they establish relationships with community organizations,
right,
from whom sometimes the complaints.
And I think that's the other thing that flows from that. If you're going to be referring them to law enforcement agencies, they establish relationships with those law enforcement agencies, and it just makes for a more cohesive relationship and I think better handling of cases.
Right, I agree with you 100%. And in addition, there are community organizations that where immigrants go for help, and where people speak their language and things like that. And you can also form relationships with those types of organizations and make all of that information flow a lot better and a lot more efficient. I agree with you. Okay.
Madam Chair, I have one last comment on the subject to make. I want to make sure we understand how this oversight thing works. RAD is your oversight. I'm the Senate's public non-attorney appointee to this body. Today, there is a newspaper article that will be read by the Senate, if it hasn't already, in which I am directly quoted as the former chair of RAD as saying all UPL cases that come before the state bar are being vigorously pursued and prosecuted. That was on the basis of a draft letter I received from staff, and as I walked through it, as I always do carefully, that question specifically was answered affirmatively. All UPL cases are being appropriately tracked and referred. I then signed that letter. on behalf of this body. So if I sound a little neurotically compulsive about wanting to make sure that members of RAD, especially its chair and vice chair, get accurate information, is because of that article today, on which I'm on record as assuring the public that they're being protected, when in fact, many, many, many cases were lost somehow in our system. So that's unacceptable. And it could have been any one of us around here who, upon the assurance of staff, sent out a letter like that reassuring the people that they were being properly protected. That's just unacceptable. It's got to change. So you're new. It's not fair to really pile on you except to say you're stipulating it's going to change. And it really has to.
I understand the importance of the responsibility. I absolutely do.
So are there any more questions on this? And again, I would encourage all of you to think about whether June would be more timely to come back on this as opposed to waiting to July, or do we want to wait until July? So I'll look to guidance from the three of you. I think everybody is trying to make sure that moving forward we get this right, and that is why I appreciate the good work, Greg, that you're doing. But I know all of us also appreciate Jim and Jason, what the two of you are doing to try to enlighten us by looking backwards as well as looking forward. So thanks to all of you. Unless there are any other questions, that now moves us to item 3C, and that is going to be our dynamic duo of Vanessa and Leah. This is now moving on to Rule 2201.
Okay, this is actually one piece, just one small piece of that, then we'll move into the rule revision that Mark Torres-Gill will address. Rule 2201 is the State Bar Rule of Procedure, which addresses the situation where the Chief Trial Counsel has a conflict and must recuse herself in complaints that are filed with the Chief Trial Counsel's office. And when those conditions are satisfied, the matters must be sent out to Special Deputy Trial Counsel. And there has been some difficulty both in retaining Special Deputy Trial Counsel because they have been and are currently, for the most part, not compensated. And we want highly qualified individuals who then will also have busy lives and usually practices. And even when we are lucky enough to get those people, we sometimes have trouble retaining them if a case goes on very long. So the current Rule 2201, which was posted and many of the RAD members have copies of, has a section D which says that a Special Deputy Trial Counsel shall not receive compensation for services unless the Chief Trial Counsel has contracted in advance with that Special Deputy Trial Counsel to receive compensation. So you may be wondering, why am I asking the question whether we can compensate if there is a provision there? Well, the answer is that there are two sides of the house, if you will. There are A cases of a certain type of recusal, and there are I cases. So I just want to run my recommendation through RAD. We had some preliminary conversation, and there was some unclarity in the sentiment about the interpretation, whether we can in fact compensate Special Deputy Trial Counsel assigned on the I side of the cases. And the reason for that is that Section D is, one might argue that Section D is under I, and therefore it may not be applicable except to the A cases. And it refers to the contracting authority of the Chief Trial Counsel, who must recuse herself in Section I cases. What I recommend an interpretation, until we have a chance over the next few months to revise and make clear Rule 2201 as to compensation, among other things, is that we do support the compensation of all Special Deputy Trial Counsels under the theory that in the Section I cases, the RAD chair steps into the shoes of the Chief Trial Counsel. The Special Deputy Trial Counsel step into the shoes of the Chief Trial Counsel. And the rule isn't perfectly drafted, but when we do construction of laws and rules,
we do look at whether they make some sense. And in this case, there is no good policy reason not to be able to compensate the special trial counsel in A cases, but not I cases. There's no distinguishing factor. And it will probably take at least until September before we can send out to public comment and adopt a new rule. And in the meantime, we don't want these cases to lag because they are as important as the cases that stay within OCTC. So my advice, I don't know how you want to take it, my advice to RAD is that we take the position that under Rule 22.1 as it currently exists, subject to being clarified by a new rule, we can compensate special deputy trial counsel. The second question would be at what rate, and whether you want to just leave that to Leah and me to determine. We have been paying some on the A side at least, and we've come up with a number. It kind of depends on whether the case is going to just be at the simple preliminary review or it's going to go to trial. And sometimes that requires a higher level of capability and payment at greater rates.
I have a question. It strikes me that A, we ought to support this, B, it ought to be within your discretion, but it does raise a question about the budgetary implications, which I assume you considered.
Yes.
And have some sense of how you pay for it under these circumstances, if this were to change now, going forward?
Yeah. Lee, you want me to tell her?
Yeah, I do believe that these Leah Wilson. I do believe that these expenses should be budgeted in OCTC. And we've established a preliminary sort of estimated budget. This is the first time we're doing it, so we have to be somewhat flexible. So that's how, I would propose that it's set up. It's essentially conflict counsel and budgeted in OCTC, but not managed by OCTC.
So if we left it to your discretion based on the complexity of the case, the type of counsel you were to retain, what would the board, from a fiduciary standpoint, what would you expect to do? Set a cap to understand what that budget allocation is? What's the thinking of the executive team?
Well, I think the request would be that we are, I know the rule change is going out. We'll be able to come back when we do the mid-year budget adjustment with at least a modest amount of actual information, because we have started paying some attorneys, and based on that pretty small sample size, we could include in our budget amendment for 2016 an actual budget for the board to approve for this fee, and then we incorporate it into the annual budget cycle. And as we build a history of actuals, we'll become more and more accurate with it. That would be my recommendation.
We have projected an amount that we think will cover at least the number of cases that we see through the end of this year. And I think hope we'll stay well within that. Let me clarify, just so the RAD knows what expenses are involved. It isn't just the hourly rates, which are going to be modest or as best as we can negotiate. It's also other expenses. If it goes to trial, for example, in a big, complicated case, you have to be able to pay for subpoenas, process servers, witness fees, those kinds of things.
So with that in mind, Vanessa, and I agree with Danny that this is a great proposal. People should be paid for what they do, because we all know that you get what you pay for. So with that in mind, the one thing that I would like to see, if in fact lawyers are paid for doing these cases, is that there has to be in place managing those expenses, that people are not taking advantage. And I can only say to you to look at what occurred in LA County in the 80s and 90s with bar panel lawyers who were paid, and there was a rate, and then we found out that lawyers weren't doing the work that they were doing, and there was a huge controversy. I wouldn't want that to come back to the bar. So while we're doing that, we need to put in place a system where someone is looking at those expenses critically and making sure that if the lawyer says, I've got to travel to New Mexico to make sure that this is done, that he doesn't take his family with him or her family with him, and in fact that is what's being done. And additionally, if we're going to work 15 to 20 hours on a case, you need to establish what you did on that case. So with that in mind, I just wanted to make those comments so that we're not back here looking at a newspaper article 10 years from now saying, oh my God, look what happened. So we considered all of this.
So if I may respond, Section F of the rule says that an SDTC may request that the chief trial counsel or designee authorize the payment of reasonable expenses for investigative, administrative, and legal support. The way that is happening in practice, at least on the ones that I'm overseeing, is I require that they get approval in advance, that we then have to approve the expenses submitted. No first class on the train, you got to, unless there's a good reason for it, they're all very carefully managed, and the number of hours they spend in the task, and a check-in regularly to make sure that those hours are reasonably related to the task that has to be done.
And you have a formal policy for that, because I think it needs to be in writing and there needs to be a policy for it. I know what you do, but it just needs to be a policy.
Well, one of the things we already do is we say you must conform to the State Bar travel policy on travel. So that's already out.
That may be, that part of it might benefit from the audit committee perhaps giving a look at some proposed policies and oversight practices.
Do we need a motion in this regard, Madam Chair?
Well, so I think there are two parts of this. I don't think we've yet, have we gotten to a full discussion of the next agenda item?
No,
and
we
that
haven't
okay. So that, we're blending these a little bit together. What Vanessa has told us in essence is for the current cases where her interpretation is that there is discussion even before the rule is changed, given her legal interpretation to be providing compensation, that that's her legal advice to us, and I don't think we need action on that. I think that it's the prerogative of our general counsel to make a decision unless anybody disagrees with her determination in that regard. I think she's gonna continue moving forward and acting consistently with her legal advice. I think for this next item, we probably want to get to the presentation on it, and then we will move on. So
Correct.
I'm going to transition to that, unless there are any other questions on agenda item C. I think we're now moving into D.
And for D, which has to do with the proposed new Rule 2201, Mark Torres-Gill from the Office of General Counsel will present that.
Good afternoon, everyone. General Counsel. And, this next item proposes amendments to Rule 2201 of the Rules of Procedure. And this particular rule, Rule 2201, I think you've already gotten some sort of pre-education on what that rule is supposed to do. Rule 2201 sets forth a procedure for finding outside counsel and in conflict cases, and it effectively in that situation when special deputy trial counsel are selected, the special deputy trial counsel. Thank you, Richard. All right. In 2201 cases, when a special deputy trial counsel is selected by the chief trial counsel, or it's referred out to the special deputy trial counsel, that special deputy trial counsel stands in the shoes of the chief trial counsel. Traditionally, these special deputy trial counsel, as Vanessa has pointed out already, have been volunteers. They've operated pro bono, and in that particular scenario, that has presented its own challenges. We have looked at Rule 2201 and are proposing certain amendments to the rule that we hope will improve the operational quality and efficiency of these cases and improve oversight of these cases, and hopefully with the proposed amendments enhance the public confidence in how these particular cases are handled. This rule amendments, we asked that the RAD approve these amendments for a 45-day circulation for a 45-day public comment period. What I'd like to do is perhaps explain just very briefly how the rule operates now and how the rule would operate under the proposed amendments. I'll try not to take much of your time. I know it's getting sort of late in the day. But very briefly, the way current Rule 2201 is structured, it's essentially a bifurcated process. There's a process for situations when it's a permissive recusal. Those kinds of cases are called 2201 case A, Section A cases. And then there's a process for those situations that require recusals, mandatory recusals, what we refer to as 2201I cases. In the permissive recusal area, that is the permissive recusal, the way that system presently works is that if an inquiry or complaint comes into the office of the Chief Trial Counsel and it falls within the umbrella, under the umbrella of the 2201 types of cases, the Chief Trial Counsel will conduct a preliminary evaluation of that case. And then the Chief Trial Counsel will decide for himself whether to close the case, retain the case, or refer that complaint out to a special deputy trial counsel. So that's how, very briefly, how those sort of Section A permissive recusals work. Under the subsection I, the mandatory recusals, the way that works under the present rule is that if a case comes in that requires mandatory recusal, for example, the complaint it makes an allegation against Greg Dresser as Chief Trial Counsel that would require mandatory recusal, it is not evaluated preliminarily by the Chief Trial Counsel. Under the rule, it is those types of cases are referred directly to the chairperson of RAD and or her designee, and then the chairperson or the designee sends the case out refers it out to a special deputy trial counsel, who then conducts the preliminary evaluation of that case. In the past, the person who received those Section I cases was Bob Hawley, and he would be responsible for those types of cases and referring them out. And presently, that particular responsibility in the I cases has now fallen to the Office of General Counsel, and particularly Vanessa, for referral out. Under the that's how those the I cases, we have a sort of dual working system, and what we have contemplated under these new rules are again a system and a more efficient system that we hope it allows a more effective, I think, operation or oversight over these types of cases, which we believe these types of cases deserve. And what I'd like to do is perhaps highlight some of the fundamental or more substantial changes in the rule. The first fundamental change in the rule is to increase the number of situations where a mandatory recusal is required. Essentially what we've done is those circumstances that in the past, current rule, permitted permissive recusal are now sort of mandated recusal items. So effectively what we've done is we've merged the subsection A situations into subsection I, so there's no distinction between either one, and we feel that so merging, expanding those mandatory recusal situations, I think will focus the public confidence and the impartiality and the unbiased nature of how we want to work. So that's one particular highlight. The next item change I'd like to highlight is that the amended rule creates a new role of a special deputy trial counsel administrator, somebody who's not a State Farm employee who will operate at arm's length. And the purpose of the administrator is to essentially operate as the quality control person to make sure that these referrals are being monitor the progress of these cases, and to be on and to make sure that everything's moving along as it should. In addition to that, the special deputy trial counsel administrator would be responsible for the preliminary evaluation of any case that is referred out to the chief trial counsel accuses himself from. So any case first goes to that person. He or she will conduct a preliminary evaluation and decide at that point whether or not the case should be closed or should be referred out to a special deputy trial counsel for investigation or for possible prosecution, whatever is appropriate. And again, I'd like to emphasize that under the proposed amendments to 2201, the obligations and responsibilities of the special deputy trial counsel don't change. Those stay the same. So with respect to the administrator, again, that person's job is to oversee the system, oversee the referrals, make sure the trains run on time. The second substantial change I'd like to highlight is in the area of second look reviews. In a typical disciplinary matter, when an inquiry or complaint comes into the office of the chief trial counsel, and those cases are either moved on to enforcement or investigation, or they're closed in investigations and don't move on to prosecution. Those types of cases, the complainants, when the case is closed, are informed that they may seek second look review. In other words, they can seek a further review of the decision determination to close their particular complaint. It's a very important public protection measure that has proven effective. And that particular job is done by the Office of Chief Trial Counsel's Audit and Review Unit. And that's their sole function. One of two functions is to review requests to review requests to review determinations to close complaints. In these 2201 cases, those complainants whose cases are closed have not been informed that they are entitled to second look review. So consequently, when in those particular cases, closed cases, 2201 cases, have not been subject to Rule 2201 to second look review. The proposed amendment changes that and requires that any case that is closed by the Special Deputy Trial Counsel Administrator or by a Special Deputy Trial Counsel who has referred a case will be subject to second look review. Again, a very important item. And I think the last fundamental change, substantial change I'd like to highlight for the committee is in the transition from, that Vanessa's already touched on, the transition from a volunteer pro bono model to a compensatory compensation model. That we, Greg mentioned it before, but when you get volunteer, when you're asking for volunteers to do these types of cases, sometimes it's hard not only to find people who are willing to spend the time to do these types of cases, but also finding people who have knowledge, the requisite knowledge to handle these types of very particularized and specialty types of cases. And it's hard to find a stable panel of people who are willing to do that, to do this kind of work. And so we're hoping that by allowing reasonable compensation for services as well as reimbursement of expenses, that we will be able to find more individuals who are willing to do this kind of work and improve accountabilities and improve quality. So there are other changes that have been made to the rule, particularly in terms of structure, in terms of refinement, but again, I'm giving you some of the highlights. And again, we're asking that Brad approve circulation of these proposed amendments for contrary, and I'm happy to answer any questions you may have. Yes.
So my question is this. I'm confused. I'm sorry. I'm a little confused.
Identify yourself.
Oh, I'm sorry. Thank you. Danette Myers. My question is, so we find out that there's a 2201 case, whether it be A or I, and there's a recusal. In the new proposal, it seems it goes to the administrator first, but I thought what happened is once there's a recusal, then the chair of RAD determines that outside counsel needs to be appointed. But in the new revision, it appears that that would go to the administrator, and then the administrator makes a determination as to whether or not it should go to a special counsel, and at which point then the chair of RAD would make the decision as to who that would be. Is that? Because in reading this, it's a little confusing. I've read the red line, and it's a little confusing. So could you clarify how that's working?
Yes, the way the proposed amendment contemplates the referral process would be that if a matter is subject to 2201 referral, if, again, under the proposed amendment, those cases would automatically be sent to the special deputy trial counsel administrator for preliminary evaluation. It would be the administrator's job to then decide whether to close that case or to refer it on. And the administrator would be the person who would select the special deputy trial counsel. The chairperson of RAD would not, as in the past, the chairperson of RAD would, has not traditionally been the person to select a special deputy trial counsel. It was delegated to staff, so the chairperson of RAD would not be involved in that selection process. Of course, RAD and the chairperson would still have specific responsibilities in this area. One, there are reporting requirements in the new rule that require that at least twice a year, the Office of General Counsel and/or the administrator approve or be given reports on how the cases are progressing. And also, the chairperson of RAD would have the authority to terminate the administrator or any special deputy trial counsel for a good cause. So those particular authorities are embedded in the rule. Does that answer your question, Ms. Myers?
That does, thank you.
Can I, maybe to you and Vanessa, and then I saw Terry and I saw David. We got some advice from Vanessa in regard to some conflict issues in relation to some closed matters, but I think it raises a question in regard to the proposed amendments to G that I'm wondering whether this might need some further thought, because in terms of the conflict issues, if there are cases that have gone to the special counsel based on board members and so on, I think we had decided that maybe we need a little bit more thought as to what should be reported back to RAD, and that could necessitate some changing in the language of G. And the other question I'm wondering is, in terms of the ability of the RAD chair to terminate the administrator, again, are there any conflict concerns? If, let's assume there were a RAD chair that had a huge number of complaints against that individual, and by virtue of that, the administrator was the traffic cop on a lot of those cases, is there any concern about a conflict that would result in a scenario where the RAD chair is terminating an administrator, knowing that that administrator is overseeing a lot of complaints against him?
So as to the first question, you mentioned G. We labored over the language, and particularly to address that question. And so we came up with the last sentence, at the end of the last sentence, that maintains a necessary impartiality and confidentiality. As to the second, and it probably isn't even necessary, but we put it in. As to the second question, it's more of an overarching one. You can't build into every rule provisos regarding laws of conflict or fiduciary duties or rules of professional conduct. They just have to apply, and then on any rule we have that's the case, we have to figure ways around that. So I don't think this has to be held up pending our plumbing the depths of the issue of the conflict that I'll bring back, the conflict issues that I'll bring back. Because as it is, this won't go in, the earliest this would go out would be adopted would be September. But I think any rule we have is always subject to conflict rules and fiduciary duty rules. So you don't have to build it into every rule of the bar. You just have to abide by them and work around whatever rule you have when that approaches.
Would it be helpful in G, thank you, Vanessa, I appreciate it. Would it be helpful in G, in that last clause, to say in a manner that addresses any applicable conflict concerns and maintains the necessary, et cetera?
Well, impartiality, conflict is ultimately an impartiality issue. We use a more general term. There might be various issues that impartiality would raise.
I know, Danette, that you raised that issue. I mean, are you comfortable with that language?
I'd like to actually, right now I am, just in reviewing because it's so much.
And it is simply going out for comment.
It's going out for comment,
Yeah.
but I'd like to see the final product when we get it.
Yeah, we obviously will, and it'll come back to us with comments and recommendations.
You know, if we do get comments, and substantial comments, then we have to, of course, recirculate again. So,
And we can think through a little more the conflicts issue.
Yeah. For you all to suggest to us, even if it doesn't get flagged during the conflict period, does that suggest any changes that we want to see? So Terry, and then David, you were after that.
Yes, mine's brief. Just the administrator. And I think it goes without saying. It's
Do you have your mic on?
Oh, there we go. My question goes to the administrator. And I assume it goes without saying that it will be someone who's got, I guess, civil litigation experience and things of that nature. But is this a person that you anticipate being in the Los Angeles area or San Francisco? And does this administrator run all the cases for the whole state, all the conflicts for the whole state? Or just how do you have that thought through?
yeah, no, I don't think we've sort of dug deep down into the issue of where this particular person may or may not be. We've actually talked to a few people who would maybe fit that role, and one in Southern California, I believe. But where that person may or may not reside is, I think, still sort of an open question. And in terms of your first point, yes, I think the administrator would have to be somebody who has significant some expertise and some knowledge in this particular area, and certainly litigation experience, because there'll be other litigators and individuals involved in professional cases.
And do we anticipate it being someone that's a current law practice and is also handling their own law practice?
Yeah, I don't think that the numbers in these cases aren't enormous. It's not we're not talking about a full-time job.
Right. Okay.
So, and again, the reasonable compensation for their services, we're not, intending to pay market rates by any stretch. We're not intending to make somebody rich, I believe. But we are, I don't think that the administrator is contemplated as having to leave the particular job that they have. On the other hand, the job that they're being asked to do, they're going to have to do well and go to the company and take it seriously.
Okay.
Terry, just to clarify, this isn't by any means a full-time position. It's an hourly, casual, if you will, job as administrator. It just removes it from the bar one step to increase the objectivity. And I don't think it matters where the administrator is. What we will be doing, and we kind of have already in terms of our repertoire of SDTCs, is we are using people from multiple geographic areas, especially if something's going to go to trial. It'll have to be up here or in LA. We are trying to find people, for example, we have several DAs. We have several ethicists, people who are active. Right now, San Diego seems to be having a lot of good people who have great ethics background, and they're willing to donate their time so far. So that we have a panoply, but they clearly have to be active members of the bar. They have to be experienced and learn, and we will also do training, rules of professional conduct, State Bar Act, all the ethics rules. The panel administrator, and we will closely watch that in OGC and OCTC, the panel administrator would be able to decide, well, here's sort of a person who's new at it, so let's just give them one we think isn't going to go very far. But then if another one looks like it's going to go to trial, they would give it to a more experienced person. And so all the details of the selection of the panel, the training of them, the amount of compensation, the Walker letters, the whole part that mirrors OCTC, you don't have to put all those details in the rule. That would be in the implementation of it. And OGC will play a role. I think RAD should approve the administrator, and keeping in mind that in some ways we are beggars who are, who can't be choosers, because as Mark says, it's a high lucrative position, and we're lucky to get really good people who are dedicated to public service and public protection by this. So but we actually do have some very good people who we would bring to you to consider as the administrator.
I might also add that with respect to the qualifications, the proposal said very clearly that the special deputy trial counsels must be members of good standing. And obviously, which is not something that's expressed in the
I have two questions, two topics.
Sure.
And what is David Pasternak. What is the second topic that you just touched upon? And my question is, why do they have to be an active member of the state bar? Because it seems to me that a retired judge or a retired prosecutor might be able to fit this role very well and might very likely be an inactive member of the state bar. And I was wondering if you'd given any thought to that.
Well, yes and no. I mean, the good standing requirement is simply to make sure that you are a member. Of course, you're not you're not in bad standing, which is a bad thing. I mean, what you're doing is reviewing allegations of professional misconduct.
So I get that part of it,
right.
But the requirement that they be an active member of the state bar, it seems to me, might eliminate some people who might be very equipped and have the time to handle this role very well, such as retired prosecutors or retired judges who are inactive members of the state bar. And so I think you might want to rethink that requirement. The second area that I want to talk about.
Well, on that step, David, but what would happen if that case went to trial? Could that person, that would be the
case
problem.
go to trial. How do we,
what do you do
MCLE
there?
requirements, that they have no disciplinary record.
Right.
I
think that's the problem.
About the administrator?
No, not the administrator.
No, not the administrator. He's talking about the prosecutor.
And they'll be practicing law.
Yeah.
Okay.
That's the problem.
Okay, good response. I didn't think that.
I didn't mean to jump in, Miriam. I'm sorry. I just thought
the second area I've got a question on is the second look.
Yes.
Who is it who's going to conduct the second look under the changed rule, changed provision?
The way that's contemplated is that there's two situations where that can arise. One, the assigned special deputy trial counsel is assigned a case and closes it. And then after that, a letter will go out to the complainant, your case is closed, but you have an opportunity to request a review of your case if you like. Then if a request is made, that request goes to the administrator, and the administrator assigns that closed case to another special deputy trial counsel for a relook. If it's the administrator herself who closes the case, and those cases will also be subject to second look, then if a request comes in, then the administrator would be required to send it out to another special deputy trial counsel to essentially review that determination. And I think that to some degree that is identified, I think, in the amended rules.
So it's on
C5 and D2, but anyway, that's how it's contemplated to work. But either way, we will make sure that complainants have that opportunity.
Thank you.
Mark, on that, somebody else have a hand up back here? Just a quick question for you, then I would have us, unless there are any other questions, entertain a motion to approve this for public comments. But on the sub 5, in regard to the second look, it says it shall refer such request for review to a special deputy trial counsel. Should it make clear to an SDTC different than the original one? I mean, obviously, it shouldn't go back to the same SDTC, but,
That's in fact what is contemplated.
right, I mean, I'm sure it's what's contemplated, but.
I have a question on that. I thought that was closed by the administrator. It would be different than the special trial counsel. So
Yes.
is it 5 when the administrator closes it?
That's right.
Prior to having the special trial counsel?
So where's the SDTC 1?
That would be D2. The administrator shall refer such a request for review to a different special deputy trial counsel than was originally assigned. Does that answer your question?
Yep, it does. So is there a motion to per the resolution, send this out for public comment for 45 days?
I move to send this out for public comment.
Okay, moved by Jason, seconded by Brandon. So any further discussion on this? Can we dispense with the rolling of people that are coming and going? Okay. And everyone so consent? All right. So, last but not least, final item on the agenda is Rule 2603. Mark.
This particular item is back from public comment. Rule 2603 refers to the second look process, and an amendment to Rule 2603 that specifically authorizes the Office of General Counsel to review second look requests. And as you may recall, this particular item was necessitated by a recommendation of the state auditor's report in 2015 that recommended that the second look review process be removed from the Office of the Chief Trial Counsel and be handled by someone that's independent of that office, a department that's independent of that office. And the senior staff, executive staff made the determination that the Office of General Counsel should be the department to handle those reviews. And in fact, we are well on our way in the process to creating handling the mechanics and creating the structure for that to occur. There has been no public comment on this proposed rule, and we are asking that Brad recommend to the board adoption of this rule this amendment to Rule 2603. I want to also add that there was a post-circulation amendment to the rule. It was a non-substantive amendment. Essentially, what we did to the rule was to conform the text of the change, the new amended language, but to conform that language to the title of the rule. In the text, we refer to complaints. The title refers to queries, investigations, and complaints, and so we just added the words inquiries and investigations into the text of the rule, which is a non-substantive change, and under the rules is not required to. Those types of non-substantive changes do not require additional public comment. But I wanted to bring this to the attention of the board. It is outlined in the item itself. Again, with respect to the second look process, we are hoping to launch the transfer on July 1st. That's sort of our target date. We're moving in that direction with respect to some of the operational decisions we have to make in-house, as well as creating the software that we will be using to track these kinds of cases in the Office of General Counsel. So we're well on our way, on that, in that process. So if there are any questions on this particular item.
I just want to recognize Mark, who has taken this bull by the horns and really put together all parts of it, from the staffing to the IT work to training, manuals, training, and thought through all these changes to take on something that wasn't necessarily welcome as work, but we're willing to do what's necessary in the office. So you should really be recognized for that.
Thank you, Vanessa.
Thank you, Mark.
And if I could just add, his presentation was awesome, Vanessa.
Yeah.
We were certainly able to understand and follow it, so thank you.
So for the most awesome presentation, were there any?
Everyone's just happy that today's about it.
Okay, so it's been moved by Jim, seconded by Jason, per the resolution that's up on the board. Having been sent out now for notice and public comment, having received no comments on recommendation of Brad, this will now go on to the board to adopt the amendment to Rule 2603. Can we dispense with the roll? No objections? All right. Well, David, you said for Brad to take as much time as we needed, so be careful what you ask for. He kept telling me, do not rush. You guys have as much time as you want. And
Pardon?
I
said, don't say that to Miriam.
Yeah. So Brad is now adjourned. So I think you guys want to take a break or? Okay. So maybe a 5-minute break before planning and budget.
Did we get a break? David, are we getting a break? Oh, 5 minutes. No, you have a break. Give me a break.
Get it back up again.
Nice to see you. So you're on the board. Oh, there's an expert planning. Well, we have planning and budget and planning and budget. No, you're not, but are you on admissions? No. When is free to go? That's not fair. That's totally not fair. You didn't show up to the picture this morning. Wait a minute, didn't they say we're going to bring up the board of some comments together? Thank you. After the committee meetings, is the board meeting? Yeah, so there's a board meeting after that. You're not going anywhere. Stakeholders.
A&E.
No, I mean A&E.
No, stakeholders.
A&E and then the board.
This and this.
You better sit down.
I think you are.
I know. You want to sit? You want to sit?
I think we're going to our chairs.
Can I roll my chair back here?
You sound like
Can I roll my chair back?
Sure does. You should.
You sound like Rachel Maddow.
Oh, yes.
That's what she says about. She said during the public hearing the other day.
Oh, that's right. Farina, that was good.
That's her. Yeah. You know, it was a kid's table. Crack me up. Oh, she's awesome. She's probably, I think, the best journalist they got going. I mean, I watch her constantly. She is just, she really knows how to ask a question.
She does.
I mean,
She does it with some humor.
she does. She does.
Amazing.
Her delivery is outstanding. She does. She does. Exactly. Right.
No, true. But you do know her political perspective.
Well, she brought out the Flint, Michigan. Nobody even picked that up. Rachel Maddow brought that bad water out. She brought it out. She doesn't get enough credit. Because I guarantee you, if that had been any of the mainstream journalists on any of the top programs, they would have highlighted.
It was kind of too hard to believe that it was true.
I know. She really went after that and brought that to light by having a doctor on the program and just brought it out.
Speaking of things that don't seem possible,
Like if I go like this, right? They did, yeah, well. You can still see her speak. You can still see the PowerPoint presentation right there, right?
Putting together.
Right? Yeah, right? Yeah. Example like that. Look something like that. Like that. This is in the audit. I don't know. I gave the, you know who knows about that foundation? She does all.
Sure you do. We know.
I gave her Jane's document.
Yeah, it's definitely not looking good. No, but the left one was because at first I thought, well, maybe, no, that one's definitely.
How's the back? How's my head looking on TV?
Great.
My head looking. My new haircut looking good. You guys are awesome. You guys are doing such a great job.
Yeah.
Because I think it's
They don't just throw it off.
They open that before.
Oh, you saw this? Terrible. This guy's terrible. He shot like 6 people. And she's just such a... Oh, no, we always have to tell this out.
I'm not going to pull this out. I'd like to see the PowerPoint.
Basically, say 5 years and one of all of the
Yeah, I know.
We need more stuff happening to be heard.
Yeah, exactly.
We need mics to be heard. Thank you so much.
When you walk the
Everybody says that?
The crime rate is so high, he thought that it's...
Oh, okay. Right.
Yeah, as long as we're starting to attach to the financial. So Jim is going to pull it off the extent my respect.
I know the name. He just got the job.
He's the master of knowing how to do it. But I work
Okay. We're ready to start the Planning and Budget Committee meeting, so if you please take your seats. As you have heard prior to each of the committees beginning, we are webcasting all State Bar Board and Board Committee meetings today and tomorrow, and so the closed captioning can be captured accurately. Please remember the following when you are speaking. Turn on your mic, be sure to speak into the mic. Before speaking, identify yourself by stating your name. If you're not speaking, turn your mic off. And we will now ask for the roll call, please. Okay.
Michael Colantino. Here. Terry Flanagan.
Here.
Miriam Krinsky.
Here.
Renee LeBron.
Here.
Joanna Mendoza.
Present.
Danette Meyer.
Here.
Gwen Moore. And James Fox.
Here. The first item on the agenda is a call for public comment. Is there any member of the public who wishes to address the committee?
I'm sorry. First, I want to welcome the newest member of the Planning and Budget Committee, which I excluded from the roll call, and Stacy Spector.
Here.
Thank you.
Is there any member of the public who wishes to address the committee? If not, the next item is the oral report. I do not have a report to give. Under the consent agenda, which is really the primary business of the committee, we do have a PowerPoint presentation for item B, the financial statement, as I understand it, and Christina Wong is going to deliver that. So I will be pulling off from the consent calendar item B. Is there any objection to leaving item A on the consent agenda? Hearing no objection, that item is deemed approved. So the first item then for discussion is item B, the financial statement for the first quarter ending March 31st.
All right. Hello? Yeah, okay. Okay. Hi. Today we are going to present the State Bar's operating result for the first quarter ending 2016. We will start with okay. Okay. We are going to start. It's not responding. I'm not the director. Oh, okay. Keep going. Keep going. More. Yeah, we'll start with the first high-level review for the revenue and expenditure item from a fund perspective, and then we will do a closer look of three major key areas of spending, including the salary and benefits, temporary help, and travel and catering. And after that, we will give you a preview of the 2016 proposed budget amendment. And we are planning to bring this back to the board in July for approval. And then we will also have some project updates. Yeah. Okay. The first one, total revenue by funds. For the first quarter, we have budget for 107 million versus actual. We received 153 million, and we have about 46 million favorable variances. And this is because of the bank settlement fund we received for the legal service trust fund program. It's about 44 million we received in March 2016. And this amount is not budgeted in the 2016 budget because when we finalized the budget, we did not know how much we are going to receive. So this would be one of the budget amendments we are going to bring back in July. But even without this 44 million revenue, we still 2 million ahead of the target. And this is because of some small items, small revenue items, including the NCLE study, NJP annual renewal fees, and we receive more revenue than what we expect. So we're in a good shape for the revenue side. For total expenditure, the first quarter we have about 41.5 million budget. And actual spending is about 38 million. Our spending is below the budget. And so another picture seeing is we're in a positive, we have a positive result for controlling the spending. And in fact, most program funds stay within the budget spending, except for the client security fund. You can see it's about 0.8 million above the budget. It's only because this fund pay out a backlog of the 2015 applications in the first quarter. But with the 2 million transfer from the LAP fund and the legislative activity fund, remember the board adopted in March, and we expect the total payout for this fund in 2016 will still fall within the budget. And we are going to take a closer look about the favorable variances, and which is about 3.5 million. So the first area we're going to look at is the salary and benefits. Total budget for the first quarter is about 17.2 million. Versus actual, we have 16.2 million, and we have a favorable variances for about 1 million. And this is only due to the timing of the vacant position being filled, and also the merit increases. And we expect some additional costs will come back in the second quarter. For temporary help, total budget for the first quarter is about 600,000 versus actual. We have 466,000. Favorable variances again for about 150,000. I want to emphasize that this 622,000 budget for this first quarter is after implementing an across-the-board cost reduction for this expenditure area. For temp help, except for additions department, we apply a 25% cost reduction to begin with for our 2016 budget. So comparing to the 2015 actual expenses, we are seeing this favorable variances is actually a reflection of the double or compounding saving for this area. So it's a pretty good picture to show for this expenditure category. And in fact, most departments are responding pretty positively to implementing the spending reduction in this area. The next one is the travel and catering. We have about 997,000 budget for this quarter versus actual 770,000. And we have a favorable variances for about 200,000. Most of the saving is from sections program. And the main reason is that for the first quarter, they usually, the activities is slower than the rest quarter of the year. So most of the activities, they won't pick up until the second quarter. So we will expect more costs will pick up for the sections fund. But still, even after that, with, as what I just mentioned, this is already, the budget is already after 15% cost reduction across the board from the 2015 actual expenses from the building 2016 budget. So the variances that we are seeing here is also like a compounding saving for this category. So it's a very pretty impressive picture to show too. So overall, both the revenue side and the expenditure side, we show favorable variances, and the overall cost is under spending is on track. So the next one, we want to give board a preview of the 2016 proposed budget that we will bring back to the board for approval. The first one is the travel and catering. We may come back for adjustment, but we won't know much until we finish the review first, because the first year, as I just mentioned, sections program, most of the activities will start in the second quarter. So we will come back and do all the calculation and see how much money we need in case for this category. For severance, we will need another $500,000, and that's including the severance pay and the payroll taxes and also the unemployment taxes that we have to account for. And as I just mentioned, the $44 million, we will come back for budget amendment, not just the revenue side, we will come back with the grant distribution plan for the next 3 years. The $2 million transfer to the client security fund, that would be an adjustment to the budget too, as well as the indirect cost allocation. The board approved to allocate our $2.67 million for the capital improvement cost in March. So we need to revise the indirect cost calculation to reflect these changes. Oh, sorry. The last item is the credit card processing fee. We won't make any changes for 2016 because most of the costs we have already paid and incurred for the billing cycle. But we will come back and seek the board's approval to make it happen in 2017, so we can start charge the member for credit card processing fee. And we will bring this back before we start the next year's billing cycle. So before I turn this to Leah, I want to see is there any questions? Yes,
Michael?
Yeah, Michael Valentino. I'd like to start with a comment for the benefit of some of the newer members, and then I'd have some questions. This, to my knowledge, is the first interim year budget amendment that seemed like routine business. I think we did it last year for the first time in my tenure. And most government agencies adopt a budget and then, as their predictions prove imperfect, as they always do periodic amendments to keep the board informed about how the finances change. We never did it during my tenure, and I think in the years before my tenure. We had a one-page budget, and therefore there wasn't much to amend. And we have, as a board, asked our staff to be put in the work, and I know there's still work to be done here, and I'm grateful for it, to engage the board more in meaningful financial planning for the organization. So I just want to mark the milestone, appreciate the work, and say one for the home team. We're making progress here in important ways. Just a couple questions. We took action at our last meeting, I believe, to assign to the client security fund savings that we accomplished by reviewing reserves and other funds. Do we have to amend the budget at mid-year to reflect those additional revenues, or did we already accomplish that amendment?
Yeah, Chris, she raised that one.
So it's there. Got it. Okay, thank you.
Yeah, I just put everything there.
The second question is probably more for Leah, and it may be a question we have to mark and save for later. But it seems to me that we have a lot of temporary funding in the general fund, temporary positions funded in the general fund. 400 grand a quarter is $1.6 million a year. That starts to sound like positions that should be permanent, which is not temporary positions. Am I overlooking something about our business model that requires us to staff in that way, or is this something you're looking at?
It's definitely something I'm looking at. And the folks that work for me and with me here, I know that it's something I'm looking at very closely. The one area where we will continue to have a regular use of temp staff is in admissions.
Sure.
And for a short period of time, we'll continue to have some temporary staff in IT. But other than that, we've been very aggressive on getting that done. And as Christine said, if you recall, in adopting the 2016 budget, the board, we implemented an across-the-board reduction. I can't remember if it's 25%, and we're coming in yet under that budget. So we are significantly reducing those expenditures.
Great, I appreciate that. I'm sure it will stay on your radar screen. The last question I have is that there's a reference on that slide in the second to last bullet point to $2 2/3 million in capital improvement costs. Are these the improvements to this building to make a couple of floors ready for market, or is it something else?
That 2.67 came from the decision to allocate a proportional share of the Howard Street capital improvements, not the tenant improvements. This is the elevator, the building upgrades, and the 2.67 is 58% of the total cost of the capital improvements for this building, and the board decided to allocate the proportional share not associated with tenants to via cost allocation. So that's what that 2.67 million is. The board decided not to cost allocate any of the debt service costs associated with the $10 million loan.
Forgive me if I ask you to revisit a painful subject, but how is this going to affect the overhead on the sections?
Oh, they know how it's going to affect them, and it's going to increase their.
Okay, so we're turning the heat on up on the lobster another degree.
But they felt that heat back in March.
Okay, great.
Made the decision.
Thanks very much.
Other question?
Okay.
Joanna?
Thank you. Joanna Mendoza. I know that the board has already voted on the transfer of the reserve from the lawyer assistance program, but I don't know if we had a legal opinion on this, whether or not we could do that. I know that the lawyer assistance program, when they discovered that the savings that they were told that they had to engage in order to build that reserve was then taken away from them, they were not very happy about this, because they had no say in it, they had no warning that it was about to occur, and they were questioning the legality of the board's activities. And I know we were not told that there would be any question about whether or not we could legally do that or not, and it certainly caused me concern when I was hearing their concerns about us taking their money and whether or not statutorily we should be doing this or not. So I'm not sure if general counsel has looked at whether or not we can be doing that. And I just want to raise the issue, because I know Lawyers Assistance Program is very upset about what we did. I think the board should be aware that they are not happy. The Oversight Committee is not happy about it. And I just wanted to raise the issue.
So, the Office of General Counsel did opine. I can't for the life of me remember exactly what we said, but I'm sure Leah will.
Yeah, so let me just see if I have it in my little device. And it was Gina that worked on this, the Lawyer Assistance Program, and here. So in pertinent part,
while you look at Leah, I just indicate that I recall a huge presentation on this as to whether or not, I believe it was at our last meeting, as to whether or not we could legally do this. And you went through an extremely detailed presentation as to what funds we could take money from and what funds we couldn't take money from. And this was one that we could take money from. So I do recall that discussion, and I do believe the board was aware and made an informed decision to do what we did.
Right, so it says, provided the statutory fee is available for the support of the program each year, excess funds may be applied to the cost of State Bar General Fund programs. General fund not defined by the State Bar Act, but we would interpret it to apply to all portions of the membership fee authorized by the legislature. So yes, we did get an opinion on it, and I believe there was a corresponding amendment to the definition in the board book. There was a resolution that came along with that action item that codified the board's decision to broaden the definition of the allowable use for the LAP funding. So pretty confident that we're covered.
I think it was the January Monterey meeting at which that was done. Maybe if you look in the archives.
The reserve policy was January, but I think these decisions were the March.
March, okay.
March. Sorry, Mia.
Yes, Renee?
Sorry, I'm just saying it for my, Renee LeBron. Okay, there we go, Renee LeBron. I do think it was the March meeting, I think, didn't we, we looked at all the accounts that were, isn't this where we looked at all the accounts that were over reserved? So I'm pretty sure we had a pretty lengthy discussion on that. It was the last meeting, whatever meeting we went through all the reserves.
So it was March.
Yeah.
Yeah.
Can I just comment? We talked all about the reserve funds, but we did talk about a legal opinion on this issue.
Okay. Well, anyway, I'm just clarifying now that yes, we did receive it. I felt confident that it was allowable.
Other comments or questions?
Okay. Just really quickly, Jim.
Yeah.
Do you want to go to the last one?
Yes.
These are some of the things the board can expect to see. So you will see a cost-benefit analysis or a full fiscal analysis and a recommendation regarding implementation of a new procurement of a CMS and the associated implementation costs. We are going to get into this afternoon, class and comp and workforce planning. Both of those have resource implications. And we'll be bringing to the board this issue of the need for the bar to establish a real cost recovery policy. Christine raised the credit card processing fees. I was very surprised to learn that we are eating all the costs associated with the 0.4, the 0.6, the processing fees that the merchant, the Visa, the credit card processors charge. We don't charge that back to our users. So it's about 1.3 million annually that we're absorbing. So some of that will fall into this broader discussion of cost recovery. So that's just a preview of things to come.
Any other questions or comments? If not, we will move on to item 3A, the update. Oh, yes.
You removed the item from consent, so we have to move it.
Oh, I'm sorry.
So if you could post the resolution and ask that it be moved and adopted.
This is the member request for adjustment to be?
No, we did that. That remained on consent. This is the second item, which is
Accept the financial
54-142.
statement.
So moved.
Motion by Palantuno, second by Flanagan. Any discussion? Is there any objection to substituting the roll call? Hearing none, the matter is approved. Next item is item 3A, the update on overhead allocation budget amendment. Yeah.
Yes, okay, so I was going to give an update. This is the issue having to do with the decision that the board made, again at that March meeting, to effectively buy down the section, a portion of the section's increased cost allocation. You all recall we did a lot of discussion about the cost per member going up to $64 and, the cost per member going up to $64, the section's expressing some concern, and the board agreeing on a one-time basis to buy down a portion of that CPM on a dollar-for-dollar share with the sections using their fund balance. So subsequent to that meeting, we presented a couple of different scenarios to the sections to buy down their CPM from $64 to $55 to $50 to $45. And ultimately, the council met and they decided that they would like to advance to the board a recommendation to buy the CPM down to the $45 level. And that is about a $1.2 million total, $1.3 million buy down. At the 50-50 cost sharing basis, that would be about $650,000 from the sections fund balance and $650,000 from our own discretionary funds. So that was the proposal that they intended to move forward. As I was looking into this further in terms of the source of the matching funds, we had been talking about perhaps the insurance and affinity program money. But I started to learn a bit more of one of our funds, Fund 88, the Section Education Fund. It's within the overall group of section funds, but it's got a different funding source. After learning a little bit more about it, I determined that I, in fact, wanted to learn a lot more about it, and I reached out to Moss Adams to engage them to actually audit that fund so we can see all of the sources of revenue going back since its inception to determine, A, if any of that funding appropriately belongs elsewhere, either to a particular section, to another entity, our elimination of bias programming perhaps, or CYLA, and if that funding truly does not belong anywhere else, if it's appropriately been exempted from the reserve policy. So because I had all of those questions about the potential source of the match for the board's commitment to do the 50-50 buy-down, I decided not to advance the recommendation from the sections to move to a $45 CPM. And I did reach out to the chair to indicate that I would be letting the board know that I'd like to hold off on that until the July meeting because the Moss Adams audit will not be concluded until June, the beginning of June.
Can you talk briefly about where the funds came from that particular fund?
Yeah, well, as I understand it, there's a variety of sources, but the majority of that fund comes from our contract with InReach, which provides our online platform for attorney education. And so that platform generates revenue. So it's a portion of the revenue. So we get a remittance that includes a large amount of revenue collected, and then we do an internal allocation back out to the fund sections that may be responsible for the programming that generated revenue. So most of the funding is allocated out, but there's an amount of funding that over the years has remained in that fund, not allocated out. And that's the amount that over time has grown. I think at the point that I looked at it, it was about $2.8 million. And so it's just grown, and I think I just wanted to learn a little bit more about it. So that was the source of my asking Moss Adams to look into it.
I just want to express my appreciation as one trustee for you taking initiative on this. I think the scrutiny you brought to our books is already paying off in significant ways, and I'm grateful for it.
Renee?
So just a quick question, the 2.8 is, what, there was another reserve, there was another amount that the section said, right?
Yes.
It was much larger, correct?
So they have 5.8 million just as sections. And then this, but I have been lumping this all together for a reserve of over 8 million, but once I really started looking at it, they're not the same reserves.
Okay.
Yeah.
So technically, the sections are entitled to the 2.8?
No, I
Or
don't
you're
know.
not sure.
I don't know if they're entitled to any of it. They may not
okay,
be.
But it's in the 8 now.
It's in what I've been calling the 8, and right now it's excluded from our reserve spend down policy.
Right.
So then if it doesn't belong to the sections, it doesn't belong anywhere else, then the question for the board will be, is this appropriately excluded from the reserve policy?
So if there's 8 million and you took out that 1.8, call it 2, there's still 6 that the sections have available for this buy down, correct?
Right, and so part of what they realized when they were doing this modeling is in buying it down, choosing the option to buy it all the way down to 45, where they're putting up half of that buy down themselves from their fund balance. Their fund balance is actually just going to grow. So it's all, it's cognitive disconnect in a way because we are mitigating the impact of the cost allocation for them, and in doing that, their fund balance is growing.
So where's the other 6 come from then?
Their 650 comes from them from their fund balance of 5.8, and I was going to recommend to the board.
Where's the other?
The 2.8 I was going to recommend.
Okay, sorry. If you take out the 1.8, that we're not sure where that goes.
Mm-hmm.
Where's the other 6? What's generally the sources of that? When you say that their fund balance will just keep growing, what is causing it to grow? Where is that money coming from?
Oh, the sections fund balance?
Yeah.
because their expenditures do not, their revenues exceed their
So
expenditures.
it's just their dues are high.
Dues and events.
Okay. So why would we hold off agreeing to the buy down? I mean, we don't really need that 1.8 in there for them to do that.
Well, remember the buy down is half their money and half the bar's discretionary money. It was going to be our affinity insurance programs. I wanted to look at another funding source because, as we know, we are under a tremendous amount of scrutiny and interest in how we're using our discretionary funds. And so I wanted to see, could this Fund 88 be the source instead of the affinity insurance program money?
Okay, so your timing is just to wait and see where our 650 will come from, not that you're questioning whether or not we would let them buy down.
No.
That seems like a no-brainer.
No, that's a no-brainer,
Yeah.
that
Okay.
portion, yes.
Okay, I just wanted to make sure, hopefully when we communicate to them that we're holding off, that they will understand that.
I think so, yeah.
Other questions or comments? Anything else to come before the committee? If not, we are adjourned.
Mission and
You. Give him time. I get to the big place here.
we're going to go into that, I think.
Well, that's what's happening on all the committees.
But the rest of these are
No problem. Well, I haven't been to the kids. I'm not quite sure why that's a big deal. It's a big deal.
Well, I think we'll get going here. I'm Terry Flanagan, and Chair of the Admissions and Education Committee. And I'd like to begin by reiterating our website of the mission. And that is that before you begin, there's a reminder of everyone here that you should turn on your mic, speak directly into the mic, identify yourself, stating your name, and if you're not speaking, turn your mic off. If there's anyone in attendance who is here to offer public comment on any of the items on our agenda, please identify yourself now. Yes. I'm going to ask you if you come forward and please identify yourself on the specific item you'd like to comment on, and then we'll call on you when the item is presented.
Okay, sure. I'm Greg Brandis, and I was going to comment on the TFAR item on the agenda.
Thank you, Greg.
And I'm Charles Weisselberg, also on the TFAR item.
Charles.
Yes.
We'll get back to you two gentlemen when we get to that item. Thank you. With that, the first item of business we have here, I'm sorry. If Dina, if you could call the roll, please.
Janet Brewer.
Here.
Miriam Krinsky.
Jason Lee.
Here.
Dennis Mangers.
Here.
Stacy Spector.
Here.
Brendan Stallings.
Here.
Todd Stevens.
Here.
Terrence Flanagan.
Here.
Thank you.
Okay, well said. Okay, we're going to go to item 3, and we have with us today Gail Murphy, our Senior Director of the Office of Admissions, and Natalie Leonard, the Director of Legal Specialization. The report we're going to be talking about the report and filing with California Supreme Court of the Board of Legal Specialization's annual report. So, ladies.
Okay, I'm going to let Natalie take the first swipe at this. So.
Well, thank you, Gail. Many of you are familiar with the Legal Specialization Program. It's one of the bar's early pipeline interventions programs, and it's created under a court rule. It offers attorneys who are members of the State Bar of California the opportunity to certify in more than 22 areas of law. That's particularly important these days, with new attorneys sometimes thrust out on their own before they choose or at an earlier point in their career. It encourages attorneys to have a broad, strong background, to complete more than the average requirement of MCLE, specifically in their subject area, and to secure positive peer review from both judges and attorneys in their areas. Each year we file a report on how the program is going. We had strong attendance at the exam in the fall. We had a successful administration, and a large portion of the applications from that exam have come in, and we can send our specialists here on the board as well. If there are any specific questions, I would be happy to take them.
Do we have any questions of Ms. Leonard?
This is Todd Stevens. Any requests for any other?
Is your mic on?
Can you hear me?
Yeah.
Can you hear me now? Okay. Have there been requests for any other specific substantive areas to expand the program that have been brought to your attention?
There has been interest in a number of areas, and there's also been interest in coming back to this board or to OCTC and learning about the areas where consumers may have a need. So for the past couple of years, the group has been working on standardizing the exams, things that you can't see that make very strong exams, and people have been consulting with us from other states about what we've done, but the board is ready to turn to some of these requests.
Okay. Thank you. Any other questions or comments? Well, members, the resolution is on the board before us, projected. Do I have a motion?
Move approval.
Approval by
Dennis Mangers.
Mr. Mangers. Dennis. Do I have a second?
I'll second.
And Brendan Stallings. Second. Is there any discussion? Can we substitute the roll call? Any objection substituting roll call? Thank you very much. Gail, you're still here on our second item. Proposed amendments to the admission rules concerning open and closed meetings of the Committee of Bar Examiners. Return for public comment.
Yes, as you're well aware, as of April 1st, the state bars committees were subject to the Bagley-Keene Act, except for the Committee of Bar Examiners in general. And so the Committee of Bar Examiners believed, however, that there should be some rule with regard to the open and closed sessions of its meetings, and therefore put together a proposed rule that more or less encompassed several aspects of the former board rules with regard to open and closed meetings, and then adding a few things that were not specifically covered, such as items that relate to the committee's law school regulation function. So those rules went out for public comment. Only one comment was received. If anyone wants to look at it, I have it here. But it was not substantive in nature with regard to proposing any changes. It was basically from someone who was not pleased with how the committee had operated in the past. with regard to his personal experience. So at this point, the Committee of Bar Examiners has adopted the rules in principle and seeks the Board of Trustees approval.
Do we have any comments? Any questions? The resolutions before us, is this the, I guess this is the, okay, we're all set now. Okay, and to resolve that the Board of Trustees approves the amendments to Rule 4.1.11 of the additions rule effective immediately. Shall we substitute the roll call?
Just need a second on
I'll send a second.
Thank you.
Janet? Brewer, okay, we're all set. Can we substitute the motion? That's done. Thank you. Dina, you have the third proposal here, the annual recommendations to the Supreme Court for the suspension of members delinquent in payment of their bar fees.
Thank you. Dina De Loretto, I'm the Managing Director for Member Records and Compliance, and I happen to staff this committee as well. The next two items are routine items, so hopefully we'll keep the agenda moving along and get to the more meaty items on the agenda. This is the annual item requesting your permission to file with the Supreme Court a recommendation for a suspension order for those attorneys who have not paid their membership fees by the final deadline of June 30th. As the item describes, they've been properly noticed in all the various ways that is described in our rules, and we'll be continuing outreach in the form of emails to remind them, and hopefully as many as possible will pay by June 30th. And that's it. The resolution outlines the suspension process as well as details in the court order would have provisions for the reinstatement process as soon as they've paid.
Any questions or comments? Do I have a motion? Is that new? And a second?
A second.
Thank you.
Any problem with substituting the roll call?
Thank you. Similarly, the next item, it relates to MCLE compliance. Group 1 attorneys were due to report compliance this year by February 1st. If they miss that deadline, they're assessed a penalty. If they don't report their compliance and pay the outstanding penalty by June 30th, this is a request to the board for your permission to place on administrative and active status those attorneys who are not in compliance. This is not a court order that we're asking for, different from fee suspension. This is actually an administrative inactive status within your authority.
Any questions or comments? Do I have a motion? Diane Stallings.
Second.
Second.
Thank you.
J.C.
Thank you.
Shall we substitute the roll call? So let's see. We are now at item 135.
I think I'm going to take the lead and we'll jump in as needed. We have a little PowerPoint. Again, this is Dina De Loretto. We have a recommendation related to our MCLE audits. Give you some context, you may recall in March we had a joint meeting of RAD and A&E where the audit process was discussed. We discussed resources that are being used for the audit. There was a proposal that staff would proceed with going forward, transferring only the most egregious cases to trial counsel for further investigation and possible discipline. But with regard to the administrative process, there was a discussion about potentially introducing new penalties, and staff was asked to come back with a specific proposal. Currently, if once a member has been selected for audit, If they miss the initial audit deadline, which is a deadline about 45 days out from the notice, asking them to furnish proof of their compliance, which they had previously attested to, they are assessed a $75 late fee. If they are deficient in the audit in any way, the same $75 late fee applies. They have till the final deadline to complete any missing hours, otherwise get placed on administrative inactive status. Only at that point would they be assessed another $200 reinstatement fee, so that to get reinstated to active status, they'd have to complete the hours they're missing, and possibly $275 in total. What we're proposing today is to add another $200 penalty that we call an MCLE audit deficiency fee to the structure. We actually, at Leah's request, I'm presenting two options here. The first option proposes that we would continue assessing a $75 late fee for late submissions, and also for submissions that are deficient by half the requirement or less. We would then assess a $200 penalty to those submissions that are more than half deficient. The $200 reinstatement fee would still apply if they miss the final deadline from bringing themselves into compliance, and would have to pay all of those in order to get reinstated. I favor this approach because I see the files that come in. And we could have graduated penalties that are much more detailed than this, but that would create a lot of administrative burden and probably be a little bit more confusing. So we try to keep it a little bit simple, but I do favor this kind of approach where it's different depending on how deficient you are because of what we see coming in. I feel like there's a big difference between someone who's done a miscalculation and is short by 1 hour, has all the hours and more, but maybe short just the ethics hours. These are the things we commonly see, versus those that have nothing to show for their education and can't come up with any of the hours. So because I see that wide variance, my gut is telling me that it would be appropriate to kind of have a phased-in penalty like this. The second approach, though, would be to keep it simple and continue to charge a $75 penalty just for late submission of the audit files. But as soon as we do receive, if we receive nothing, or as soon as we receive the audit proof and it's deficient in any way at all, they get hit with a $200 audit deficiency fee. In both cases, if they don't complete what they're missing by the final deadline, they would be placed on administrative inactive status and accrue the other $200 penalty. Leah favors this approach. It's simpler and it's more straightforward. And
it's less judgmental. Yeah. Dina and I disagree. So that's why I said just present both of them.
Are you on?
Sorry. Obviously, we can make either approach work, and we'd like you to give us some guidance on what you think is most appropriate. So this is just we've done some, I want to thank Bob McPhail on my staff who did a lot of number crunching based on past results and what we see as results in the audit, what we might project as revenue with this new model. In the case where we just be assessing the extra $200 to those that were, had more than half the hours missing, we project about $139,000, which is up from just under $100,000 we were collecting up to this point. Our direct costs, which is temps and other supplies, which I'll mention in a later slide, are about $160,000. And so we're approaching almost even break even for the extra cost of this audit. The second model obviously would bring in a lot more revenue, and the revenue would exceed the cost of operating the program. Just a little bit more detail about the costs. As you can imagine, the bulk of the cost is labor costs, the temps we come in, that we bring in. Obviously, if we did a smaller audit, we would pay less in temps, we'd need fewer temps for a fewer amount of time. But overall, we are trying to kind of cut those costs. This is pretty conservative. We're hoping to spend less than this. The fact that we're only going to be referring the most egregious cases to trial counsel will save a lot of time and expense in the back end at preparing files that are suitable to be transferred to trial counsel as evidence files, and we hope to be able to release the temps as early as possible in the process. The assumptions that we've made are based on doing the audit selection process the way we've been doing the last 2 years. After having done the audit for a few years, we found some patterns as to what groups are more likely to have problems with the audit. And so this is just a reminder, we presented this to you before. of how in the last 2 years, and we expect to continue this year, how we've targeted it. It's a net amount of 10% of those that have reported compliance. And we target at a little bit of a higher rate those who have prior administrative actions, because we know that they typically don't do as well in the audit. We target at a little bit of a higher rate those who comply after February 1st, and we target 100% of those who comply on the last possible day, June 30th. The only thing we're going to do differently this year, we've learned after the past 2 years, we targeted those who had failed, had been selected for audit in the past and had failed. And we targeted them, all of them. And we found that they actually did well in the audit. They're not at a higher risk than anyone else. And so they may be selected again randomly. Then we'll suggest they go buy a lottery ticket or something. But we're not going to target them. So this just, for future discussion, raises the point. We intend to proceed with the same model we've been using the last couple of years, but we would welcome the board's guidance on in the future what to do. Obviously, when we target the problems, you get problem files, you'll charge more penalties. If it's a true random selection, we won't have as many problem files, we'll collect less penalties. And we've kind of crunched the numbers to give you an idea of, based on what the audit selection criteria are and the size of the audit, how it will influence the revenues and the costs.
So, Dina, I just want to point out, when in all of these cost models, you have not taken into account the cost of your own staff.
That's right.
So this is a very significant underreporting of the actual cost.
That's true. We absorbed a lot of the process with existing staff, the planning and oversight of the process. These costs that we're stating are the additional costs we incurred by hiring temps and postage and noticing the things that were above and beyond what we were doing already. So it does not take into account the time of permanent staff to oversee this process. And the last meeting, we thought it would be interesting to kind of look at other states. So we gathered sampling of other states. It's hard to compare what we do with what other states do. Most of them have already moved to a model where they collect all of the records from the providers in advance, and so they're in the position of telling their members, you're done or you're not done. And if they're not done, that's when the penalties accrue. The other states appear to charge penalties based on just late compliance as opposed to severity of compliance. And as you can see, if we're talking just about our audit, the max penalty right now is $275, and it's on the low side compared to some of the other states. If we added another 200 with a max of $475, I think we'd still be appropriate. It seems to match up with the other states. I did an average of the other states, excluding California, and it was about 600. So, but there is quite a variance, as you can see, as low as $150 to as high as $2,090. And some states don't have MCLE compliance penalties per se. I know New York, for example, focuses a lot more on auditing providers and the education itself. And that's my presentation. And so I'm happy to answer any questions. And
Jason?
To the slide referencing the different ways to identify members for audit.
Yeah.
What I've seen is your current practice seems very effective in identifying folks who are deficient in their MCLE. And I would encourage that in my own view. That seems particularly effective in public protection in keeping our members current in their educational requirements. And that sort of divorced from the entire idea that our fee structure generates X amount of revenue compared to costs. As to the second, perhaps your first question was how should we utilize individuals? Your recommendation on option 1 is based on your experience relating to what you actually see.
Yeah, the 12 and a half hours is a natural cutoff. If we made it 8 hours, it wouldn't be that much of a difference, to be honest. It tends to be a few hours short or very, very short. And 12 and a half seemed like an even, right in the middle, simple to calculate, reasonable line to draw if we're just going to draw one line.
And how often, if you would just ballpark it, do you see lawyers who are just short by, there's like one ethics hour or they just discounted?
It happens a lot. It happens a lot where the intent was obviously there to comply, but because of the miscalculation or a lack of care in counting or in being aware of all of the specific, the ethics, the bias, and the competence issues are covered. It happens quite a bit that there's a mistake like that, and in my mind, it's a bit different than someone who can't show anything.
But in both instances, in my calculus, both instances, they're still a testament to the fact that you've done it.
That's true, and their record keeping perhaps wasn't very good, and they're both deficient, and in both cases we would require they make it up, otherwise risk being placed on administrative inactive status.
Any other questions? Brandon.
Brandon Stallings. Is there any sort of appeal process that the members can go through if, let's say, they dispute the amount of fees or ask for a fee waiver? Is that built into the resolution?
No. It's not built into the resolution.
But isn't there some kind of process? Because what about that recent DA's office that was late and it went to the committee made up of some of the board members? Or that was the membership?
That was membership fees.
Membership fees.
Right. We do have some guidelines that are remnants of when there used to be an MCLE committee of waiving the $75 late fee in the case of the regular MCLE reporting requirements that revolve around extreme hardship in very narrow circumstances. We had not contemplated applying that to this new fee, but that's something we could do.
Sorry, Todd, just one other question. Just so I'm clear, the just slide where it listed the correct costs, that did not include any labor costs as far as staff members who are assigned to other units. And when they're working on this audit, I think it's the $160,000.
So it's 100, right, if we're doing 10%, it's 130 in labor plus 30,000 in miscellaneous postage, paper, printing, those kinds of costs.
And that's for the entire audit. That's not for the individuals who are deficient, who would be under this either $75 or $200.
That's correct. That's the whole process.
Okay. Do we have any breakdown of the amount of individuals who the $75 or $200 fee would apply to? Of course, the number of hours and sort of direct costs.
Well, besides just the gross number here, I don't have it broken down. We do have it broken down, I think, in the office. Bob is smiling at me. Somewhere we have it because we did a big formula to kind of come up with this, and we have records of how many. I want to say last year out of 5,500, Bob, does this sound familiar? About 1,200 had some kind of a problem, big or small.
That's close.
Yeah. So this year's group is bigger, so we're looking at more an audit pool of more like 6,400. But we have a sense of how many have an issue, and then we have it in a database that we could break it down by how many hours. Doc, do you have?
Just a comment on that. There's probably
I'm asking, if you don't mind, Mr. Chair, Robert McPhail from my staff to answer.
there's probably a very slight marginal difference in the cost of handling an individual deficient audit versus one that's not deficient, but it's not very high. I can't tell you, good audits cost this much, bad audits cost that much. There obviously is extra time, but we didn't try to calculate it in terms of, well, how much do we have to charge extra for the cost of the deficient audit?
I kind of think of it, it's more of an esoteric thing. Because there are bad audits is why we have to have audits in the first place, so covering the cost of the process.
Just a quick question. Dina, between option 1 and option 2 that you and me or Todd Stevens that you are debating, how much time did you estimate would save staff time if we adopted or recommended option 2?
I don't think the calculation, distinguishing the difference would take us that much time because it's one or the other. It's not a graduated scale of 10 things. It'll be pretty straightforward either way. I'm trying to be very objective, and either way will make it work, but we'll spend a lot of staff time dealing with complaining members for, I think, a $200 fee over a minor discrepancy, if it applies to everyone. But that's, me being super practical on the customer service, answering the phones side. And so this seems like a fair approach that we can stand behind, but we can make either one work.
Any other questions? Well, we have two resolutions before us. We have a motion.
I'll look at the resolution.
You can see that.
So, yeah,
Let me see if I can make it look
to be clear, the first one makes the distinctions between the severity of the deficiency, whereas the second one, the second set, does not. But they both propose a $200 additional fee.
And we have Dina favoring resolution 1.
And for Leah's credit, she is my boss. So I said, whatever you want. And she said, no, that's a good. Go ahead. They should hear all the information. So, yeah.
And just to explain where I'm coming from, I have been uncomfortable with what I see as sort of this value judgments that are being infused throughout the process. And I just step back and say, I don't care why, and I don't care if they're 1 hour, 5 hours. That doesn't matter to me. If you're late, then we'll apply a fee, and if you're not, then we won't. So that is the sort of the rationale that I have for it. But I'm just to get to your point, Jason, I've gone back and forth with Dina a lot about this targeting of people who have had problems in the past, because in lots of other areas of the world, if you think about policing and what we're doing in the criminal justice side, that's exactly what you don't want to do. And so here we are, targeting people that we know are going to fail. However, I get that this is a different context and we may have a different reason. So that was my rationale for saying I don't want to impose any judgment about who's more or less deficient. I just simply want to assess it closely. So that's why I had my approach, but I really respect Dina, so I said, put them both forward.
Mr. Chair?
Mr. Mayor.
Ms. Wilson just told me, and I move the second of the options.
Second.
Motion by Mr. Mayor and second by
Mr. Lee?
Mr. Lee. Any other comments?
I was going to say, for me, it's the attestation of completion of hours. Leah talked about value judgment. I mean, as a lawyer, if you're going to assign an attestation you complete the hours, you have to complete the hours. So.
Yeah, Miriam.
The second option makes more sense to me as well, although I can see arguments as to both of them. But I just want to make clear that I don't support the second option because it's a fee generator, a revenue generator. In my mind, I think that's something to be aware of, but I don't think that we should be determining what are penalties based on, how do we kind of reach a revenue stream. Obviously, we need to be looking at, can we support the work that we do, and that's important. But if it's the right thing to do, I think we should support it, not based on the revenue versus cost analysis. So I just want to make that clear.
No, I absolutely we lost money doing this. I think we're more than issue.
All right, we now have a resolution supporting number 2. Shall we accept that first roll call or put it to a vote?
Perhaps someone suggest put it to a vote. Yes. Janet Brewer.
Yes.
Miriam Krinsky. Jason Lee.
Yes.
Dennis Mangers.
Yes.
Stacy Spector.
Yes.
Brandon Stallings.
Yes.
Todd Stevens.
Yes.
Thank you.
So the next item is item 3F, dealing with the TFAR recommendation and request to release it for public comment. And gentlemen in the audience, I'm going to ask you to come up after we have our initial discussion here. I'll ask for your comments as well. And so I'm going to turn this over to our Executive Director, Elizabeth Clark.
Thank you very much, Let me begin with an apology. I've received a great number of, I think, quite agitated comments about the TFAR proposal, and I think there may be some misunderstanding as to what we were doing today, so let me first make that very clear. TFAR is a project, a great deal of work has been put into this. It goes back a number of years, and a tremendous number of people have been engaged, and it is a subject of a great deal of intense interest and concern. And as the report suggests, we have been reviewing it. I'll say more about that, but recognizing the level of interest, we thought the time had come to put this out for public comment, to make sure that we were getting all parts of the broader community, giving them an opportunity to comment, not just those who were part of the original committee structure or who had been deeply engaged in it, because we think it does have a broad cross-cutting implication for how we prepare lawyers. So now let me turn to a little bit about what the three proposals involve. I'll start, however, with a bit of history. TFAR is actually a two-part project. It was looked at starting in 2012, if I'm not mistaken, and it moved forward, and with some broad recommendations, TFAR 2 began to be looked at in 2014, and that effort went forward and came before the board with some broad recommendations that were adopted in late 2014. And then, of course, as we moved forward, several things happened, and among them, most notably, I think, we had a very significant audit, which was delivered to us in June of 2015 with significant financial implications, potentially, for the work that it was requiring. And then, as you know, the entire executive suite changed. And so in the fall, as we arrived, the decision was that we really ought to look at this again in light of how the recommendations might or might not impact some of the requirements, particularly in the audit. Now there were three parts to TFAR, which, as I've mentioned, was really looking at improving preparation of young lawyers, law students as well. The first of the proposals had to do with pre-admission competency training, and I think this is perhaps the most contentious of the three recommendations, because the recommendation, broadly stated, was that there be a requirement of 15 units of practice-based experiential courses that would be required in law school for graduation. I'll come back to that one in a moment. The second two involved what appear to be important, but at least as we've modified them, they don't seem to have quite the level of controversy attached. And so perhaps dealing with those first makes some sense. The second was a 50-hour pro bono or reduced fee legal services requirement as a requirement for seeking admission to take the bar. The third requirement was an MCLE requirement that would have added 10 hours of relevant preparation for young lawyers after graduation. Looking first at the 50-hour pro bono requirement, one of our concerns as a staff was to explore what the level of additional cost would be were we to implement the proposals exactly as they were written. Now, I'm not yet talking about the competency training 15-hour credit component because, as you'll see, that really didn't impact the bar as the other two did. So as to the 50-hour pro bono requirement, initially the proposal had been drafted to extend across the admission to the bar period. So 50 hours would have spanned then from law school into the first year of practice. And because of the difficulty that created in monitoring and review, we don't have a system that really allows us easily to create that type of structure that monitors both before and after graduation. We proposed that the 50 hours of legal services occur during the law school period. So that would give a student either 3 or 4 years to complete the requirement. And in discussion with law schools, we also learned that the law schools would be perhaps not enthusiastic, but willing to be the certifying authority. I should say that as to the 50-hour requirement, you should be aware that there is now pending before the Senate a bill by Senator Block, which would do much but not exactly what the proposal as modified and as we propose it to be now require. The MCLE component of the three-part TFAR recommendation was in many respects somewhat easier. We were, however, concerned that we once again integrate this into our existing structures so that our monitoring and enforcement effort would not add additional cost or require us to create new structures. And so to that end, after considerable conversation, we decided that the best approach would not be to seek an additional 10 hours, which would, by the way, in all likelihood have required a statutory amendment, but rather to include up to 10 hours within the 25-hour MCLE requirement as it exists, and then responding to suggestions by some because of the concern that this 10-hour really practice-ready component to MCLE for new lawyers would best happen in the first year. We decided we could do that program in the first year of practice. So 10 of a lawyer's first 25 hours completed normally every 3 years would then happen in that first year. So with those changes, we felt that we could slightly modify the proposal that the TFAR committee had come up with and still honor the spirit that it represented. Now we come to the more difficult proposal, which as it turns out really has less cost implication for us, but does seem to have a great deal of contention within the broader legal education community. And here, after a good bit of study, the TFAR committee came up with the notion that there should be at least 15 units of practice-based experiential training in law school in order to develop better law practice competency. There was also the ability to substitute some actual training such as internships, externships, clerkships for that 15 hours. We've come forward with a change, which isn't to say that the 15-hour program would never happen, but rather to say that the first step could easily be to take advantage of a national development where the ABA is now requiring 6 hours of such practice-based experiential learning. And so in order first to make sure that all those who study law in California, whether in an ABA school or California school or otherwise, would come under the same requirement, we're proposing that that 6-hour requirement be applied across the board. Now, as to the 15-hour component, here we think a better approach is not to adopt that now, but to allow the experience and learning that will come from watching the ABA requirement, and one that is similar but far from identical going forward in New York. So in case you miss this, the ABA's requirement, although adopted in 2014, really doesn't become effective until this coming September. And so we won't have an experience to learn from with regard to what the ABA is now requiring with its certification procedures and so forth for a few years. And in exploring what's going on in New York, we learned that they have yet actually to implement their program, although we expect that they may also attempt to do so this fall. But it doesn't have a great deal of content yet that allows us clarity, and certainly no experience to draw upon. Knowing that these three proposals, TFAR, if you will, had been something that had been worked on very hard and had a lot of interest, we spent some time trying to first look at how we might refine particularly the two proposals that were of financial concern to us, but also the experience-based component as well, experience training, and had a number of conversations. March 1, Gail Murphy organized Council of Law Schools. Do I have that?
Assembly.
Okay. We had a day-long meeting there, followed with conversation with legal services organizations, because of course the pro bono requirement requires 50 hours of work in legal services or other types of nonprofit pro bono efforts of a legal nature. So we talked with that group. The next day, I spoke with the chairs of the three different subcommittees of TFAR, and earlier I had spoken with Justice John Streeter, who had been the chair of the entire effort, and received comments and concerns from them. I also felt it was appropriate, because of things that I was hearing and learning, and indeed there had been a group of law school deans that had written a letter that expressed their concerns about the 15-hour proposal in particular and opposing it, that it would be appropriate for me to speak with the executive director of the Association of American Law Schools, which represents virtually all ABA-approved schools nationwide, and her counterpart at the American Bar Association, who is the managing director of the legal services, or I should say the law school division. Had lengthy conversations with both and heard their concerns and their, what shall we say, their view of the proposal, and learned that they had little concern about the MCLE requirement, and indeed we didn't think they would, that they were stepping back from earlier concerns about the 50-hour pro bono requirement, and indeed the ABA advised that they thought they were probably going to be changing their requirement to include this as well, but that they continued to have really strong concerns, and they felt that many of their constituent law schools would as well with the 15-hour credit proposal. So gathering these disparate points of view, it seemed to us that the time had come to move forward and put this out for public comment so that we can gather views from various quarters. Now, as I mentioned, what we did in refining the proposal was to try and create something that we could implement sooner rather than later, leaving to the future what we think is likely to be the most controversial part of TFAR, and that is really whether we should go as one state from a 6-hour competency-based requirement to 15 hours. And here, some say yes and some say no, and whichever side they're on, they hold the view rather strongly. I might want to pause at that point because I see Gail Murphy sitting right in front of me, and she's, of course, an expert, as I'm only an amateur. And I wonder, Gail, do you wish to comment or add to what I've said in any way? Dina DiLoretto is here too, and Dina had a role, of course, in the MCLE part. Gail's role was on the adding requirements for law school graduation in order to be qualified to take the bar exam. So if either of you would like to contribute, I'd be happy to cede a little bit of my time to you.
The only thing I would say under the sort of the modified approach, I think as far as the folks who would have to implement it, that it would be much easier to do so under a much, as contemplated, simpler rule, but yet getting to the substance of what has been suggested new IPRTs should have before they start the practice of law and right after the practice of law.
For the MCA requirement, it's pretty straightforward. I think that incorporating it into the existing requirements just makes it a lot more feasible. We can implement it within the structure we have now, and so it would reduce costs significantly to have a separate requirement. And as you mentioned, it's changes that are allowable in the way the MCLE rules are set up now and don't require legislation.
Well, and I would also make the point that I believe the sort of modified approach you can accomplish through a court rule rather than having to go to the legislature and change admission requirements, which is where most of the admission requirements are now or in statute.
Any other questions or comments?
So I want to thank Elizabeth for all of the work and outreach and thinking and learning in regard to this. And I know, it's been a balancing of wanting to get as much input as possible, be thoughtful about this, but I think many have also noted that we can't wait forever, that we need to move on this. It's important to put something out there and start to get some feedback. And so, I think that this really reflects an effort to try to balance both of those, to get as much input as possible, but yet to move something forward and start to, this is not the finish line, this is simply putting something out there to get the feedback so that we can then come back to the board for us to make the final call. I guess I have thoughts on two parts of this. One is more a question, and the other is a thought that I think is consistent with what I've understood from discussions with Elizabeth, from being there along with Terry at the meeting of the Law School Council, Law School Deans,
Assembly.
Assembly, okay, they are an assembly. It was my understanding that the thinking behind the 6 units was not that that's the end of it, but that we should start by at least putting the 6 units in place, just as the TFAR implementation group was looking at a phase-in. But that I think, and I would suggest that maybe we modify the language a bit so that it's reflective of that the aim would be to kick it off with the 6 units because that's consistent with the ABA, because that appears to align with where others are going. And there's some benefit of starting to phase this in at a place that's starting nationally at a common resting point, but then that we would study and evaluate and consider increasing the 6 units or ramping it up or phasing it up. And I would feel more comfortable with that because I think there was a lot of good work by TFAR and thinking that went into the 15 units. And having taught at law schools, I see some real benefit from competency training that goes beyond 6 units. But we need to figure out how do we get from here to there. And starting with 6 units seems the right way to get from here to there along a pathway. So I guess to you, Elizabeth, just that strikes me as consistent with what you're recommending, but could we maybe make that a little bit clearer? And then the second was just in regard to the modest means issue on the 50 hours. And I'm not sure who to direct the question to, but I could understand that if the state bar were still the one trying to administer that it would be tough to get us into a whole effort around which clients qualify and which don't, and what are the standards. But I think if we're now saying that this is something that the law schools would certify, and because we really are trying in part to have this be helpful in filling the justice gap, that it makes some more sense with the law schools administering it to keep that modest means requirement in there. So I'm just trying to understand why we would still want to take it out if it's not up to us to administer it.
I think Kelly Evans would probably be the best person to answer the question, but given that she's not in the room, I will say, this is Elizabeth Parker saying, that there is no easily, shall we say, access definition of what modest means includes, and I think it was for to simplify, to make it clear, to make it easily manageable, that component was taken out, and it didn't seem to us that it did great damage to the proposal, but the point of it all was to make sure that law students had a pro bono experience, and the definition of pro bono was sufficiently broad that it would not be a problem meeting that requirement. So, Gail, would you want to add to that? Or?
You said it very well.
Okay.
Janet. Janet Brewer. I admit this is more of a comment than a question. I'm very conflicted about this whole proposal. On the one hand, I am a strong proponent of providing MCLE for attorneys, even upping the requirements that we have for MCLE. I think that we definitely need to make sure that new attorneys are proficient and they're not practicing on their clients. But I'm also sensitive to the concerns two concerns. Number one, law students coming from out of state and how they're going to comply with these requirements. And number two, we've talked on a number of occasions about the high cost of legal education and the tremendous amount of debt that students coming out of law school have. We also know that there are far less jobs with big firms where the people that are going to be subject to these rules are being paid for the time that they're providing these pro bono services. So now we're taking law students who've already got crushing debt, are probably self-employed, and imposing on them a requirement that they provide 50 hours of no-cost legal services. And I wonder what that's going to do. I wonder if it's going to discourage students from out of state who went to good schools out of state from coming to California and taking the California bar. I just want to know if those concerns have been addressed and if there's any way to take care of them.
So, Elizabeth Parker, your question, I think, is addressed only to the 50-hour pro bono requirement?
Primarily the 50-hour pro bono requirement.
Most of the deans and others who spoke felt that 50 hours was really relatively modest over a 3 or 4 year period, that in most, if not all schools, it's happening even now, and that it aligned nicely with some of the experiential preparation that we hope students will get. And as a dean, I can tell you over a decade, that has been my experience too, whether evening or day students. I think the evening students are the ones that you might be most concerned about holding jobs and so on. But my personal experience, and I heard no one countering this, was that this doesn't create an imposition or a problem. And I was interested to hear that the ABA is moving in this direction too, for just the reasons I've said. They see most, if not all, schools already doing this because of the value that it does give their students. Gail?
Yeah, I would also say that I think New York sort of has already plowed that field in a way, and I don't believe that they have encountered some of the problems that they thought they would. And we do get in California a lot of out-of-state ABA law students, so I think it is being incorporated into their education, and they would be able to double count, so to speak, both the experience training and the pro bono. So I'm not sure that would cause the same problems that we originally thought it might.
Brandon Stallings, what type of consideration has been given to students who, let's say their entire law school career, they work for a district attorney's office where they might be prohibited from representing, even on a pro bono basis, individuals of modest means. As a DA, I can't necessarily come and volunteer and form attorney-client relationships because of the nature of my work. So has there been any consideration regarding students who are pursuing a track maybe towards becoming a U.S. attorney or a district attorney?
Well, yeah, I have sort of limited knowledge of that, but I from what I've heard, that would be true if you were a DA or part of that group of attorneys, but you could be doing some sort of work with an internship with the DA's office and be able to count that, or at least, I'm not sure about pro bono, but the other. And I know that was one of the issues as to why there were groups that were opposed to a year after admission being included as part of the pro bono, because there is a prohibition to do pro bono if you're part of the DA's office, and offices like that. So I'm not sure it would be the same issue pre-admission, because obviously you're not authorized to practice law until you're admitted to practice law, so I don't think the same issue would be there. But I am not the authority.
And I may not be either, Elizabeth Parker speaking, but again, from my decade as a dean, this was never a problem for students who were interested in pursuing a prosecutorial position after graduation. And I would say that the breadth of pro bono opportunities is quite broad. So I think that in that menu there would be opportunities that would work no matter what course you might want to take after graduation.
Jason.
Jason Lee. I think it'd be helpful for me to get a little background on procedural, what procedures were for the original TFAR recommendation, what had happened. Because I had thought that the board had approved the original TFAR recommendations, and then what happened, and this is all obviously before my time, and then what happened after that. It sounds, based on what you're saying, Elizabeth, that we are modifying some of those recommendations and now setting it out for public comment. I guess some of the questions are, did the original TFAR recommendations go for public comment? Things like that. I think it'll help me understand, just context-wise, what's being proposed.
Elizabeth Parker, again, speaking from knowledge and reading, they did. And I think what happened when they were, let me see if my memory is correct here, they went first, I believe, to the board in September of 2014, and then were finally approved in November of 2014. And there was an implementation plan, there were rules attached and so on, but what was not done in a thorough and effective way was to really cost out what this set of proposals would involve. And as I mentioned, when the audit came out in June 2015, it quickly became clear to everyone, I think, that we were going to have to look very carefully at new initiatives that might be costly. And it was for that reason that when the new executive staff came on, we were encouraged in September of 2015 to look seriously at what the costs were. There had been numbers provided, but when we really studied this deeply, Leah's not here to back me up on this, but what we concluded was that the number of staff and the impact would be probably close to $1 million, maybe even a little bit more annually. And obviously that's not an insignificant number. And so it was learning that caused us to want to think a little bit more carefully as to how the proposals, I should say, might be modified without doing violence to them, honoring the spirit, and yet aligning them more effectively with existing systems so that the cost would then go down.
Thank you.
Are there any other comments from the board for the trustees at this point? And if not, I'd like to ask Mr. Brandis and Mr. Weissenberg to step forward. Please, gentlemen, you just grab those front two seats and introduce yourself. Let us know what's on your mind.
It might be up there.
Well, thank you. Thank you, Chair Flanagan. Thank you, members of the committee and Board of Trustees, for a couple of moments of your time. I only have one comment to make, so it won't take long, I think. But in it are two things.
Could you identify yourself?
Yes, pardon me. Greg Brandis. I'm the Dean of San Francisco Law School. Two things in it. One is a compliment. The other one is a peril I'd just like to make sure I bring to your attention. The compliment is that of all the professional activities I've been engaged in, the TFAR implementation process that I was a part of. So I was in phase 2. I was fortunate to sit through all of phase 1 as well. And so many members of the board and other great members of the profession participated in that policy decision-making process, which I'd say when the board, the bar does something well, it does it really well. Because that was the most tremendous gathering of different viewpoints in a completely open, full public hearing setting. Every meeting of that group was conducted as a public hearing and was transcribed, so it's a full record of everything that occurred there. Much of it is, of course, on the State Bar's website. It was a tremendous process. And I'm reminded of a particular moment in which lies the peril that I bring to your attention. And the particular moment was somewhere near the end of phase 2, when the proposals had solidified a bit and people understood where we were headed with it. There was a moment where around the table, and it was in this room, I think I was on that side, and most of the members of the profession and the judges were on that side. Is that your memory too? Yeah. So as it happened, most of the deans all sat together, and most of the judges and members of the profession who weren't in legal education sat together on the other side of the table. And it was one of those moments where we were pointing fingers at each other. Sort of, the members of the profession in the bar and the bench were saying, no, you do it. And the folks in the law schools were saying, well, we're already doing a lot, and we're already under criticism for the cost of what we do. So you do it. And of course, what we were talking about is making these new lawyers truly competent to practice law. We're equipped with all the skills that they need to really be in practice. And what led to that moment, I have to tell you, and this is the peril, was the folks on the bench and bar side very much believed the law schools were getting away with something in connection with TFAR. Despite 15 hours being the proposal on the table at the time, and pro bono and all the other things that the law schools had taken on, there was still a strong sense from that side of the table that the law schools were getting away with something. So here we are, at least 3 years later. The board had already passed the whole thing. I was in the room when John Streeter presented it. He almost got a standing ovation, just as close as you get to that with the Board of Trustees, and a unanimous vote.
And now we're, a year and a half after that. And I just want to make sure it's on the record that it isn't the schools regulated by the state bar that are coming to try and dilute the requirements placed on the law schools. That's not what I'm here to say. This is not coming from us. So whatever the folks in the bench and bar thought at the time we were trying to get away with, we're not trying to get away with it here. So wherever you go with the proposal, and I think it has good policy aspects to it, as well as certainly challenges. All of those challenges that have been mentioned today, of course, are discussed extensively in the record by the affected groups at the time. Hundreds of people participated in those meetings over the years. Whatever the policy ends up, I just warned you about the peril that is out there. And it's not just from the public, it's not just from advocacy groups, it's not just from the legislature, which I've learned a great deal about the legislature recently, as I suspect others in the room have, and where they stand and what they think about these issues. It's from inside the bar and from influential members of the bench who see lawyers come to them in court all the time that they think don't have the skills. So one technical point to be sure I've mentioned is there's a bit of confusion, 6 versus 15. 6 is the ABA rule, but that's rather narrowly defined in the ABA rules. A particular kind of experiential training is what they were talking about. TFAR was talking about something a good deal broader than that. So the kinds of skills that were permissible in the 15 units or 15 semester hours under the TFAR plan was a good deal broader than what would qualify under the ABA rules. So it's worth keeping that in mind if that issue comes before. But again, why would someone from the law school come and want to stick to 15 when we can get away with 6? Why not? From our perspective, as long as it's on the record that we're not the ones trying to make that happen. We came together, we deans, my colleague, Dean Weisselberg, and many other deans, came together with those members of the bench and bar over a very extensive period of time, including a number of public members, to conclude on this plan. And so I don't come to praise it. The policy is really up to you. But I do want to mention the peril. I've been a lifelong aviation buff. And one of the things that sadly happens around airplanes is that sometimes people walk into spinning propellers. Sorry to take your mind to that image in the middle of all this, but it still happens with startling regularity, even though everybody knows that's a risk if you're out on the flight line at an airport. And I just want to make sure the bar doesn't do the same thing without fully reviewing what's out there in terms of sentiment around these proposals. Thank you very much.
Thank you, Dean. Mr. Weisselberg.
Thanks. My name is Charles. Is this on? My name is Charles Weisselberg. I'm a law professor at the University of California at Berkeley, where I also serve as associate dean and have for the last 3 years. I was also a member of TFAR in Phase 2, along with my friend here, Greg Brandis. He's a bit more gracious than me, and I think I want to be a little sharper in my comments and much more critical of what the bar is seeking to do today. I actually was pretty shocked when I opened my email yesterday afternoon and saw for the first time the proposal that was being submitted here. And I have no illusions about what the bar is seeking to do here. I don't misunderstand what the bar is doing. It is gutting recommendation A and materially altering recommendations B and C. I think that's quite clear from the document that was presented. And along with other members of TFAR, I was very surprised to see that. I also communicated this morning with some of the working group leaders from TFAR Phase 2, who received this morning at about 7:30 in the morning by email the proposal that's before the bar here today. I think a reason why this room isn't filled with other people from TFAR is because you did not give advance notice of what you were going to do. And I think well, let me not say what I think. I want to make 3 points. One point is about process and notice. The second is about the merits of what you have submitted and why I think it is not in shape to go for public comment as it is now written. And third, I want to note something that's misstated in the memorandum with respect to what TFAR has done. First, on process and notice. There were 2 phases in TFAR, as Director Parker has noted. TFAR 1 was a conceptual phase, and I know we have one member on the board here who served on TFAR phase 1. And it did research, it held public meetings, it took essentially evidence, it did scholarly research, and it made a finding that lawyers in this state before admission needed better training and experiential education, needed more skills training, and 15 units of that was approximately the right amount. That was then adopted by the Board of Trustees after it had been sent out for public comment, and that was in the fall of 2013. Phase 2 was authorized by this board to write rules to implement the conceptual piece that was decided in phase 1 and had been adopted by the Board of Trustees in phase 1. At that point, the board authorized a much larger committee. TFAR phase 2 was expanded to 30 members, which included leaders of the bench, of the bar, deans from various law schools in California, and it set about the hard work that Dean Brandes has referred to of trying to come together and come up with a series of proposals to implement TFAR phase 1 and do so in a way that the law schools could implement, that the bar could implement, and that members of the bar and judges and academicians would feel would appropriately serve both new lawyers and protect the consumer, people in the state of California who receive legal services. TFAR phase 2 went through 8 public meetings. Drafting the recommendations in TFAR phase 2 was an iterative process in that we heard statements at each meeting from members of the public, we held deep discussions, and what we were writing changed in light of what we were hearing throughout that process. We came up with a series of draft recommendations in the late summer of 2014. Those were sent out informally for comment in advance so that we could rework the final proposal. We received informal comments back from schools and others. Then it was sent out for formal comment for a 30-day period, and we received formal comment back. And those were the series of rules that were adopted by the Board of Trustees in November of 2014. So the process in TFAR phase 1 and in TFAR phase 2 was everything that this process is not. It was open, it was transparent, it was iterative. It had an opportunity for there to be an exchange among all constituent groups, and we heard from many, many, many lawyers in California and throughout the nation. So to suggest that this just needs a broader airing, I think, does not fully respect the process that was engaged in TFAR phase 1 and TFAR phase 2. So I wanted to suggest here today that what is needed is not simply comment on these proposals, because there was enormous airing of the proposals previously. I want to move to the merits of this, though, and move from process. I find it difficult to understand what comments you are seeking in light of what you said today and in light of what you've written. As I read the proposal, I read it as a document that said that, we've had an audit. The bar's in financial trouble. We need to devote resources to the disciplinary process. We don't have the money to implement recommendations A, B, and C. But then when I read the document in detail, it provides 0 cost estimates for implementation. The document that you provided is bereft of any data other than a statement that it'll cost about $1 million to implement this. Really, if you want public comment on the financial piece of this and what is worth it for the bar to spend its money on, this is not the document that will get you those public comments. You need a document that will lay out what the benefits of these proposals are, and some description of the cost of implementation, proposal by proposal. Then you maybe can get some comments back from members of the public of, gee, recommendation B as written is too costly, or recommendation B as originally written, might be tweaked in a particular way to reduce certain amounts of cost. And it seems to me that comments from the public of the costs and benefits of different parts of this, those are the kinds of comments you want to elicit if you really are making these changes on the basis of fiscal considerations. But I've heard here today a statement that recommendation A is not being changed for fiscal reasons, but because there may be less support among staff than originally, perhaps due to a change in leadership of the state bar, and because some leaders in academia nationwide are critical. When we put the proposals out in phase 2, we knew that there was some dissension and disagreement among leaders in academia nationwide. We elicited comments as best we could from the ABA, from deans throughout the country. And in this room, as Dean Brandis has suggested, we try to work through those comments and forge an agreement between different constituencies, those in academia, those in the bench, those in the bar. And I think we did a pretty good job. I know that the AALS and deans will always be critical because they don't like regulation of any form. And that's what they're pushing back on. I have to say, Director Parker referenced a letter that was written by a group of deans in the ALS. There was a group put together called the Dean's Steering Committee that issued a statement that was quite critical of TFAR. But it was the funniest thing you've ever seen because it was an amazing demonstration of the need for practical skills training in higher education because for some reason they missed TFAR Phase 2. They wrote a statement that was really critical of TFAR, and they had apparently read the report from TFAR Phase 1. They missed the report of TFAR Phase 2, and in Phase 2 we made a very substantial number of changes that would lessen the impact of these requirements on law schools, and that would lessen the cost of providing these changes. So Dean Shauna Marshall and I wrote a response to the AALS, which it put on its website, but it wasn't that interested in revising its statement after it was pointed out that they read the wrong set of reports. I guess I just think that if this goes out for public comment, I would like something to go out that's clear about what you are asking for. If you're making changes on recommendation A, I think you should be clear about what recommendation A after TFAR 2 actually does and what it provides, and I don't think this report does that. If you're making changes because you fear retribution from deans nationwide, maybe you should own up to that. I actually would kind of hope that you'd come back to some of the people who worked so hard in TFAR 1 and TFAR 2 for comments on this before sending it out for public comment, and maybe ask them whether they have any suggestions to reduce the cost, since you say that that's a reason to make the changes to recommendations B and C. It seems to me that that is a process that would honor some of the hard work that was done over about a 3-year period by leaders of the bench, bar, and law schools. And I don't think that the process you've engaged in here honors that work, respects that work, or draws from the expertise that was gained from discussions in this very room. And I guess the last thing I want to say, the substantive part is, if you're sending this out for public comment, I really do think that you should state accurately what TFAR Phase 2 has proposed. I was looking at what has been described as the most controversial recommendation, and that's recommendation A, the pre-admission competency training requirement. What's described here is the original approach says, well, a law school should certify, or a new applicant should certify that they've taken at least 15 units of practice-based experiential courses. And in lieu of some or all of the 15 units of coursework, the candidate for admission may opt to participate in a bar-approved externship, clerkship, or apprenticeship at any time during or following completion of law school. I think that reflects TFAR 1. That's not what passed in TFAR 2, and that is not what the Board of Trustees adopted in November of 2014. It's a misstatement of what TFAR recommended and the State Bar adopted following TFAR 2. What TFAR 2 proposed and what the board adopted was 15 units in law school, and up to 6 units could be substituted by an apprenticeship or a non-credit earning placement, could be summer jobs that law schools would oversee and law schools would certify. So in practice, it was really 9 units of coursework plus up to 6 units of an apprenticeship that law schools would oversee. We designed it that way so that the bar wouldn't bear the expense of overseeing the placements. And we have recommendations about what should happen in those placements to try to ensure that students would receive high-quality training. We modeled those on externship guides and such, and we looked at those pretty carefully. The State Bar also retained the ability to, after a student has graduated, provide the equivalent of what would be 6 units of practice-based work as a sort of a stopgap in case someone was coming in from out of state and they needed a few extra units. That was something the State Bar said it could do for people who had already graduated. But those two pieces together are different than what is stated here. And what is stated here doesn't describe the benefits of the proposal that TFAR made. We felt, based upon the work that was done in TFAR Phase 1, that more than 6 units of practice-based learning was important for new lawyers in the state of California. We adopted a mixed model that allowed that to be delivered through coursework in law schools or through an apprenticeship program. We thought apprenticeships would do a lot to actually bring law schools and members of the bar together, because law schools might be looking at students' experiences in private settings over the summer and in different government agencies, and they would be in much better communication with members of the bar. So the problem of distancing between law schools and the bar, which many have noted and commented on, was also something that this proposal sought to address. But let me stop there. You can tell I feel strongly about this. I feel strongly that the work of TFAR has been sort of cast aside because of a change in views of staff in the State Bar without addressing carefully the findings that were made in TFAR Phase 1 and TFAR Phase 2. I think that the expertise in this room that was gained from those phases should be drawn upon, and you should go back to some of the people who worked in TFAR to see if there's a way to reformulate this proposal before releasing it for public comment, if that's what you aim to do. And then I think you ought to state accurately what came out of TFAR Phase 2. So thank you for your time.
Thank you, Mr. Bird. Dennis?
This is a difficult situation, as you can probably start to sense here. I had the honor to serve as a public member in TFAR 1 and 2. And while Justice Streeter and I had some very strong disagreements around the governance task force issues of the day, on one thing we totally agreed, and that was that this task force, TFAR, was to get at the essence of some of the things that Ms. Krinsky and I and Heather Rosing and others that have had RAD responsibilities have been most adamant about, and that is that the whole discipline issue starts way earlier than anything here. And all of these issues, you have no idea how spirited and how intellectually stimulating and satisfying those long, long days were, especially perhaps to someone like me who is, I'm a former school principal. I'm not an attorney, didn't know anything about really this profession. But what an amazing learning experience to come in and almost immediately be thrust into this process, and to find the deans and other distinguished members of the profession sitting down together and really trying to get at the bottom line of how we prepare people to enter this profession, to be successful, to be ethical, practitioners and to avoid falling into the disciplinary process. I thought it was really quite amazing the way the issues were resolved. Ms. Greenman, a member of the staff here, was a very capable staff member who went far beyond just acting as a staffer to John Streeter, and it was a beautiful process. I had no trouble in my own mind adopting the recommendations of TFAR, and when it came to a vote of the board in its wisdom decided to support them as well, as has been discussed here. I couldn't vote for this today because I agree that there's insufficient information to justify the compromises that are suggested here. And I can't say that I have a solution. It's awkward for me because there is a new sheriff in town. There is a new team of executives who have a lot on their plate, who have inherited legacy issues, and who are grappling with costs, legitimately costs, and just getting their feet on the ground. And this at least appears to them, I'm sure, to be a big bite. So as a fiduciary, I have to kind of balance these things, and I can't say that I'm absolutely certain about the right approach to take, but I think if I had to choose among them, I would choose to, rather than put this out to public comment in its current form, and reinitiate what we can anticipate kind of as a rehash of all the old issues that were very well resolved and around which we came to consensus, I'd be tempted to put it back for comment to the people who were on TFAR 1 and 2, and ask them to once again engage, only this time with more data. For specifically speaking, what would the real costs be? Because I can't yet understand exactly what horrendous new costs would be borne by the bar. It seems to me a good deal of the costs are borne by the other willing participants. So anyway, it's complicated. I can't vote for this. It betrays, in my judgment, it betrays the work we did on TFAR and the agreements to which we came. And I would like to see this delayed and come back in a different form that better represents the consensus we arrived at in TFAR 1 and 2, and that this board already has voted, I think it was unanimously, if I'm not mistaken, to support. So,
is there a motion to that effect?
Well, in that ramble, it would be hard to decide what my motion is. But I have to say that I'm
sure you can simplify it.
You think?
Yeah.
Well, let's give it a try, because of all the things that both of our distinguished deans said, and I hold them both in very high regard, and Dean Brandis and I, in the course of the TFAR conversations on sidebar and over dinner at times, we had the opportunity to discuss at some length, and I learned a great deal from him and them in the process as a novice to this business. So I kind of like the idea of re-referring this to TFAR before it goes out to general public comment, only with a great deal more detail that they can get their hands around. So I would move that that we do exactly that we put this recommendation from the staff back in the hands of the TFAR participants for their comment, as with more information about the potential cost as a prelude to going out for generalized public comment. That's my motion.
Not a second, but when I was preparing for the interview for the Supreme Court appointment, I was advised by a number of individuals to read TFAR because they believed it was exemplified the work the bar was doing. So my question as to you, Elizabeth, about the context and the procedures that occurred to the board's adoption, and I'm very much persuaded by the comments made here today and the unanimous decision by the board at the time to adopt TFAR's recommendations. I do feel that we should solicit the comments from the original TFAR members. So
we have a motion on the table.
Yeah, so I guess with all that, I second that motion.
Okay. Second by Lee. Comments and questions? Miriam.
I think that part of what Denny's motion is trying to get at, as were the comments, is that maybe there's a little more processing that's needed here. I'm not sure about the processing being working to just reassemble the very large TFAR group, and I assume it would be. Assume the motion is contemplating TFAR 2, the implementation group. I do think. Many of us have read TFAR 1, we've read TFAR 2. I tend to agree that you don't really get a sense of, especially the implementation, the phased-in, carefully thought through phased-in implementation of TFAR 2. So even before folks vote on it, I think they probably would benefit from having a deeper understanding. There are parts of this that aren't that far off of some of the compromises that TFAR 2 tried to make. Some things are being struck in slightly different ways, but TFAR 2 didn't say go for 15 in year 1. I mean, it was a phase-in, and I see this as a way of trying to rethink some of the phase-ins. So I don't know that I see the divide quite as great, perhaps. I think that there was a strategy in TFAR 2 for how to achieve the finish line. And what I'm hearing from Elizabeth is just maybe the strategy that she sees to reach the finish line is slightly different from the strategy that TFAR 2 saw. So I think it's a long way of saying I don't know that the differences are as great, but I think that more processing is needed. And so I'm not sure that the processing that I would embrace is just reassemble TFAR 2. Because I don't know that that'll have all the perspectives in it, Elizabeth, that you've been hearing from or trying to bring to the table. And I also think we need to get some input from from the Supreme Court. And so I'm wondering whether if we threw the ball back in your court, Elizabeth, and said you're clearly hearing some desire for more of a process to bring the good thinking from TFAR into the mix. Where would you go with that? I mean, do you have any thoughts for how we could achieve that rather than just throwing it back to TFAR 2?
Elizabeth Harper. I wasn't here for any of this, and actually I wasn't serving as dean when most of this was going on. But I have enough connections into that community to know that there is a very strong point of view that, I choose my words carefully, was excluded. And I think that's part of the tension that we have. That, and I would say this is not the only time in this role as executive director I've been in this position where there seems to be a major disagreement and strongly held views at the ends of a continuum, and the question is then how do we bring them together? But I would tell you that the people that I have spoken to and who have approached me have not necessarily been people you would always think of as coming together, but they've had very strong views, and they have not been the views of the TFAR 2 group, and they have felt that they were not included in the conversation. And some of them argued that to take this kind of a step to go directly to 15 hours without the very cautious incremental approach is really to put California in a position that could be awkward at best, untenable at worst, really making quite a problematic incursion in what has been, at least for the ABA-approved schools, a national set of standards that has been consistent over a number of years. I think those voices need to be considered. I don't have a strong view myself. Frankly, I would have tended to favor this as a dean, and yet some of the deans who have approached me are from just the kinds of schools, not a Cal, but a school more consistent with your school at University of San Francisco that really does focus on practice-ready preparation, saying we cannot implement this. This would be really very costly and very difficult. Costly because they need new faculty, disruptive because it would really represent one whole year, they feel. So I think, at the end of the day, we may find with the ABA proposal that we move in this way, but we do it in a way that's more gradual and more inclusive. But the comments that I've heard, certainly in the meetings I've had, have been very positive. I told you the numbers that we had. So I would say that while I haven't spoken with everybody involved in TFAR2, we certainly did reach out and heard from them. We attended one of the meetings. That's one point of view, but there's another very strong point of view that has different views and that feels that it was not included. And I think when you confront that kind of a situation, the idea is to move the conversation forward. And that was really what we were trying to do in going forward with a 45-day comment period. Now, the comment period may be too small. Maybe you want something larger. Maybe you want something different. But the reasoning behind this was to put this out and, in fact, to get folks like yourselves and others to come forward and talk candidly about the proposals.
Dennis, Dean first, and then you're...
Well, frankly, it's just...
May I just clarify one thing my general counsel points out to me, which I thought was obvious. Of course, public comment would include everybody, TFAR and others.
Well, Dennis mentioned, first of all, it is not true that they were not included. What is true is that some of them didn't prevail. You should have seen the letter from the dean of the School of Law at Stanford. It was the most vitriolic piece you've ever read in your life, and that dean had the opportunity to come here and make the case. Other deans came and made cases. Lots of people came here. It was as inclusive a process as I think I've ever witnessed. And all views were taken very, very seriously. But the final consensus represented the prevalent view that it was time to just stop talking about these things and go do it. I listened to all the arguments from the dissident voices about this will be too expensive, it will take too much time, we can't be certain it will have an effect. You, the state bar, don't have any right to be telling us what to do. You're not the boss of me, in variation, blah, blah, blah. But the idea that it wasn't inclusive is absurd. What we're hearing now is on the cusp of the bar finally implementing a unanimous decision of the board to implement the recommendations of TFAR. The dissident voices who were included and who were heard are striking back to suggest that we ought to put a modified version out for public comment so that they can embrace a modified version, although I will guarantee that some of them will fight even that. Just on the principle of you don't have any right to tell us what to do. The recommendations of TFAR that this board voted unanimously to support would go farther to improve the quality of the practice of law than anything else that this state bar is doing. And we shouldn't be shy just because some of these voices are now being raised once again, hoping that this time they can prevail when they did not succeed in convincing all of us in the first place. That's no way to do business. We should have the courage to go forward with the recommendations, and if we're leery about the cost, well then further monetize the thing and make better recommendations with regard to how you think this ought to be phased. But let's not back off something that clearly prevailed in terms of one of the most important improvements I can imagine in the profession. It'd be a big mistake.
Mary.
Elizabeth, I'm wondering whether you think there's a way or that it would be beneficial to try to bring together some of the voices that you've been hearing from, some of the folks who worked on TFAR2, and obviously, there are some on the board who are particularly interested, just to be able to look at what we've learned since TFAR2, some of the added concerns, some of the cost issues that have cropped up, and to see if there might be some meeting of the minds. I mean, my sense is, even from the comments you both have made, that there are some elements of this that you wouldn't be that troubled by. And even parts of this that strike me as similar to the implementation plan that was proposed. So I don't think that this is all wrong, is my sense. But my worry about just putting it out for public comment is that we're going to get these diametrically opposed letters that will come back at us after 45 days. And I'm not sure then where we go with it. I think we'll probably at that point say we need to process it more. So why not maybe process it first and see if that can lead to some meeting of the minds that then enables us to put something out for public comment that has a greater, sort of wind behind the sails. But again, Elizabeth, I'm sort of throwing this back at you to see what you think about that, whether you feel, given what you've heard, that it just simply isn't going to get us anywhere to try to bring people together, put them in the same room, and see if there can be some meeting of the minds.
Elizabeth Parker. Well, I really thought, I had hoped that the first 50 hours of pro bono and the NCLE, while modified, were sufficiently consistent with the recommendation that we could at least go forward with those. I recognize, as I said in my opening remarks, that I think there is a great deal of difference of view on the 15-hour experiential learning proposal. So perhaps one thought might be to go forward now with the 50-hour and the NCLE requirement, which could take some time to implement, and get those started. We can do those, we think, with relatively modest cost, and we then have that just to be able to say we'd accomplished, while we perhaps follow the course you're suggesting of talking further about the 15-hour proposal. Again, what we were trying to do was to find a way forward, and I guess I'm successful if I'm being hit from both directions, because it's obvious that we are in one of those situations where reasonable minds could differ. But that might be an alternate proposal.
Sir, can I try one more just back at them?
Yes, one good.
So when I look at also kind of the time frame, the post-admission MCLE was to have kicked in 2015. 2016 was the 50 hours, and frankly, I think there are some benefits to the 50-hour proposal as it's been modified. The Young Lawyers, CYLA, had some real concern about that, 50 hours extending beyond the time of admission. And I thought that there was some validity to their concern. It was sort of the issue that Janet raised. Are you really expecting us, when we're dealing with student loan debt and the burdens of striking out in practice, to be trying to do that 50 hours then? So I think there's some real wisdom in making that a pre-admission requirement. So those were the two things that TFAR 2 suggested get out of the starting blocks most quickly. So let me start with those two. Do you see on the modifications that Elizabeth has suggested, do you think that there would be any great concerns about how those are defined as modified? Because then maybe one could think about that 15-hour, again, I saw you all had phased it in. You weren't trying to get to 15 right away. And I'd like to view the start at 6 as the phase-in way that we maybe eventually do get to the 15. So as to those other two, do you think that there's a problem? Or do you see great concerns about putting those two out?
So, this is Charles Weisselberg again. And by the way, I don't know if I said this before, but I have to speak in my individual capacity. I speak on behalf of my school, or of course for TFAR. I'm not sure I know the answer to that, but I think I know who may have some insight.
Is your mic on, Dee?
I'm sorry?
Is your mic on?
Oh.
And then you told you.
Okay.
Turn it back on. Yeah.
Oh, is that better?
Wait a minute.
Sorry, no, I apologize. I saw an email this morning from Hernan Vera, who is your board member and who's not, I gather, not here today. But I think he led one of the TFAR working groups and the one on pro bono. And I think he had expressed in an email, and I don't want to speak for him, but my recollection is he said he would welcome the idea of working with the board to try to think about how to deliver that recommendation in a cost-effective way. So I do think that even if the board doesn't want to try to reconstitute all of TFAR, that there are certain expertise to draw upon and willingness among TFAR members and leaders to try to work with BAR to deliver this in a cost-effective way. He might see something in the 50 hours that I don't see, and I would hesitate to opine about his advice. But can I add just one of the things, a point of information and thinking about ways forward? So I don't know if you know this, but a couple of months after the Board of Trustees adopted TFAR Phase 2, Chapman Law School convened a meeting for law schools in California, at least the ABA accredited law schools, and we had representatives from, I think, Albany and one law school there. And it was an amazing collaborative day to talk about the recommendations, because there were law schools that weren't intimately involved in the TFAR process, but wanted to talk about how to implement it. And what came out of it, though, was a sort of an agreement that we would collaborate with each other. We talked about creating networks for sharing supervision of students in apprenticeships and such, which we assumed would grow and develop. And we talked about ways that it would reach out and make this information and this network available for out-of-California law schools. So what I saw that day at Chapman was at least a willingness and a desire to engage, to carry out these proposals in a great way. And I actually think the community of people who attended that meeting, they should expand it into all law schools in California, would be a place to go to for comment and advice, because these were folks who already thought about how to implement TFAR's recommendations in a very positive way.
Thank you. We have a motion on the table here. Is there any, in light of our discussion here, is there any modification of that, or we
I'm open to the potential for friendly. I'm open to the potential for friendly amendments. It's hard to get my hands around the dean's suggestion about going to the assemblage of deans. It seems to me like there might be more benefit to Elizabeth's suggestion of putting the items around which there may be concurrence of public comment and taking the most controversial element and putting it back into a process for more study, perhaps to be determined by the CEO in terms of a proposal to the board. Because I don't want to be too prescriptive about something this complicated. On the other hand, as you can tell, I have very, very strong feelings that this thing got well aired, and the board already took action and made its position clear. And now we seem to be in a retreat that I'm not finding acceptable. So I'm open to wordsmithing here.
I propose modification. I would suggest that we approve for public comment the slightly modified version of TFAR 2 as the 50 hours and the post-commission competency training. And I really think that it's in keeping with the spirit of TFAR, that there are some modifications. We'll get feedback on it, but let's put that out for the 45-day public comment. That as to the pre-admission competency training, that we direct staff to work with representatives from the original TFAR task forces, as well as other key stakeholders, to get input on, pardon? To get input on modifications regarding the modifications and phasing implementation in regard to the pre-admission competency training that that are consistent with the spirit of the TFAR recommendations and also on the fiscal reserves.
Can I suggest adding something like including but not limited to the financial impact, since that seems to be one of the core reasons why we're revisiting some of those.
Yeah, I had that as well. They're consistent with the spirit of the chief our recommendations and also address district concerns as well as any other challenges.
What about the post-admission MCA? She said it'd be a certain.
So the post-admission and the 50 hours pro bono, we would put those two out for public comment. Public comment, the proposed, yeah, or B and C. B and C. Right.
Okay. Okay.
The proposals related to the 50 hour, the proposals related to the slightly modified 50-hour pro bono and post-admission competency training recommendations in two parts here. Yeah, yes. Post-admission and MCLE competency training recommendations.
Okay.
I mean, Elizabeth Parker again. I will say that the MCLE, very modest change that we recommended no one seemed to object to. And really, we did that because if we had added 10 hours, we would have had to go to the legislature for approval, and we pretty much knew from earlier experience that that was, as it were, not going to be successful. So in the changes there, we were really definitely trying to find a way forward. I think it's a very valuable proposal. And I'd emphasize sensitive. I thought this was where Trustee Brewer was going a moment ago, that we didn't want to add additional cost to recently admitted lawyers. This proposal carries with it as well the notion that the bar will develop online training that will not have a cost to them. Indeed, and again, Trustee Brewer will like what I'm about to say, we hope that in that 10-hour, up to 10 hours creation, that we might even create a pilot that could later on be useful in other contexts. So that seems to me to be a positive step forward. The 50 hours, again, we did talk with legal services. Our concern as a bar was that we didn't want to straddle pre-admission and post-admission. That created an awkwardness for us, and I understand what the conceptual reason was for initially proposing it that way. So we thought, if we can do this before, it becomes very easily implemented. And as you know, the law schools were very willing to work with us on that, and indeed said they were prepared to help with the certification and so on. So again, it was an ease of implementation as well as the cost concerns that we were working to address. I'll say too that I was encouraged by many to look at the New York model and to see what we could learn there. And at this point in time, the answer was nothing. They behaved in a much less, I would say, I don't want to be too critical of them, but they're less rigorous, and the reason for it in part is that they don't have, as we do, a whole law school accreditation process. And so they're doing something that's not appropriate for us, although they haven't started, but I think that's what we'll get from that. And so really, as we thought about phasing in, we really thought it's the ABA 6 hours that's going to show us the way forward, that will create the machinery we need to take advantage of to then one day think about, can we actually move to the 15 hours in a what do we say, a stepwise basis. So I don't want to be defensive here, but we were trying to help.
Yeah, I'm not sure we can finish it right there. Magic fingers.
How does that look?
Jenny, is this your proposal?
This is a modification.
Yeah, is this okay with,
Well, one thing that the proposal does not now contain is a time reference to the further study. And I might just add that, as you may know, this year's American Bar Association meeting is in San Francisco, and that will naturally bring a fairly significant group here, and it would be an ideal opportunity to try and create a conversation across different perspectives. Would that be too late a time from your perspective?
So when is that?
It's the first few days of August.
And so between now and including that opportunity for input,
Yeah.
the time to come back would then be when?
Would be in the fall. We had a special meeting in September, then failing that would be October.
It's acceptable to me, and I would take this as a friendly amendment. Or it would be fine with me if my colleague recast this as her motion.
I'm fine either way, but I'm wondering one thing.
Can you turn on your mic?
This is done by yourself.
Mary Krinsky. This is coming to the board tomorrow. We're simply moving it for the board to consider tomorrow. And I do wonder, I mean, it might be helpful to know before it comes back to the board as to B and C, whether there's a strong sentiment among TFAR 1 or 2 folks that they have heartburn in regard to B and C. I mean, again, my sense is that there are some good elements of B and C that the TFAR folks I've talked to on TFAR find very positive in terms of where it's moved. But if you all got a sense from TFAR 1 and 2 folks that B and C are really troubling to them, that might be helpful for the board to know, and it might cause us tomorrow to say, let's just put it all into the second result clause and not put B and C.
A point of order here, or whatever we would call it, this does not go to the board.
Oh, because it's only going out for public comment.
Right, that's right.
Even though part of it is not public comment. Do you feel prepared to answer that question?
I'm going to defer to my colleague in the direct answer to how others that he's been in contact with might say. Let me simply say this. The policy decisions are many and very clear. There were a lot of considerations that went into deciding those details of how this is going to work. They were listening to a lot of folks. So again, it's the propeller problem. When you put that out there, all of those folks who contributed all those things are very likely to take it that the bar is acting without deference to that activity. And I don't personally, I will speak for just myself at the moment. In terms of policy, I think there were good things in TFAR, and I think there were things that I disagreed with. But I, along with a lot of other folks, voted unanimously that that was a good package for the policy of the State Bar of California. On balance, taking everything into account. And I suspect that those folks will still be there feeling very strongly about the pieces that they cared about. So whether the bench considered it important for there to be an additive, how many times we talked about the additive requirement of CLE? It wasn't, there will be strong voices saying this doesn't add anything to CLE. There were. I suspect they'll still be around. Because you've made it part of the regular requirement, it's not an additional requirement. Cost considerations, I think, were addressed, so I don't think there's any concern about additional cost. But there certainly are concerns about additional time. So I can't answer exactly how people will react. Perhaps my colleague has a better sense of that.
I'm trying to stay away from Team Brand because he's propellant. But there was an exchange this morning among some former TFAR members who had worked on pro bono, including Professor Luis Guerrero. And I've seen it from Vera, and honestly, I can't say their views, but I did have a sense that they very much wanted to work with the bar to lessen cost concerns, so that if there's an opportunity to consult with them in thinking about what would then go out for public comment, I know they would welcome that. But of course, is your choice and have some policy choices to make.
Okay.
I withdraw my motion, Ms. Krinsky. You're liberated to promote this.
All right, we have a motion, currently a motion, which you can see on the screen here. Are there any?
Could you read it? Let me, can I, before making the motion? So if we look to have this come back to us at our July meeting, so we're talking about 2 months from now, do you think, Elizabeth, it would be all that terrible to just put it all into the second resolve clause? In other words, let's just try to get input on all of it. Because having heard that, I'm just wondering whether we should just look to bring some of these voices together, put them in a room, and see. It may well be that they'll feel very good about BNC, or it may be that they'll have some tweaks at the margins on BNC that we would have wanted to hear before we put it out. And we're really talking about, I realize it's 2 months, but it's a 2-month delay.
You're talking about
Not
putting up on the resolution today.
Yeah.
And during that 2-month period.
Yeah. Just to respect, individuals who spent a lot of time working on this, but to try to bring some of these voices together to try to get, if we brought those folks into the same room with those who have some strong views on the other side. I realize that, some may think we heard all those voices, some may think we didn't, but if we could put them all in a room, we now know more than we did a couple of years ago. We've got the added fiscal issues, whether we might be able to get somewhere that's a little bit more consensus building.
I'm Elizabeth Parker. I'm prepared to do it either way. I will say that in the amount of conversation I've had up to this point from both sides on the issue, the 50-hour and the MCLE issues did not seem to be terribly contentious as we modified them. There was the usual, they would have preferred the original way, but they recognized why we were making the choices we were. And so, again, I repeat myself, I thought this was a way to get something moving sooner rather than later. But it really, I'll do it either way. It doesn't big deal.
Hi, Stacy Spector. I just want to make the point, just to underscore what our friends with the public comments made, and that is they both talked a lot about process. So what you're saying is valid about the 50 hours, but it doesn't solve the process issue. And I think since we're inheriting this, you in particular, as an administration leadership, I think the process issue is probably where we might just want to take 1 or 2 steps back as a recommendation, just to make sure that we're taking care of our business. Like Miriam said, it's only 2 months. Take care of that business, get all the input since the work was done, people dedicated that time, give that consideration its due, and then come back to the table and be ready to go. I just think that it might be one of those moments where it's worth it.
I just want to jump in and just clarify that we have gotten a lot of input. It's not as if we sat in a room and drafted this. So
I don't think anybody's insinuating that.
Okay, so there has been quite a bit of
heard what's been said.
Okay.
Well, we have a withdrawn motion and one that's
I'm going to modify
sort of on the table. Go ahead.
Let me suggest it be a single resolve clause. So get rid of the first resolve clause. I'll just say resolved. And in regard to the recommendations relating to, and then put all 3 of them there. Or you can just say relating to TR1 and 2, or you can say the recommendations relating to creating mission competency training, MCLE. I mean, just put all of them there. Now I think, Denny, it's just a modified version of the organization.
When it gets a second, I'll comment.
Okay.
If it gets a second.
I would still move that.
We have a motion on the table. Do I have a second?
Yeah, wait and see.
What it says.
Yeah.
spirit of the TR1 and 2 recommendations on the last slide.
Yeah, that's what I'm
And
exactly.
report back, and
Yeah.
at the very end, rest, and report back to the committee in July.
Has everyone read the motion? Is there a second to the motion?
That's second.
Second by Stacy. Becky. Jenny?
I'm going to vote no on this motion. A, it seems to me a retreat from the unanimous vote already taken by the board. B, it tries to repeat in a shorter time frame the entire process we already went through. C, as Ms. Wilson suggests, we've had input up the yin-yang, if I may use this term of art.
It's a legal term.
Yeah, legal term, which I'm famous. And I just think it throws the entire thing back into virtually a chaotic environment that I don't think is going to be very instructive to our leadership. So if the rest of you think this is an elegant compromise, by all means vote for it, but I'm going to vote no.
Jason.
Just to prolong this discussion for one more minute, I think the critical element here is the addressing the fiscal issue, which I think is new information that was not available to TFAR 1 and 2. So to that extent, I'm going to support this motion because I think that will add valuable information to the final decision.
I'm going to support this one. We need to move this along. And this is to move the process along and recognize all the work that was done.
All right, I'm going to take the roll.
Janet Brewer?
Yes.
Miriam Krinsky?
Yes.
Jason Lee?
Yes.
Dennis Mangers?
No.
Stacy Spector?
Yes.
Brandon Stalling?
Yes.
Todd Stevens?
Yes.
Motion passes.
All right. Now we have two more. Thank you, gentlemen, for the presentation. Please. Yeah. Our next presentation, Gail Murphy.
Okay, Gail Murphy. 2 seconds. Basically, we are releasing results from the February bar exam tomorrow, Friday. And that's it. Thank you.
Do we get any information on?
Hi, Pam Wilson. Just to let you, I'm sorry?
These are no action.
That is correct. Just to let you know, the annual meeting is well underway. The Solo Summit is also well underway, and you will be hearing from us in mid-June with all of the annual meeting previewing what you need to do as far as registering for the annual meeting. I'm just keeping this very brief in the essence of time.
We have no other items before us for the committee, and so our meeting is adjourned, but if you'll wait for just a second here, I think we're looking at the issue as to whether or not, for those of you who may be waiting for a board meeting, whether or not we're going to have a board meeting today or whether until tomorrow.
We're discussing it right now.
Yeah, that's what I thought.
They don't report here today. What did you say?
Well, yeah, I think well, no,
It counts if there's a cut.
Well, I didn't.
No?
Well, no,
Decision made, we're not going to have, for those of you maybe here for the board meeting, we had scheduled one for today and for tomorrow as well. Because of the lateness of the hour, we're going to wait on today's board meeting and have a full board meeting tomorrow instead. So I believe we're finished with our business today.
Let's just, I would like to start promptly at 9 a.m. tomorrow because we have a very full day, so ask all the trustees to try and be here ready at 9 a.m.